Every day in the USA, people find themselves in court.
Calling case 2020-1981 DC, Richard Beck versus Jennifer Martinez. Today is Wednesday, December 13th, 2023 at 2:10 p.m. 2021-1981 DC.
Get rid of the echo.
Yep, we're good.
Court will note the appearance of Ms. Sharp on behalf of the plaintiff. The defendant is appearing in pro per. This is the time and place set for the evidentiary hearing on two matters: the plaintiff's motion for denial of parenting time for makeup parenting time, as well as plaintiff's motion for return of child and to enforce the orders. The court would note that the court had entered an ex parte order to enforce judgment of custody and to show cause for failure to comply back on July 25, 2023, which stated in the order in paragraph 1 that the defendant shall immediately return the minor child back date of birth to plaintiff for his parenting time. The plaintiff has subsequently filed an additional motion in this particular matter that was filed on November 27, 2023, stating that there has been an additional denial and that the child has not been turned over to him. Ms. Martinez, have you in fact complied with the turnover order in this matter? And I say that only because the most recent motion, the plaintiff had contained in paragraph 17 of the motion various texts from you, in fact, demonstrate or showing that you do not have the intent to comply with the court orders in this matter.
I did return Bella for visitations with her father until she was abused by her father physically. She came home with cuts to her mouth that were confirmed by her pediatrician, and then that is when I stopped.
Okay. It's my understanding from reading the motion that that CPS was involved and they did not substantiate. Is that correct?
They were at the doctor's office when the doctor showed them and confirmed to them the cuts on our daughter's lips. However, whether they followed their protocol for child abuse or not I'm not exactly sure.
Okay, well, I can only assume, I don't know, but I assume that they followed their protocol as they're required to do. Well, I guess the main point is, are you in fact refusing to turn the child over to the plaintiff?
Well, as of right now, yes.
Okay.
The plaintiff, Mr. Beck, has pled guilty to domestic violence, which
Okay.
occurred July 1st.
That's the only point I want to make
Yep.
today, Ms.
Okay.
Martinez.
Yep.
As a result of your failing to turn over, as this court has ordered, the court is going to remand you to the Calhoun County Sheriff,
Okay.
where you will remain incarcerated until such time as the child is turned over to the plaintiff.
Okay.
So you can go with the deputy.
As I'm in court, how am I to allow the plaintiff to know where our minor child
Well,
is?
you're gonna have to make your phone call and make sure that whoever, where the child is, that the child is turned over, but at this point, you will remain incarcerated until such time as the child is.
But if I'm in jail, how am I supposed to get my child and give her to the plaintiff? I'm just trying to make sure that I know what to do from.
You'll have to call somebody or let the plaintiff know where the child is so he can pick up the child.
May I ask one more question?
Yes,
So we are gonna follow the current parenting time order, which is from the plaintiff gets our child from 8 p.m. to 8 a.m. So
the current orders have not been changed. They will remain in effect until such time as we have another.
so I am to turn our child over to the plaintiff at 8 p.m. tonight?
Is that, if that's the time of the
Yeah,
turnover?
well, yeah, that is the time of the turnover, yep.
Well, in this particular matter, I do note that the court has previously, and there are makeup parenting times that are required. Ms. Sharp, what are the makeup parenting times that you've requested?
My client initially went without the child starting July 5th. And I believe she started to comply back with the order, was it in August?
I don't remember, she just placed me.
Okay, let me just look at my work. And then she stopped complying, November 3rd and my client has not had the child since.
Okay, so in total, how many days is that?
29, the last time, 29 overnights, correct?
Yes.
Okay, and then, from November 3rd until now, I'm sorry, just 1 second, Your Honor.
May I, Your Honor?
Just a minute, let's figure this out first. You need a calendar, Ms. Sharp?
Yes, I can bring a calendar, Your Honor, I can do it. Sorry, I was relying on his mom, which she's out there,
Oh,
and she knows all the dates. I was gonna put her up on the stand to do it, and. Okay, so the first time was 29, and now, my client's stating it's 34 overnight,
34 total or 34 this time?
additional,
Okay, so we have a total of 63, it looks like,
correct?
is the total. Ms. Martinez, is that square with your understanding?
Yes, yes, it is. I was just wondering if the court was going to go by its recommendations that anybody that had pled guilty to domestic violence should not have 50-50 custody of the minor child, because
We are enforcing the orders that
Okay.
are in existence at this time. We're not
is the
gonna
court
spec-
going to investigate because of the domestic
Court does not
violence? of the plaintiff?
investigate.
Oh,
Other
the
agencies,
FOC handbook said it. does.
other agencies investigate, CPS investigates, the police investigate, the court does not investigate.
And I was just wondering, because the FOC handbook says that the court would investigate. if
Court
they
will
were-
order that the child be turned over to him immediately,
Okay.
forthwith, and that he will have the child for the 63 days that he has been denied as make-up parenting time. Yes,
I can have my ride here. Cindy, go get the minor child and bring her here within a half hour. She is only about 5 minutes from here. If the court can wait a half hour, I can have her here in a half hour.
well, okay, I'll have the deputy take you, he can holding tank, and then we'll see that the child.
I'm sorry, should she bring her here to this
You can
courtroom?
do that when you go to jail, figure it out. So,
I can, there's a personal protection order against him and he continues to address me. When my friend Cindy goes to get, should she bring her here to this courtroom?
Bring her back to the court. In fact, what we'll do is we'll have Ms. Sharp and her client, they can be out in a conference room and the child can be turned over to them. And at that time, once Ms. Sharp is confirms that he has the child, then we will allow your release.
Sure.
Okay.
Can you do that for me, please? Thank you.
The child has been turned over to your client, is that correct?
Yes, Your Honor, she's in the
Okay.
hallway.
Court will again reiterate that the child will remain with the plaintiff in this matter for the next 63 days for the makeup parenting time. And thereafter, the parties will then comply with the current order that's in place. Anything else, Ms. Sharp?
The only issue would be, Your Honor, is that the child goes to school and the child, or the school has given my client a hard time before because it didn't say that it was his parenting time at that time. It's gonna be probably the next 7 days since I had to do a 7-day order for it to go into place. So there is concern that the child won't be able to go to school because he can't drop off and pick up based off of what they believe is the current order, not. So but we just want to make sure she still can go to school somehow.
Oh,
Yeah,
Yeah, and if you want to add that in the order in case, it's necessary, because you're gonna have the child for 63 days, so you'll need it. So but the fact is that he does have opportunity or does have the right to take the child, pick up the child and be involved in the schooling. He would have that right anyway pursuant to MCL 722.30.
yes.
Ma'am, don't shake your head unless you know the law.
I'm sorry, but the only reason why it's like that is because those are my parenting time hours. Mr. Beck doesn't have Bella during school hours. So that's why the school has that in place to follow the order to a T.
The law states that the non-custodial or the other parent, even if they're not a non-custodial, the other parent has the right to all information concerning schooling, doctor, etc.
Yes, they inform him about anything that goes on in the school, but just to follow the order to a T, he was not allowed to drop her off at school at noon or pick her up at 3:30 because those are not his parenting time hours.
We'll put that in the order, make sure that that's taken care of so that he is allowed to drop off, pick up and do whatever's necessary for the schooling purposes.
Thank you.
Anything else, Ms. Sharp?
Just that probably in the next 7 days, because it will be a 7-day order, he probably won't have the ability to take her to school and my client just wants to, unless maybe mom can reach out and let them know. Or my client will try to reach out, but they won't follow anything without the order. So
That's up to
Yeah.
that's up to the defendant.
Okay.
I'm not gonna
Thank
order that she contact the
That's fine.
school or anything at this point.
thank you, Your Honor.
Ms. Martinez, anything else that you?
Yes, sir. Can you tell me how this is in the best interest of the child, being that
Ma'am, I
I'm a
don't
victim of domestic violence that he pled
Ma'am,
guilty to?
file a petition if you have.
Thank
an
you, Your
issue.
Honor. Thank you so much.
Okay.
Court calls case People versus Courtney Waldick.
Or Your Honor, it happened with Courtney Waldick. Judge, this is date time set for our second probable cause conference. At this time, Ms. Waldick is inclined to waive her right to preliminary exam, and we've gone over those rights.
Waldick, is that correct? You're waiving your right to a preliminary examination?
Yes, Your Honor.
You understand that is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, Your Honor.
And you understand that you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive their right.
Yes, Your Honor, we do, and if that's the date, I'd like to address bond at the appropriate time.
Pardon?
Yes, I do waive, but in case this affects her pretrial date, I'd like to address bond at the appropriate time.
All right. So before I set the date, you may address bonds. Go ahead.
Your Honor, at the time my office charged this case, we requested a 100,000 cash surety bond. At this time, I am renewing that request. I understand that Ms. Waldick was given a 50,000, 10% bond at the time of her arraignment. When we were last before Your Honor, I did not have the benefit of certainly I still don't have the report because the investigation continues to be ongoing. However, the information that is now available to me has grown substantially since we were last here. I will start off by going through essentially the timeline of what occurred here. In the early morning, January 21st, 2024, people that were commuting to work or other locations observed and discovered the body of Miss Shelley Mason lying on the side of Prospect. It was unknown at the time what occurred to Miss Mason, who killed her, and who was involved, but the police were rapidly able to put together an investigation that led to them to be able to identify Miss Waldick as the person that killed Miss Mason. On January 20th, the day of the crash, Miss Waldick had been to a baby shower. She then went to Maze in Ypsilanti with her friends, where she was drinking with her friends. She was texting people that were not present, somebody who was either her friend or her boyfriend. She had texted things to her boyfriend about meeting up with him later. In her text messages to her boyfriend, she indicated that she was out drinking with her friends and that she would be continuing to be drinking with her friends. She referenced to him that she wouldn't feel comfortable driving too far to meet him later, and I apologize for my language, but that she was going to be really hopped up. She did drive instead, though. She drove her car and she killed Miss Mason. After getting home, she did stop. She did not call the police, and she left Miss Mason there. After getting home, Miss Waldick saw her roommate's name was Sarah. And notably, we now know that Sarah actually drove that same route as Courtney a couple minutes ahead. And Sarah did see Miss Mason alive and walking on the road. And Sarah initially told the police that she saw Miss Mason walking on the shoulder of the road, which is consistent with physical evidence in this case as well. But when Courtney got home, and this is supported by Sarah's statement, as I understand it, as well as from the text messages that followed this, Courtney was quite hysterical. I'm gonna call her Courtney. Courtney told Sarah that she had hit someone and that she needed to go back. Courtney and her roommate took over an hour to return to the scene. During this time, Courtney did not call the police. She did not ask for anybody to go out to the scene to help Miss Mason. Instead, she started texting her friends, her family. Her reaction to this was substantial and quite emotional. However, when Courtney came in for her interview with the police, which mind you was the Friday following, so she came in for her interview on January 26th. The crash occurred on January 20th. She told the police that she believed that she hit a deer. This deer had just kind of popped out of nowhere, that she saw it just coming at her. We know from our interview with Sarah, the roommate, that Miss Mason was walking down the road. Sarah saw Miss Mason a couple minutes ahead of Courtney, and that Miss Mason was walking down the road. But what we also know is that Courtney didn't think she hit a deer. Sarah has now told us that Courtney came home and said, I think I hit someone. Sarah has confirmed for us that there was no mention of a deer. So when Courtney got home, thinking that she hit someone without calling the police or stopping to help that someone, she continued to tell her friends and her family what she had done and what stress she was under. She didn't call the police, leaving Miss Mason lying in the snow on the side of Prospect in who knows what condition. And I will say that the evidence in this case bear out that it is possible that if Courtney had just called the police, Miss Mason might still be alive. That's why we have crimes like this. That's why the penalties for crimes like this are so substantial, because Miss Mason may have still been alive and may still be with us right now. Miss Mason was a mother, she was a daughter, and she was a grandmother. And that woman was left on the side of the road without anybody with any help being sent her way. But not only did Courtney not call the police and not attempt to save Miss Mason in any way, what I now know is that Courtney then deleted approximately 150 messages on her phone. She deleted those messages that I referenced earlier about her not wanting to drive so far. She deleted a message about her being fucked up. And I will make clear for the record, the message says, I'm going to be fucked up, not that she currently was when she sent it. She deleted a message that said, I wish I would have called 911 immediately. And she also deleted, got to live with it and get my car fixed ASAP. Deleted before her phone was turned over to the police. What she also did when she got home, and I know that defense counsel will argue that this was normal for her behavior, was she parked her vehicle in her garage. That car remained in the garage, and the garage door remained closed, as far as I understand it, with the garage inside. The police subsequently did a search warrant, and it wasn't until they were there with the search warrant that they were then given consent to go into the garage and discover the Jeep. Your Honor, her guidelines, as I score them, are 19 months, 38 months, as I currently have them scored. My office requested a 100,000 cash surety bond at the time of charging this, and I am again renewing the request. Thank you, Your Honor.
Response.
Thank you, Judge. Obviously, I don't have to tell the court that Ms. Waldick stands here before you innocent until proven guilty. I'm not going to try the case in front of you, but I will address some of the things that were just said. First and foremost, there was an arraignment on January 28th where, as Ms. Hughes indicated, their office requested a $100,000 bond. A record was made. Prosecutor who attended the Zoom arraignment on that Sunday, myself, each made a record, and bond was set at $50,000, 10% with an alcohol tether. It's our argument to the court that that was not an unreasonable bond, nor was it an abuse of discretion. The fact that there's an ongoing investigation or this was charged early, that's not my client's fault. Maybe the prosecutor's office should have waited until the investigation was complete. With that said, Ms. Hughes indicates there was some drinking going on. My client turned herself in as a person of possible interest to the Washtenaw County Sheriff's Department to Detective Webb on January 26th. That date could have been sooner, and the police report indicates could have been sooner, but Detective Webb actually asked her to come in on Friday and not the Thursday beforehand. I appreciate Ms. Hughes that no evidence that Ms. Waldick was quote unquote fucked up, but that maybe she had said she was going to be. That talks about something in the future. It doesn't mean that she was. The same witness that Ms. Hughes talks about, and I don't think Ms. Hughes would This Sarah, quote unquote, Sarah, who has come forth and said some things, is the same Sarah who said she knew nothing about this originally. So now we have two different stories from Sarah, because originally Sarah said she had no idea what happened on the date in question. Ms. Waldick is now, since the arraignment, been before you twice here on February 22nd for her. She's been compliant with bond the whole 2 months to today's date that she has been on bond since being arraigned, with an alcohol tether the whole time before she was released from jail, with absolutely no issues. So this is the second time before you, but including going to the sheriff's department to speak to Detective Webb, she's appeared 3 times. She's not a flight risk. In addition to being on alcohol tether and having no issues, she's also reporting, checking into community corrections weekly. I've heard nothing today regarding any bond violations, because I don't think there are any. There's been no change in circumstances as we see it since the date of the arraignment. Ms. Waldick is definitely not a flight risk, and she's not shown that she's a danger to the community in the past 2 months at all. Again, there's been no allegations of that. Judge, the 8th Amendment of the U.S. Constitution indicates that the court shall provide a bail that is not excessive. Stack versus Boyle, 342 U.S. 1, and People versus Edmond, 81 Mishap, 743 says bail that is set in an amount higher than reasonably calculated to give adequate assurance that the accused will appear is excessive under the 8th Amendment. Edmond goes on to say that courts have held that money bail is excessive if it is in an amount greater than reasonably necessary to adequately assure that the accused will appear when her presence is required. Court rules are designed to enforce these principles, Judge, and under these rules, there's a double presumption that a pretrial arrestee will be released without any case bail requirement. And that's stated in 765.6, MCLA 765.6, that in part, a person accused of a criminal offense is entitled to bail. The amount of bail shall not be excessive. Court rules go on to indicate what the money bail should be and what is required, what's considered in terms of setting bond. And those things under subsection F 6.106 say a defendant's prior criminal record. She has none. Defendant's record of appearance and non-appearance, or flight to avoid prosecution. She's been at everything. She's actually been at more.
Well, that flight issue also includes concealment of evidence, doesn't it?
And I guess this came up at the bench when we were here on, surprisingly, on 2/28 or 2/20, our last probable cause conference date, 2/22, when neither party had asked to address bond, but you had mentioned it.
Well, counsel, if you want to point at me, I'll tell you exactly what I know about this case. What I know about this case is the warrants came to me. That's how I knew. And that it came to me because I'm in charge of all of these felonies and reviewing every bond that comes through. So that's how it came to me. So if you want to make dispersions against the court, go for it. Let's roll.
I'm not making dispersions. I'm saying the court had asked us to approach and talked about bond.
Because I'm putting everybody on notice where I am. That's why. Go ahead. You want to come at me? Let's do it.
I'm making a record as to.
No, go ahead and make your record. I'm just telling you where I am.
In addition, and obviously we know that search warrants aren't necessarily evidence. I appreciate that you know things or allege things because you were a party to the search warrants. In addition to what I've already indicated in terms of bond, she's not a flight risk. She's appeared at every court appearance. She's gone to the sheriff's department, met with Detective Webb. She consented to a release of and a search of her phone. She doesn't have any shown history of substance abuse or addiction, a mental condition. She's employed thankfully at a local hospital. She's got family members here. She's probably got about 5 family members here. She lives locally. She's got ties to the community. Again, bond is set at protecting the community and a flight risk. I think that what she has shown over the course of the past 2 months is she's neither. I'd ask that bond stay the same. Thank you.
From the people.
Nothing further, Your Honor. Thank you.
The court, in looking at the file and so that the record is clear, counsel came to the bench and the court was apprising counsel that the court had some concerns with the bond that was set. Neither counsel at that time was ready to raise the bond. There were certain things that came to the court's attention that were not in the magistrate's mind nor the magistrate's information at the time of the arraignment. I brought that to counsel's attention, quite frankly, out of fairness to both sides so that it could properly be argued before the court. What was not known, certainly to the magistrate at the time, was that there was this delay. There was information that was provided to the magistrate at the time regarding the defendant turning herself in, which was somewhat confusing as to how that occurred. And I apprised counsel of that. What my initial conclusion or what I saw was based upon what was presented to me prior to that hearing. Additionally, since that time, something that was not available to the magistrate were these text messages, which lead also to the defendant's knowledge, which play into this court's mind as to this defendant's danger to the public. Furthermore, there is, in terms of the issue of flight, of concealment of evidence and the like, now the deletion of text messages and other evidence in this case, which have just been alluded to, the deletion of basically evidence, which I think also bears upon the defendant's risk in this case. Also, the likelihood, the court can take into account the likelihood of conviction and other things as it regards to setting a bond. But certainly there is now clearly more information that's available to the court regarding this defendant, the offense that was committed and the like. The court, I will also take into account the fact that I don't have any community corrections violations. I don't have anything along those lines. I do not believe that, given the information now available to the court, that the amount of the bond that was originally set, I do not believe that it is appropriate, and that additional bond would be required in this case. Defendant's bond, Mr. Allen. The defendant's bond in this case will be increased. I think that the amount requested by the people was an appropriate amount. Quite frankly, it was appropriate, but now knowing what I know, I would actually raise it beyond that, but I will not do so. In this case, her bond will be increased from $50,000 cash surety to $100,000 cash surety. Are they, counsel, just for the purposes of anything, are they able to do that right now? Or
we've made arrangements. There's a surety bondsman in the courtroom who can do that. If you can give us 15 to 20 minutes, it'll be taken care of.
She'll be taken back and do that. I think they can do that.
Hold on, sorry guys. We need to arraign her on the information. I apologize. I interrupted all of our proceedings.
Oh, okay. Yes, that's to the circuit court.
We'd waive the reading of the complaint and have the matter set for circuit court pretrial. I asked that she'd stand.
She stands. Defendant having waived from a reading standing mute, the court will enter a not guilty plea. Pretrial, technically, counsel, and I'll do it for the convenience of your schedule. Technically, she would be given the end date, but if it looks like you're going to post, I can give the out date. So
yeah, she'll be out.
She'll be out.
May 2nd at 1:30 before Slate Thursday.
Pretrial, May 2nd, 2024, 1:30 before, that's a Slay Monday. Slate Thursday.
Judge, after that surety is posted, can I come back with proof so that, please?
Thank you. Hold there.
Good morning, Ms. Richter. Can you hear me?
Yes, good morning, Judge. How are you?
Good morning. Nice to see you. Mr. Moddard is here with us at the court. I'll call the case. We're on the record and on the live stream. This is Portfolio Recovery Associates versus Mitchell Moddert. Mr. Moddert is here at the courthouse in the conference room, so we can set up a private conversation if we need to using a breakout room. Attorney Christine Richter from Portfolio Recovery Associates is here on behalf of the plaintiff. This is a pretrial in this matter where the plaintiff filed a lawsuit suing the defendant for $7,738.02 plus cost, interest, and attorney fees. Mr. Moddert was served with a lawsuit and he filed a handwritten answer that we accepted. And essentially, he says this is fraud committed by his ex-wife. He doesn't name her, but says he didn't do this and this was all done by his ex-wife using his name and social security number. The debt is from several years ago, and I don't have very many facts, like the billing history, where the bill went to, where it was paid from, that sort of thing. Mr. Moddert, what's your ex-wife's name?
Now it's Michelle Jean Adams.
Jean, Jean?
Yes.
And what was that last name? I didn't quite catch that.
Adams, Adams.
Yes.
All right, you were married to her from when to when?
I don't know. I divorced her in 2007. She's done this several times.
All right. Divorced. So you've been divorced from her from 2007, and during that time, did you and she live in the same house?
Well,
After you divorced her, did you ever live together?
No. No.
All right. Some we can learn by where the bill was sent, where it was paid. It appears this was a credit card with Synchrony Bank, and there would have been a charging and paying history on it, which could shed some light on this. Ms.
Your
Richter,
Honor,
do you have
if
any?
I may, based on what I've seen from the billing statements, this was a Care Credit Synchrony Bank charge account, and Care Credit is typically used for medical or cosmetic or dentist or veterinarian procedures. What I see here is a single charge on February 18th of 2019 in the amount of $7,500 for a plastic surgery center in Grand Rapids, Michigan. That's the only charge that I see on there, and there was maybe 1 or 2 payments on it before it went into default.
Did you ever have plastic surgery in Grand Rapids in 2019?
No. Never. It was a lot bigger than that. It was over $30-some thousand she had done. She had different things done to her body and charged all this stuff up. I never received anything, no credit cards, no thing, never signed for anything. I'm on full disability since 2015.
I didn't realize that.
Yes. And I have all my stuff paid for through full Medicaid, full Medicare. And she knows she did all this, and she got them she gave them a couple of payments, and then they took her name off somehow off the thing. And I was able to talk to her through my daughter a little bit, and that was about it. And, she says, oh, don't worry about it. It's okay. And she does this with other people too, so.
Well, you've alleged in your answer that she had done this to others as well. Ms. Richter, do you have any thought here?
I do have one thought. Mr. Motor did indicate he is on Social Security. That in and of itself may qualify him to allow me to close this out on a hardship a financial hardship situation, if I could get a copy of an award letter. And perhaps we wouldn't even need to go down the road of, who used this credit card and what the circumstances were around it.
I think she should be accountable for what she did. She's done this a few times and got away with this situation, and now she's even done it recently in the last couple of weeks here again to somebody else. And yeah, the only thing I get to do is talk to my daughter to find out what's going on with her mother.
Well, in addition to the civil ramifications of this, this is a crime if your information is accurate. If she falsely charged a debt in your name and had this significant unpaid medical bill, it's a crime. Whether you can get anybody to investigate it or charge it or prosecute it is another question. This is only regarding the civil debt. And portfolio recovery could attempt to identify her as the actual person that made the charge and pursue a civil case against her. Your only concern is you don't wish to be liable for this $8,000 approximate debt. What Ms. Richter indicated is if you are on Social Security, disability, or other Social Security, you're essentially, even if it was your debt, it'd be very difficult to collect it, if not impossible from you. They can't seize your Social Security. And if you can confirm that with the attorney, they could simply dismiss the case against you. Whether or not they proceed against her or anybody proceeds a crime against her, is up to them. What I would propose, Ms. Richter, is we adjourn this about a month. I put the two of you in a breakout room. You give him what you need from him. And if he provides that information to you, you can simply dismiss this as a hardship case. Do you have an objection to that?
No, Your Honor, that sounds great.
All right, today is March 4th. Let's adjourn this to April 8th at 9:30. Mr. Motter, I'm going to put you on what's called a breakout room where you can talk privately with Attorney Richter. She wants you to provide information regarding your Social Security disability status. And if you can do that, they may then just dismiss the case. Now, no one's going to do a criminal investigation unless you or somebody else make a complaint. You may be able to give her enough information which they could pursue her as the actual generator of this debt. But you were divorced well before this happened. I do believe you didn't get plastic surgery in 2019 and never got billed for it. So, all right, let me set up a breakout room, put you both in.
Can I have a further date than the 8th, because I won't be here on the 8th? Will I have
Where
to
were
be
you?
in court at 8 on the 8th?
Yeah, well, if it's dismissed, you don't have to be. Why, are you going to be gone on April 8th?
Yeah, I will be gone till the 10th of April 10th.
All right, well, let's set it for April 15th.
Yes, a statement, Judge. I just want to make, should be a second one. I just want to make sure that the court is.
I mean, I've read everything that's in the PSI report. If you want to continue to confer or something, then I'll take this up when we have a break in the trial. Okay. All right. If you can have him wait in the back.
Small one.
All right, we're going to go on the record. In 2023 CR 0696, State of Texas versus Chris Lynn. Can I have the parties announced for the record for the state?
Second for the state, Your Honor.
Defense?
Cornelius Scott.
And are you Mr. Lind?
Yes, ma'am.
All right, we were here previously and it was reset to have a witness appear by Zoom. The witness is not here by Zoom. Mr. Cox, do you have any other witnesses?
Yes, Judge.
Right, so I'll let her tell me her statement. All right, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? You're gonna have to speak up.
Yes.
All right, you can lower your hand. State your name for the record. All right, so my understanding from your attorney is that you sent in a letter by email to probation. Is that correct?
Yes.
All right, can you tell the court what you wanted to say? All right, and I'll allow her to read her email because if the email would have went through probation, I would have just read it anyway.
Absolutely, Your Honor.
All right, you may read your email.
I wrote to whom it may concern. I'm writing to in hopes that you may consider offering probation to my stepfather, Christopher Lynn. I maintain a good relationship with him, and I know he is not a threat to me or my siblings or my children. I don't want a no contact order also, or protective order, I'm not sure what it's called.
Okay.
I had also requested a no for the no contact order because at the time I was still helping my mom take care of my uncle. He has now passed away, but I do still help her take care of my brother, and she helps me take care of my son as well. He has been a big help and stepped up as a father to all three of us, and I do believe he can continue to do so if given the opportunity. I feel as though he has spent enough time, and we are all just trying to put this behind us and move on with our lives.
All right, thank you so much for coming down to let me know that. I really appreciate it. All right, and then the court is also in receipt of an email through probation, and I reviewed that as well. Okay. All right. And the court is ready to pass sentence. Mr. Lynn. All right, I've listened to what the witness has had to say, and I've also listened and read the stipulations. I've read everything, right? And I want you to know I understand what was stated to me, and I understand the wishes and desires of people, right? So I know that from reading the PSI report that people want you back in the home. And it appears that people want you back in the home because financially there's an issue. For example, financial support is needed, right?
Yes.
Okay. Thank you. But this is indecency with the child by contact.
Understand.
And it was reduced to that from continuous sexual abuse of a child.
Understand.
You can't be around children.
Yeah.
And I'm not going to grant your application. I don't think this is based upon what I've read. I don't think this is a probation case.
Understand.
Okay. All right. And I want the mother of the children to know that the statements made by children or people who are complainants in these cases, it is not their fault that you're going to prison. A lot of people think, oh, it's the child's fault. Sometimes people don't put their children first. It's, oh, I need another source of income. Need another source of income. People need to work 2-3 jobs instead of perhaps putting their child in a situation where their child is not safe. Okay. And I appreciate your understanding that. So this is what I'm going to do. I'm going to find you guilty, sentence you to the 10 years in the prison, give you credit for any time served. There's a $1,500 fine. Time and money will run concurrent. There's to be Chapter 62 compliance. There's to be no contact with the complainants. All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. I keep forgetting it's 2024. Did you review that with your attorney? Did you understand it and did you sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you. We can go off the record. So, are you the mom? Yes. Here's the thing, and this is just a side note. Oh, and Mr. Lynn, this is not for you because you've accepted responsibility, and I appreciate you accepting responsibility. Children who have been abused in the way that your child was abused, bringing them to court because you can't meet your rent or your mortgage or pay your bills or have somebody else to watch your children, that's an issue. You understand? Because when you bring them into court to do that, that is not acknowledging what they've been through. What you're doing is saying, yeah, I know what you've been through, but we got other issues. I got a bill that needs to be paid and he can help me pay that bill, so suck it up. That needs to stop. And it is not her fault that he's going to prison. I'm sending him to prison. So if you want to blame somebody for not having your mortgage paid, your electric bill paid, or somebody to help you watch your children, you can blame Judge Boyd. You understand? Your daughter and the children who are impacted by this, they need to go into therapy. And you know why they need to go into therapy? Because one, their mother is not standing up for them. Their mother has brought them into court to write a letter saying that the person who has sexually abused them needs to have probation. So don't be going home blaming her because your man is no longer at your house. Your man is no longer at your house because he sexually abused your children. And any of your children who have children, he should not be around them. And it was very good of him to accept a plea and to accept that he has done wrong. And you need to open your mind and accept the fact that he has done wrong and he should not be around your children. And you need to apologize to your children and tell them you were wrong for forcing them to come in here to give a statement about, we want him home. I'm not in fear for him, so your bills can get paid. Do you understand? Good luck to you.
The last one.
That's the last one.
Okay, here we go.
See that? Very official self-authentication. Is that? I'm not sure.
Ready? Court does call the case of the people of the state of Michigan versus Lovely.
Yeah, thank you, and good afternoon, Jonathan Emmons on behalf of the people.
And Kenneth Overwater, Assistant Public Defender on behalf of Ms. Lovely, who stands to my right in court.
Okay, thank you. We're ready to proceed to exam.
Judge is ready.
Yeah, people are ready to proceed in this matter. My understanding is that there's also some kind of a violation hearing. Did you want to do the exam and then kind of do everything all at once, or however?
Yes.
Perfect.
That's.
Not that there's anybody else left. I'm going to call my first witness, Corey Johnson, but I have the officer in charge, Dusty Patel, also here with us today.
All right. Sir, please come forward. Be sworn.
How much for our firm testimony about today? The truth of the truth and nothing but the truth.
George, I think. All right, go. You may inquire.
Yeah, thank you. And good morning, Mr. John, or good afternoon, Mr. Johnson. Thank you for being here today. Just to kind of get right into it. With the court's permission, there's a child involved here. I'm just gonna refer to it as the child, so I'm not putting his name.
That is fine.
and likewise, if defense could. Do you have a son?
Yes, I do.
Okay, and who is the mother of that child?
Defendant.
Okay, and just identify her. Okay, and is that somebody who you see here in the courtroom today? And how do you know Miss Lovely?
She's an white.
Okay, and you guys are obviously divorced then?
Yeah.
When was that divorce, when did that become effective?
2019.
Okay, and as such, out of that divorce proceeding, was there a custody arrangement that was entered into regarding your child in September of 2022?
Yes.
Can you briefly tell us what the terms of that arrangement were?
Yes, we each had 50-50 custody, joint custody, and then we did our exchanges on Fridays.
Okay, and so is that one parent would drop them off at school, the other parent would then pick them up?
Yes, you complete your week by dropping them off on Friday, and then the other parent would start their week picking them up.
Okay, so I want to fast forward to Thursday of I'm sorry, February of 2023. Did anything change regarding that arrangement, that custody arrangement?
Yes, that the first week of February, I would have had custody of my son, and I was contacted by investigating the claims that she had made against me. They turned out to be false. So, I believe it was like the 6th. They contacted me and they said, we're going to go back to normal custody. We advised her to continue like you should be, dropping him off at school, and I would pick him up, et cetera. And that never happened.
Okay. So February 6th of 2023, I believe that was a Monday.
Monday or Tuesday.
Okay. You were supposed to have the child on what day? That Friday, so roughly the 3rd. I looked at a calendar earlier.
Yeah, I have to look at it.
Okay.
Well, hold on, I just want to make sure. On the 3rd would have been your pickup, the beginning of your custody.
Yes.
Okay, go ahead.
And then that should have terminated with you dropping the child off on the 10th.
Yeah, Friday.
Okay.
Whatever the Fridays were, got it.
All right. And so then now turning to the 6th of February, CPS gives you the okay to resume your pickup. Do you have any interaction with the defendant regarding the child exchange on the 6th?
Yeah, she contacted me on our family wizard.
Okay.
Told me she was not returning.
Okay. Prior to February 6th, had you been observing her social media feeds?
Yes.
Okay. And did you have any concerns about what the defendant was going to do with herself and the child?
Objection, Your Honor, as to the relevance of what's on her, allegedly on her social media feed, certainly with regard to what he may have speculated he was worried about her doing.
Well, but that goes to his state of mind as to everything. I'll overrule the objection. I'll hear it.
Go ahead. Yeah, so had you been kind of monitoring her social media?
Yes, I was concerned that she was going to take state.
Okay. With a specific destination?
New York, that's all I knew.
Okay. And so did you share those concerns that you had with the defendant at all?
Yes, I told her that would be a violation. We were required to provide an itinerary to try to work, and that never happened.
Okay.
I verified that with Sarah Mazer. She said they hadn't received an itinerary, and that what she provided wasn't appropriate.
Okay. So on the 6th, obviously the child does not return to your care.
Right.
Okay. What happens then on the 7th?
I contacted and law enforcement in reference to the issue. A order was filled out and sent to the judge by a friend of court to pick my son up and return him to me. That was signed by Judge O'Brien.
Okay. Did you anticipate that you were going to be able to pick up your child from school that day?
Yeah,
Okay. Did you reach out to the school at all?
I did, and they told me that he hadn't been brought that day.
Okay.
I think he said it was like mental health or something like that.
You obviously didn't excuse him. Okay. Okay. All right. The order, when you contacted the friend of the court, were you able to receive a copy of the order, from friend of the court?
I did.
Okay. I'm going to approach with what's been marked as people's proposed exhibit number 1. If I may, Your Honor.
Yes, you may.
All right, Mr. Johnson, that exhibit that I've handed you, you've had an opportunity to review that before testifying today?
Yes.
And is that something that you're familiar with?
Yes, this is the order that they sent to the judge. That she signed to pick up.
Okay. And is that a fair and accurate copy of the order that was submitted and signed by Judge O'Brien at the 22nd Circuit Court?
Yeah.
Okay.
Got it.
And that's the order. What was that order informing what was supposed to happen with the child?
I believe, let me read it just to clarify. Says that she's supposed to return to me immediately and not leave the state of Michigan.
Okay. Your Honor, unless there's any objection or voir dire on the issue, I'm going to move to admit people's proposed exhibit number 1.
No objection for purposes of exam.
Exhibit 1 is admitted.
Did the court want to review that?
Yeah, I'll say.
Thank you.
Thank you. Standard order. Okay.
Thank you. So now turning your attention then, so that February 7th, that order gets signed. You said that you contacted police. What agency did you contact?
I contacted Northfield Township, and I believe it was a detective that called me back. He called me back.
Okay.
I sent him that document that I had by email, and then he basically said because of the multi-jurisdictional thing that he was going to forward it to the state police.
Okay. And as such, did you end up later that day speaking to Trooper Pitzel? Pitzel. It rolls off the tongue. Pitzel. Okay. All right. And where did you speak to him at? Where did he come to your house? Okay. You spoke to him over the phone. Did he? Well, you kind of explained the situation to him as best you could. Okay. All right. Moving forward to Friday the 10th. Had you received custody of your child by the 10th?
No.
Okay. Then moving forward to the 13th, that Monday, February 13th, by that point in time, had you received custody of your child? Okay. And it's your understanding that pursuant to the order, the child was supposed to remain in your care until further order of the court. Okay. All right. So then tell me what happens on the 14th of February. Had you, on the 14th of February, so this is Tuesday, had you received custody of your child? Okay. So what did you do or what happened in terms of that custody arrangement?
And contacted front of court and law enforcement and advised them that at that point she wasn't even in Michigan anymore. I
Objection, Your Honor, foundation as to where she was.
I can, if it.
Well, he is, as I understand his statement, whether it's true or not, that's what he's indicating. So there may not be foundation for what it is, and the court will give it whatever weight I give that statement, but I'm going to overrule the objection. Go ahead.
Thank you. Go ahead. So I'm sorry, you reached out to friend of the court. You gave them some information.
Yes.
What happened as a result of that information?
They submitted another order to the judge. And this was for her, this was terminating her parental rights, and she had until the 24th. It's an ultimatum that she had to return them to front of court by then. That was the latest, but it was to immediately do that.
The 24th of February.
Yes.
Thank you. And if I may approach with people's proposed exhibit number 2. The 14th.
Yes, you may.
Thank you. Mr. Johnson, you've been handed what's been marked as people's proposed exhibit number 2. We just talked about the court order, the document in front of you. Do you recognize that item?
Yes.
Likewise, did you have an opportunity to view that before testifying in court today? Okay, and is that a fair and accurate copy of the order that was submitted and signed by Judge O'Brien on the 14th of February of this year?
Yes, it was.
Okay, and unless there's any objection or voir dire on the issue, I'm going to move to admit People's Proposed Exhibit number 2.
No objection for exam purposes, Judge.
Exhibit 2 is admitted.
All right, so then this order gets signed without telling me what you spoke to. Had you been communicating back and forth with the trooper during this period of time? Okay.
He advised the contact.
Well, don't tell me what he told you. I just want to know if there was still that communication. Okay.
Keep me updated on status of it.
And had you been communicating with the defendant at all, sending either via Family Wizard or otherwise?
No, I sent her a message stating that I was contacting the authorities. She didn't return my child.
Did she ever respond in any kind of way? Okay. All right. So then to finish this up, when was the next time you actually received custody of your child?
I called the school Wednesday or Thursday. It was like the 16th, I think, that week. And they said he was there, that he had been dropped off. And so I told them that I would be there early to pick him up. And I had the order. I gave them a copy of that. And so they were aware that I had custody of him.
Okay. All right, and that was February, you believe, 16th of 2023, Thursday. Okay. And again, at that point in time, to the best of your knowledge, between February, well, I guess 6th and February 24th. So this is after communicating with CPS to I'm sorry, February 16th. It was the defendant that was the only barrier between you and having custody of your child? Okay. There was no communication that he was missing or anything to that extent. And in fact, had you spoken to your son during that intervening period of time?
Phone call with him, just the one.
Okay. You had one phone conversation with him? You recognized his voice? Okay. All right, and I guess, how old is your child? Okay, so he doesn't, he may, I guess, but does he have a phone? Okay. So when you spoke to him, how did you get in contact with him?
We are required to call each other's cell phone.
Okay.
Alante cell phone.
Okay, and so you called the defendant's cell phone and you were able to speak to the son?
Yeah.
Okay. Thank you. Your Honor, with that, I don't have any other questions for this witness.
All right. Before you begin cross-examination, I just want to clarify one thing. The first order, sir, that was signed on by Judge O'Brien on the 7th, there was an indication that the child was to be returned to you, that your understanding was that the child was supposed to be returned and remain in your custody.
Yeah.
As I'm reading this.
Go back to 50-50, our regular agreement.
Okay.
I think
that's fair. And if I'm counting out the dates, had the child would not have been returned to you really until the 14th, right? If I've got it.
I was supposed to have him that first week of the 3rd.
Correct. So you would have the 3rd basically through the 9th,
yeah,
right? Then the defendant would have the 10th through the 13th. And then your next time would have been the 14th and beyond.
The 17th.
Or the 7th.
Yeah. Whatever that Friday would have been.
Yes, the 17th and beyond, I guess.
Yeah.
So I guess, okay, so here's what I'm trying to figure out. I'm looking at this order and I'll let you see it again, the order of February 7th. And it indicates that they're ordered to immediately return the minor child to defendant's father custody care and so on. Had that order been effectuated on the 7th, you would have then had the child from the 7th to what, the 10th?
Yeah.
Okay. And that's what didn't happen. Okay.
I didn't get him on the 3rd. I didn't have him. He was never returned. I never got him that week at all.
Right. So, but what I'm saying is the time, I don't know really what I'm saying. What I'm indicating is you didn't get the child on the 3rd. The order to return the child to you signed the 7th. But if everything were to go back, really, there's like 3 days from the time of the order that it didn't happen. I mean, from the time of these orders, right? 3 or 4 days. Okay. The week then of, oh, let me just stop there for a moment. Because one of the questions the prosecutor asked you then is, on that order, that the child was to remain in your custody. That's not quite correct. On the 7th, is that right?
I believe she's supposed to be returned to me so we can continue our parenting time.
Okay, so, okay, that's something different. That's what I'm trying to figure out. On the 7th, the judge is ordering that the child be returned to you as though this interruption had not occurred. And then it would go back to the normal schedule, right? So from the 10th to the 17th, the defendant would have had primary possession of the child at that point, not really custody, but possession.
Yeah.
What interrupts that, though, is then the order of the 14th, which then says, and this may have, I just want to be clear on it because it may be what you were talking about, the 14th order. That order doesn't, as I'm reading it, isn't now referencing the parenting time. That order is saying this child goes to the father. That's it until the court says otherwise. Is that your understanding?
Yes.
Okay. Pardon?
That's how Frank Court explained it to me as well.
I probably did a better job though, right?
You did.
Okay, thank you. All right. Thank you. No, it's okay. All right. Cross-examination.
Judge, if I could just have a moment.
Yeah.
May I receive the exhibits?
Mr. Johnson, are you currently employed? How? You do what?
I work in Little Diablo Salsa in the morning.
Little Diablo Salsa. Were you previously employed in law enforcement? When were you employed in law enforcement?
In 19.
How long were you in law enforcement prior to that?
Your Honor, I guess I'm going to object to the relevance of the question.
What is the relevance?
Judge, if I'm allowed to understand his involvement with law enforcement, it might explain why he chose to involve law enforcement in this in order to deal with what is a civil matter.
I don't know. I'll let you go. I don't think it's gonna matter to the court because if a child's withheld against a court order, I don't know that that's a civil matter, but I'll let you have your definition. Go for it.
How long, when did you start working in law enforcement? And where did you work?
Police department. I worked for Amber Township, Northfield Township, and shortly, a little short stay at like the Golden Stoppers and reserve work.
Prior to the reserve work, you, Northfield, Hamburg, and Pinckney, you were working there as a police officer? Would you describe this, the child custody arrangement in the course of your divorce as contentious?
Somewhat, yeah.
And this all started when Ms. Lovely filed a Child Protective Services complaint against you, correct? This particular incident.
Yes.
When did that happen?
I believe it was beginning of February. Amanda Moore contacted me from CPS in Oakland County.
So early February, CPS contacted you, indicated that an investigation was being started. And you were told that it was based on allegations made by Ms. Lovely.
Yes.
And you testified that investigation was closed.
Yes.
When did that happen?
I think that was the 6th.
And how were you made aware of that?
I spoke to Amanda Moore, the investigator.
On February 6th or February 7th, you said you contacted a friend of the court.
Yeah.
Did you also file an ex parte motion and that motion was denied, correct?
Yes, because they authorized the other one that front of court.
But you filed a motion and that motion was denied.
Yes.
Okay.
An ex parte motion. What?
That was an ex parte motion to compel your parenting time, correct? Judge, I have no further questions.
I don't have any redirect.
All right, you may step down. Thank you. Any additional witnesses for the people?
I'm gonna call the trooper. And
Sir, please come forward and be sworn.
I am Trooper Dustin Peitzel, going to be spelled yes, it's P-I-T, Susan Charlie, yeah.
Why is that so hard, Mr. Emmons? And I just noticed that when you called him to the stand, you
Yeah.
Use the last name. You just used
I
his
am-
title. Okay, I'm just saying.
You're on to my
I was-
ways.
I was paying attention, but go ahead. You may inquire.
Thank you. Trooper Peitzel, thank you for being here today. I want to turn your attention. How long have you been employed with the Michigan State Police? Thank you. And were you employed in that capacity early February of 2023?
Yes.
Did you become involved in incident between a custody issue between Alante Lovely and Corey Johnston?
Yes.
Thank you. Who did you first, or how did you first get involved in this information? And again, I would respect it to the extent that you have to refer to the child, just refer to it as the child.
At first, I was dispatched to an assistant agency. I was for my dispatch notice, I was advised to contact Detective Buxton, I believe his name was.
Thank you. And I think that's Buxton.
That's correct. Township Police Department. I contacted him and he advised me of the dispute that we're here for today.
Okay. And we had some testimony earlier about their court order. As a result of that communication with the Detective Buxton, were you able to receive some kind of court order in some kind of way?
Yes, he forwarded the email to me, and I was able to review and see the court order as well.
Okay. After speaking to the detective, based on the information that he gave you, you have a telephone conversation with Johnston?
Yes.
Okay. Did you get some fine information from him?
A little bit more information, what Detective Buxton was able to provide.
Now you have the information from the Northfield Township Police, as well as from Mr. Johnston. What was your next step of your investigation to assist with this situation?
My next step was to make contact with Miss Lovely and I guess attempt to persuade her to comply with the court order.
Okay, and did you do that?
Yes, I did.
Where did you speak with Miss Lovely?
I spoke with her at her residence in South Line.
Okay. And for all intents and purposes, that's I think there's a small part of South Lyon that's in Washtenaw County, but her residence is in the Oakland part.
Correct, it is in Oakland.
Okay. And is the defendant, is that somebody who you see in the courtroom today?
Yes.
Just need you to point to her and tell us what she's wearing.
It's the female with a kind of white shirt with flowers on it.
Thank you.
More kind of beige.
And for the record, Your Honor, the witnesses identified the defendant.
And record shall so reflect without objection.
And thank you. Did you have a conversation with the defendant?
Yes, I did.
And did you talk about the court order?
I discussed it with her. We talked through it together, yes.
Okay, and what was her response in regards to you showing her this order that she's supposed to return the child?
She advised me that she would not return the child.
Okay. When she advised that she wasn't going to return the child, what did you do?
I told her I would be in contact with her within 24 hours. And to confirm whether she returned or not returned the child.
Okay. Did you inform her of maybe some of the consequences of not returning the child?
Yes, I did. I informed her that if she failed to return the child within 4 hours, that charges would be sent up against her.
Okay. Did she in some way show some kind of acknowledgement that she understood what you were saying?
Yes.
Okay. So then did you follow up with the parties at some point in time later?
Yes, on February 10th, I called Mr. Johnson again to confirm whether his son or whether the child had been and he advised me he had not been returned.
Okay. And so based on the information that you got from Mr. Johnson, did you then speak to Miss Lovely again?
Yes.
And what did Miss Lovely tell you about that?
Miss Lovely told me that she once again did not return the child and that she questioned the validity of the court document that I provided her.
Okay. When she questioned the validity of the court document, did you offer to do anything for her?
I did, yes.
Okay. And what was that?
I offered to, I believe that was a Friday night, courts were closed. I told her, hey, I'll go down to the 22nd Circuit Court as well and confirm that this is indeed a valid document. Prove to her that yes, this is a valid document.
Okay. And did you do that? Did you follow up with the 22nd Circuit Court?
Yes.
Okay. Did you get some kind of confirmation about the validity of the document?
Yes, I had spoken to one of the clerks, I believe her name was Miss Thompson, and she confirmed that that document was signed on the 7th by the judge's name is spacing right on my mind here, but
Judge O'Brien.
Judge O'Brien, thank you. And she confirmed that that was a valid document.
Okay. And did you then relay that information to Miss Lovely?
Yes, I did.
Okay. So you've now told her about it on the 7th, gave her to the 10th to comply, and then on the 13th tell her that it's a real court order. What was her response to you in regards to that information?
Once again, she told me she was refusing to return the child, and after a brief few words, she hung up on me.
Okay. Thank you. Your Honor, with that, I don't have any other questions for this witness.
Cross-examination.
Thank you, Judge. Trooper, in the 4.5 years that you've worked for the state police, is this a common thing, common part of your duties?
I'm sorry, what do you mean? As in,
I guess
are you
serving orders for child custody, is that a common part of your duties?
in my 4.5 years, this is the first time I've had to do it.
The only time you've ever had to do it is in this case.
Yes.
So it's unusual. And you indicated that you spoke, well, I guess let me circle back. You received the order from Detective Buxton, correct?
Yes.
And where did Detective Buxton get it from?
And he advised me that he received it from Mr. Johnson.
From Mr. Johnston.
Yeah.
So Detective Buxton didn't get it directly from the court either,
Unless he actually.
to your knowledge.
To my knowledge.
Okay. So you then told, as you indicated, you met with Ms. Lovely and you told her about the order, and she indicated that she had doubts about its authenticity, correct?
Yes.
And you testified already, but that she told you that a motion had to that effect had been denied, correct?
Yes.
Right. So she asked you to independently verify that that was accurate, and you agreed to do that.
Yes.
And you told her that you would do that.
Yes.
Okay. And then by the time you were able to do that was September 10th, correct? To verify the document was authentic.
The 13th, she didn't.
February, excuse me, February, not September.
She requested on the 10th for me to verify the document, not on the 7th.
Okay, so you agreed to do it on the 10th,
Correct.
and then you verified it on the 13th.
Correct. 10th was Friday night, courts were closed.
Right.
The 13th would have been the earliest. That was Monday morning.
So she had indicated, when did she indicate to you that she was concerned about the veracity of the document?
On the 10th.
She didn't tell you that on the 7th?
I do believe she probably did indicate it on the 7th.
Okay.
I don't recall.
Okay, so things she told you on the 7th, she certainly told you about the CPS investigation on the 7th.
Yes, she did.
Okay. Judge, if I could just have a moment.
And
Did you ever attempt to independently verify that that order had been entered prior to February 10th?
No.
You didn't look into Odyssey or any other system?
Yes, I did.
You did?
Yes.
Okay, what did you do?
It's not really a system I'm familiar with,
Mhm.
so I attempted to look through the online court system to see if any of that documentation or through the family court system,
Mhm.
to see if that order had been posted within it, and I did not see it in it.
And when did you do that?
I don't recall which date I did that.
Would you agree that it was somewhere between the 7th and the 10th?
Yes.
So you were, between the 7th and the 10th, you looked and you weren't able to see that that order was entered either?
Correct.
Nothing further, Judge. Thank you.
any redirect?
I just want to reiterate. Did she express some doubt over the veracity of it on 7th of February of the order that you presented to her?
Yes, she didn't think it was a good document.
Okay. And then she might have also expressed some doubt on it on the 10th.
Yes.
That caused you to follow up with the court on the 13th.
Yes.
Okay. Thank you. I don't have anything.
All right, thanks, Chairman.
Thank you.
You're all set. Any additional witnesses?
I don't have any other witnesses, Your Honor.
Any witnesses for the defense?
No, thank you, Your Honor.
All right,
Your Honor, at this point in time, I'd motion to find the defendant over on the charges contained within the information, the one count.
respond.
Your Honor, I would object. First of all, it seems to me that based on the testimony, this entirely occurred in South Lyon. So I'm not really sure that there's jurisdiction. This appears to have, the child was in Oakland County the entire time. So I think there may be a question as far as venue. However, on the facts of the case, the testimony is relatively clear from the trooper that he showed her this order on the 7th. She indicated to him that she didn't think it was accurate. They both, I think, he independently attempted to look in Odyssey, couldn't find the order. There was an order, a motion that was made and denied, which was testified to by Mr. Johnston. So at the very least, it makes it clear, I think, that there's confusion over what order would be entered or what order would be accurate if there was, this motion was already denied on one motion and then entered on another. Additionally, Your Honor, when the officer presents this to her and she indicates that she doesn't believe it's accurate, he agrees to look into it. Just a reasonable person would interpret that the officer is considering that possibility and is looking into it. If the officer is looking in to determine whether or not the document is accurate or true, it's reasonable for a person not to follow it until they're told that it is. She
Or
was,
that they go and determine that themselves.
and she hasn't testified that she attempted to do that yet. However, need to prove that she attempted to do that, and it wouldn't have done any good because the officer already indicated that order was not in the system yet.
Or that he couldn't find it.
Or that he couldn't find it. But it does take time for those orders to appear. She couldn't independently verify it. By the 10th, that's now her parenting time. She hasn't received verification from the officer yet, who's indicated he's going to look into it. He does. She gets verification on the 13th, but that order does not change, and the court indicated that order does not change her parenting time. Now she's into her week. So the child stays with her until the 17th, and then the child would go back to the child's father on the 17th, according to the parenting time agreement. That's obviously changed by the February 14th order, but that's not really what we appear to be discussing here. The issue seems to be this time period from the 7th to the 10th. Because the order that issued on the 14th said she had until the 24th to return the child, and the child was taken by the father on the 16th. So we never got to the violation of that particular order. So based on all of that, Judge, based on what the officer told her and what the officer did and how it would imply to her the possibility that this order is potentially untrue or invalid, he couldn't independently verify it. He couldn't tell her that it was accurate until her parenting time had started. I would ask the court to dismiss the charges in their entirety. If nothing else, perhaps it's the basis of a show cause that could have been handled in family court, but as far as a parental kidnapping, I don't think it rises to the level to criminal conduct when the officer himself agrees to take on the task of verifying the veracity of the document.
I would ask the court, I know the court's probably already aware of this. Anything that our arguments are not evidence, but anything that Mr. Overwater argued was that what she did, there was no testimony to that. So let's just focus on the evidence that we have. Take or retain for more than 24 hours the child with the intent to detain and conceal the child from the child's other parent. What do we have? On the 6th, CPS says that Mr. Johnson testified, CPS indicates that child custody is to resume as normal. At the 7th, he's supposed to pick the kid up from school. The child does not go to school that day. That prompts Mr. Johnson to then turn his investigation both to the police as well as friend of the court. He did this order. He talks with the trooper. Trooper turns around, talks to mom. At that point in time, mom is on notice. She says, I'm not returning the child. I don't believe that's real. Fast forward to the 10th. He tells her, you have 24 hours to do this, or you could be looking at charges. She rolls those dice. She says, well, I'm throwing in. The 10th, nothing changes. Custody has not changed. Mr. Johnson testifies he has not received his kid, his child in those intervening days. Trooper Pitzel goes back on the 10th, says, hey, what's the deal with this order? She says, I don't believe it's real. I'm not giving the kid back. He verifies it on the 13th at her request, verifies that it was in fact real. She says, I'm still not going to return the child. It is what it is. 24 hours she had to return the child or comply with the custody agreement. That order was entered on the 7th. She was made aware of it on the 7th. There's no testimony to suggest that there was anything else that was going on other than there was this order that she had to comply with, and she didn't comply with it between the 7th and the 10th. So for that, Your Honor, as the court knows, this is an order out of our circuit court that gives this court venue and jurisdiction. That's where the order arises out of. That's where the underlying custody agreement comes out of, this court, giving this court jurisdiction over this matter. Therefore, I would ask the court to bind the defendant over on the charges contained in the information.
There may be two bases for certainly venue and jurisdiction of this court. The one that's brought up by the prosecutor, so I can dispose of that. It's enforcing a Washtenaw County order. Also that the venue is stated on the complaint is Northfield Township. there's going to be the 1 mile, certainly, or any conduct that occurs within that. So the court does believe it has jurisdiction and the venue is proper here. As with respect to the elements of this offense and when it occurred, what a wonderful world we would have if defendants who were presented in order by a peace officer were able to say, I don't believe the order, and just not comply without doing their own checking, without doing their own, I guess, footwork on it. Certainly, officers may assist in that, but once presented with the order, it is the person who is subject to that order's obligation to follow it, check it, verify it, and make sure they're in compliance with it. This defendant didn't do that. She just said, I don't believe this order, and then left it to everybody else. What is also clear from the testimony is that the parental father knows that it's his time and he has that order. He follows all lawful means to obtain the order. The order gets served on the defendant. The defendant says she doesn't believe it. The trooper told her she had 24 hours to comply with the order. She didn't. The question then becomes, well, and that's going to be from the period really from the 8th, because of the 24-hour period, to the 10th, that she did not comply with the order. And that in and of itself constitutes that offense. I think it may be a question of fact for the jury as to what the February 17th order means in terms of it going back, because there are different interpretations. One interpretation of that order, on the face of that order, one interpretation is, if you've interfered with my custody, then I basically take your week. So I still do the off and on, but now the weeks are reversed. That's one way to interpret that order, because it's just week on, week off. The other way to interpret that order is we go back to the normal schedule. I don't know which way that order really reads on the face of it, but in either event, I mean, and that to me says that that's going to be a question of fact, because it may very well be that the defendant then interfered with what would become the child's father's week that would have previously been her week, because that week on didn't happen. So that's a reasonable interpretation in this court's mind, certainly, and having seen it before, of these orders. Under either analysis, and again, I'm here to decide whether or not there's probable cause to believe that a crime was committed, not as to whether or not she has complied with the order, nor to necessarily give an interpretation of that order. That's for other proceedings. Given all of that, the court does believe that the defendant has committed the offense of kidnapping, custodial interference, and that people have sustained their burden of showing that by probable cause, either, so that we're clear, either is to that period after being presented with the order and not complying within 24 hours, or in retaining the child if there were a switch of weeks for that following week. Under either one of those analyses, people have sustained their burden. And therefore, the defendant is bound over to stand trial on this charge.
I'll acknowledge receiving the information, Your Honor. I'll waive its formal reading, and my client will view this allegation.
Defendant, every way, formal reading, standing mute. Court will enter a not guilty plea. All right.
As a point of clarification, if I may.
Yes.
The court's recitation on the find over, the court referenced an order of February 17th.
I meant February 7th.
Okay. Perfect.
If I said 17th, I meant February 7th. All right. Court will indicate the defendant standing mute. Enter not guilty plea. Pretrial will be set for
October 16th at 1:30 PM with Judge Slay.
October 16th, 2023, 1:30 before Slay. Is that
That's a Monday.
that's a Slay Monday.
Your Honor, there is the violation. I don't know
Yes.
if you wanted to address that.
I do. So that we understand how we got here, that the court had ordered Miss Lovely on July 27th that there was to be no posting, commenting on social media regarding this circumstance, or particularly the child, or anything having to do with this. All social media that she had previously posted regarding this case was to be removed, and that the court was very specific that it included anything to do with the child directly or indirectly. That was on July 27th. We returned for a hearing August 17th. The people, I think, filed a motion or a request to an emergency motion on the 9th, I think it was, to revoke her bond. At that time, the court reviewed it. There was a partial hearing on that. Well, there wasn't really a hearing on that date when she came back on the 17th. Based upon what the court saw in the court's previous order, the court did indeed revoke the defendant's bond, remanded her to the Washington County Jail, have subsequently released her from the Washington County Jail, but had set a bond hearing to address the issues in this case, because there was a claim that the subsequent posts were not with reference to the case. And that's where we are.
And I believe that subsequent post was something about a stalker, and then she referenced that, or at least the indication was that was in reference to a landlord or some kind of landlord tenant dispute.
Correct.
That is my understanding as well.
Where was that landlord tenant dispute heard? And what was the name of the landlord?
Her name was Emily Knox. The landlord tenant dispute was at Water Edge Apartments.
Where was the case heard?
There was no landlord tenant case. We just had a eviction case coming from the property management. But there has been police report filed for different disputes. So previous property manager does not.
So there was no landlord tenant action that was filed?
Not through the courts. There was a police report. Police have been called. That's made and only from that associated with the exactly, and we found our eviction. We're part of the edge because of the situation with the old property manager. All right, and that's been taken care of.
It's my understanding that there was an actual court case, but within
That's what I had.
50 seconds.
Excuse me. The eviction case.
Right. That's Water's Edge Apartments versus Justin Hatchett and all occupants. So.
Who is Justin Hatchett?
I believe that's her
That's
significant other, fiance.
We're both on the lease. He just was named first.
So how does this relate to that?
There was an incident.
I'm sorry, Judge. How does what relate to that?
How does the stalker relate to that case? Because I'm a bit confused only because before she had told me there was a landlord tenant case. Then she told me today there isn't a court case, but now I find out that there is a court case, and I'm now trying to relate the language that she was using to that case.
Well, my client indicates, judges, that she was being harassed and stalked by the former property manager. What was the name?
Amberly Knott.
Amberly Knott. And that's the person to whom she was referring when she made that post. There is an email addressed to Ms. or it's to, purporting to be to Amberly. I don't know if that's been tendered, but.
I find it interesting. There was also this issue with the GoFundMe, right? And so the GoFundMe is the GoFundMe. I recognize it's been disabled. It has not been deleted. But in that language, when she's talking about what had happened, she says, still being harassed, stalked, manipulated, and talked about by my ex-husband. So she's referencing that same language that comes in, what was it? In that post from, I think, July 27th, which that apparently happens to coincide with one of our dates here.
Yes.
So it's just too convenient. And I find it too remote to refer to a stalker or a landlord as a stalking, because a landlord is a stationary kind of thing. It's the building. So it's just strange, and it seems too remote.
So Judge, the GoFundMe was early July. That was before, I believe, the court's order, is my understanding, when that was created, and it has been disabled. A person can have more than one person harassing them in their lives. So while she may have had, obviously there's a difficult relationship that she has with her ex-husband, that does not mean that she's not also having issues with this landlord property manager. Again, this isn't the owner, this is the person managing the properties who's there in the area, is driving around in a golf cart, is watching her, and has been harassing her. That is what she's reporting. I would ask the court, based on the vagueness of what that post was, to dismiss the bond violation. She's already spent, I believe, a week in jail as a result. And I've admonished her to stay off of social media in its entirety during the pendency of this case. And I don't believe there's any indication that there have been any issues since she was released from custody.
Well, let me just say this. I don't think the defendant believes any court's order. It distressed me, first of all, in coming back, that there was a violation of my order. Right? Then when I'm listening to testimony here, Judge O'Brien issues an order. She didn't want to follow it. She just doesn't believe that people are going to issue orders that may affect her, and that she can just decide to do things as she will. I hope her time in jail has sort of bemused her of that idea, especially when it comes to me. I think she's also going to run into a different type of animal I don't mean that in a bad way, but a different type of judge when it comes to Judge Slay. And I would almost just dare her to not follow Judge Slay's order to the letter. Because 7 days probably won't be long enough. What I'm going to do is I'm going to find that there's a violation, sentence the defendant to 7 days credit for the 7 she served. I'm also going to issue a new order, or as part of her order going up. And I think it's wise advice, Mr. Overwater, defendant is not to be on any social media. No use of social media. Ma'am, do you understand me? Thank you.
Thank you, Your Honor.
Otherwise, your bond will continue at this point.
Thank you, Your Honor.
Thank you, Your Honor.
All right, court is calling 2022 CR 7209, State of Texas versus Uriah David Huffman. Can I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense?
Carl Alexander for Mr. Huff.
And are you Mr. Huffman?
Yes, ma'am.
All right, you entered a plea of guilty on September 11th. You applied for deferred adjudication. According to the plea bargain agreement, punishment is to be assessed at a cap of 12 years in the prison. There are two cases that are being taken in consideration. There's an affirmative finding of deadly weapon, a $5,000 fine, and the state is opposing your application. And there is restitution to Joshua Sandoval and Ramon Lavario. Have both parties had a chance to review the PSI report?
Yes, Your Honor, the state has. Yes, Your Honor.
Any objections?
There's a few corrections, Judge, but I think we can handle most of that during testimony.
All right. State, do you have any witnesses?
The state.
All right, defense, do you have any witnesses?
Yes, Your Honor. Okay. I guess first I'll go ahead and take care of the Zoom witness called Candy Huffman.
All right, can you unmute yourself, please? All right, any objections to the witness appearing by Zoom, state,
No, Your Honor.
defense?
No.
All right, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth, and nothing but the truth, so help you God?
Yes, I do.
All right, you can lower your hand. State your name for the record, please.
Candy Joanne Huffman.
Defense.
Thank you, Your Honor. Ms. Huffman, although I think we can tell by your last name, how are you related to Uriah?
I'm his mother.
And how old is Uriah?
26. Oh God.
Have you not seen Uriah in a while?
No.
Where do you currently?
I also have lupus, and so memory and stuff is a little, I have to think about the math.
I got you. Okay. Where do you currently live at?
I live in Florida.
Can you be a little more specific, at least what county?
Orlando. I live in Orlando.
Uriah, he's originally from Texas, is that right?
Yes, he was born in Dallas.
And was there a father in his life?
No,
Has he ever known his father?
no, he's never met him. He left, rather I left him when his father, whenever I was 4 months pregnant.
Does your son have a drug problem?
He did. Yeah,
And you say he did, are you talking about the fact that he's been sober since he's been in jail for a year and a half?
yes, I suppose.
Okay, so prior to his arrest for the offenses that brings him here today, how bad would you say Uriah's drug use was?
I would say probably pretty bad. As far as what I was aware, he was always high.
Did he choose to be homeless in order to feed that addiction?
I think that I don't think he chose to be homeless in order to feed the addiction, to be honest. I think he chose to be homeless, and the addiction, or the drug use rather, was just part of it because of the people that he was around.
So during this time, the time that Uriah took part in hurting people, was he the same Uriah that you knew and raised?
No, no, absolutely not. Uriah was never violent. Even whenever I found out about what happened, I was shocked. He's not a violent person. He was never in fights at school growing up. He never at all. He wasn't violent at home. He didn't punch walls. He was never like that, ever.
Now, since his incarceration, have you had contact with him, either through
Yes.
phone, video visits?
Yes.
And have you seen Uriah change over the course of the last year and a half?
Yes, other than just being understandably sad and depressed and lonely, as you would be in the situation that he's in. I got my son back. He's became I could talk to him again. He could carry on and wanted to carry on a conversation with me. He was back to being my loving son again.
Now, if the judge grants Uriah deferred adjudication, okay, will he have a place to live?
Yes, he can live here with me.
So that would be in Florida.
Yes, sir.
And again, if he's granted deferred, there's probably going to be a lot of requirements of him, such as making appointments, being tested for substance abuse, probably doing some type of classes of community service.
Mm-hmm.
Will you aid him in making sure he's complying with all of the requirements?
Absolutely. Yes. I work from home. Well, I am starting a home business. I'm an artist, so it's just crafting, but so I'm free to do that.
Will you help Uriah in getting employment?
Yes, absolutely.
Does he actually have a job waiting for him in Florida if he is granted probation?
Yes. My husband had spoken to but he told me, now this was a while back, that he sorry, my hand is cramping, that he could have an entry level position with my husband.
And what would he be doing?
Just computer work. I'm not really sure exactly what it is, but it would be just stuff on the computer. Other than that, if that isn't still available, because he hasn't talked to his boss about it recently, then I would do whatever I needed to do to help him find a job. That would definitely be a priority.
And again, if Uriah is granted deferred adjudication, he's very likely going to have to make restitution to the victims of his cases. Would you help him make sure that he stays employed and he's making good on that debt?
I would do whatever I needed to do to help him do what he needed to do. Yes. My husband and I would, my mother and father would. I've already talked to them about it as well. My mother and stepfather also live here. That's why I moved here. And they're also supportive. So
that's a support structure that Uriah has there in Florida. Did he have all that here before when he chose to get lost in drugs?
He's always had me, but no, not really. Other than me, no.
But so now it's a bigger support structure waiting for him.
Yes, I would say so. But he also he won't know anybody here, like nobody from, anybody that he used to run with or know on the streets or anything. Like, he won't know anybody here. So it would be a complete fresh start, and as far as that goes, I think that would be a great help as well. And that's just my opinion, but yeah.
All right, Ms. Huffman, thank you for your time. I'll pass the witness.
I'm sorry, state.
Thank you. Ms. Huffman, I'm Jason Garahan. I'm a prosecutor for the state of Texas.
Yes, sir. Hi.
Hi, nice to see you on Zoom here. I got the indication that you're, when Mr. Alexander was asking you some questions, that, tell me if I'm wrong, but Uriah's violence towards other people was sort of a drug induced. Is that what you feel?
Yes, I think that it was drug induced, and that and because of who he was with, more than anything.
I mean, you are aware that there's a evaluation, what we call a precedence investigation, where your son stated that he denied consuming alcohol or drugs during the commitment of this offense of aggravated assault on an individual. Are you aware of that?
No, I'm not, but I know how methamphetamines work, and I know my son, and he wasn't the same person at that time.
Were you there?
Mentally?
Sorry.
No, I wasn't. I obviously wasn't there, but I talked to him often. Well, sometimes I went and talked to him for a month or two, but I mean, I talked to him that day, the day that he got arrested, and I could hear it in his voice.
Did you know that if he actually didn't get arrested on the day of the offense?
No, well, no.
In his precedence investigation, he said he did meth after the offense happened in the days following. You're not aware of that, are you?
No.
And are you aware of the victim's injuries in this case?
The victim's what?
Injuries.
Yes.
So you're aware that he lost an eye?
Yes.
His skull was crushed in?
Yes.
And that he was shot at more than once?
Not by my son. I'm sorry. It doesn't matter. Yes, I am. And it's a terrible thing. And I'm glad that he is alive.
You're also aware he was stabbed? Is that correct?
No, I wasn't aware of that part, but I mean, it doesn't make it any better or worse. It's all bad.
You realize also that he was hogtied with his arms
Yes.
and his behind him?
Yes.
And put it in his own trunk of his own car.
Mm-hmm.
And driven around and then dumped on the side of the road without many articles of his clothing, pretty much naked. Are you aware of that?
Yes.
Your son told you this?
No.
Okay, no further questions, John.
All right, any further questions? All right, you can call your next witness. All right, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand if you'll state your name for the record, please.
Uriah David Huffman.
All right, make sure you keep your voice up.
Yes, ma'am.
All right, defense.
Thank you, Your Honor. All right, Uriah, you had a chance to go over this PSI. I'll just start there. Right.
All right, you're gonna have to answer yes or no.
Yes, sir.
Okay. And I believe you said there's a couple things you wanted to cover.
Yes, sir.
Okay. So let's just cut right to the chase about what happened to Joshua. He was here to go. Right.
Yes, sir.
The PSI talks about you actually tying him up. Did you tell the probation officer you actually tied him up?
Probation officer?
that interviewed you for this? Did you tell them that you tied him up?
I don't believe so.
Okay. So as far as the tying up is concerned, because he was tied up, right?
Yes, sir.
Okay, how did you participate? What was your active role?
I just got the rope. Okay. And I handed it to DK, or to Daryl, sorry.
I'm sorry, could you speak up?
I got the rope and I handed it to Daryl.
Okay.
And that's your co-defendant in this case, who I believe you referred to as DK.
Yes, sir.
The PSI also talks about you putting Josh in the trunk of his
Yeah.
car.
Yes, sir.
Did you do that?
No, sir.
Did you tell probation you did that?
No, sir.
Did you drive his car away with him in it?
Yes, sir.
The PSI also talks about when you guys went and stopped somewhere in Atkins, and it makes it sound like you took part in the shooting, like that you actively shot Joshua. Did you tell probation that?
No, sir. I mean, I told them that I was there, yes, but I never touched the gun. I never did anything like that.
Did you assist in removing Joshua from his trunk so that he could be shot?
I don't believe so, no.
Did you have a gun?
No, sir.
So are you the one that shot Joshua?
No, sir.
Who did shoot Joshua?
Daryl shot Joshua.
Now, you're not saying that you didn't participate in what happened to Joshua, are you?
No, I'm not saying that.
And I believe what's actually in the stipulated evidence is earlier that day, Joshua had actually hit you in the face with a guitar. Is that right?
Yes, sir.
And so you made DK aware of this?
And whenever DK pulled up to the trailer, he asked me why I was bleeding, and I told him that Joshua hit me with a guitar.
Okay. Did you ask DK to do anything to Joshua?
No, sir. He walked in and started doing that on his own.
Okay. But once DK started doing things to Joshua, you made a choice, right?
Yes, sir.
You chose to go get the rope.
Yes, sir.
You chose to drive the car.
Yes, sir.
And you chose to plead guilty as opposed to no contest, right?
Yes, sir.
So probably the biggest question in the back of the judge's mind is, based on everything that happened to Joshua, okay, and what you did participate in,
Yes, sir.
why in the world should she give you probation and not just send you to prison?
Because I understand that it was wrong in not calling the cops and participating in any of it. And I believe that I can prove that that's not who I am, and that I'll be able to complete probation and pay back any kind of restitution that goes to them, to Joshua.
Are you sorry for?
Yes, of
What
course.
happened?
I'm sorry that all of it happened to him. He didn't deserve it, and I'm sorry to his family.
Well, they're right there. So you think maybe you should tell him and not us?
Of course, I'm very sorry that all of it happened to Joshua. If I could go back, I would have called the cops. I would have tried my best to convince DK not to do it. I'm very sorry.
You had an evaluation about your drug usage.
Yes, sir.
And I think it says in there you were using meth daily. Is that accurate?
Yes, sir.
Okay. DK wasn't just your friend, right?
What do you mean?
DK was selling meth.
Yes, sir. He was, yeah.
Okay. And all the people you were associating with at the time, including Josh, you guys were all meth users, is that right?
Yes, sir.
Again, if the judge takes a chance on you, that's a hard thing to shake. It was recommended that if you're granted probation, that you do inpatient therapy.
Yes, sir.
Excuse me, rehab. Are you willing to do that and do what it takes?
Yes, sir.
No matter, because there's several programs a judge could choose from, some of which could take up to a year before you're ever released.
Mhm.
Are you willing to do that?
Yes, sir.
Are you asking the judge for a second chance despite your choices?
Yes, sir.
Tell her that, not me.
Yes, ma'am. I would. I hope that you'll give me the chance and opportunity to prove that, or to give me a probation and even the drug rehab program.
I'll pass the minister.
State.
Yes, Your Honor. Mr. Huffman, you said you didn't actually actively shoot. Mr. Penwell, right?
Yes, sir.
And you actively, I guess, grabbed a rope, handed it over to DK, which is Daryl King, right?
Yes, sir.
Daryl King is the one that shot Josh, is that right?
Yes, sir.
Who stabbed him?
I'm not aware.
You're not aware? You didn't have a knife?
No, sir.
You didn't have a knife.
No, sir.
And so the stab wounds, you don't know how that happened?
I'm aware that he got stabbed, but I don't
So who
know how.
stabbed him?
All right, I'm gonna need you to speak up.
I'm aware that he got stabbed, but I'm not aware of who stabbed him.
Was there anybody else?
Mm, Was there anybody else that could have stabbed him?
Mhm.
Yes.
Who?
I don't know his name. It was just a guy.
So you don't have the guy's name.
No, sir.
So this random guy that you don't know his name stabbed Josh. Is that what you're saying?
No.
So who
I'm
stabbed him?
saying that there was another guy that could have done it.
Could have done it. So you could have done it.
No, that's not what I'm saying. You asked me if there was anybody else.
Okay.
Yes, there was.
You were there.
Yes, sir.
You were there when he got put in the trunk.
Yes, sir.
You were there when he got tied up.
Yes, sir.
You're the one that drove the vehicle around, right? In a hot trunk. And you knew that this individual had been stabbed, beaten, and tied up.
No, at the time, I did not know.
You didn't know he
found
had
out-
been beaten?
No, that he'd been stabbed. I didn't find that out until I was already in jail.
Oh, so you didn't witness any stab wounds. You didn't see him bleeding before he got shot?
No, sir.
He wasn't bleeding before y'all shot him on the side of the road.
I didn't shoot him.
I know, I said y'all, law parties in the state of Texas, if you're standing there, you're participating, and that doesn't mean you pulled the trigger, but you were there, right?
Yes.
And
Yes,
you
sir.
left with DK, right?
Yes, sir.
Was he bleeding before before you all shot him? Let's just say DK, I'm not gonna split peas with you. DK shoots him, you're standing next to DK. Was he bleeding before he was shot?
Yes,
Why was he bleeding?
yes, I assume he would. I can't tell you why he was bleeding. I'm sure
can't?
he got stabbed, but I don't know who stabbed him.
Did you hit him?
No,
You never hit Josh,
no, sir.
ever.
No, sir.
So DK did everything.
Yes, sir.
So DK stabbed him.
Okay, well, I don't know. I can't say for sure if TK stabbed him.
Okay. So he was bleeding before he was shot, right?
Yes, I mean, I
Hey,
believe I saw.
You were sober, you weren't doing drugs, you weren't drinking. Right? That's what you told everybody in this packet. You weren't drinking and you weren't on meth the day this happened. You said it twice. So you were sober when this happened. Right?
That is what that says, but I've already tried to tell my lawyer that I was using at that time.
At that time, were you using that day or not?
Yes,
So now that's something else that needs to be changed in this packet.
I thought that's what he said. I'm trying to.
I
make
don't
it
know,
clear
I'm
to
asking
him.
you.
Yes, that I was using drugs that day.
So these two items that say right here, it says defendant denied consuming alcohol and using drugs on the date of the instant offense. That means that offense that happened that we were just talking about. That's wrong.
I mean, yes, I did use drugs that day.
Okay. Before or after you all shot him?
So,
Sorry, I
Both?
can't hear you, sir.
both.
So you're using drugs before and after Josh was shot,
I had used drugs before. Yes, and
that day.
yes, that day. Yes, sir.
And then also right here, it says right here, I wasn't consuming alcohol or using drugs.
Yes, that's well, my attorney went through with me, and I told him that was wrong.
Okay, so now that part is wrong also. That you
Yes.
were using alcohol and drugs.
Not alcohol, but drugs. Yes.
Okay, all right. So you deny, well, okay, you do remember him being tied up, right? What you call hog tied, right?
Yes, sir.
And he didn't have his clothes on, right?
Yes, sir.
Why didn't he have his clothes on?
Because they got taken off.
Who took them off?
DK.
And you just stood there?
Yes, sir.
Was he hog tied at the time that the clothes were being taken off or not?
Yes, I believe so.
He was. And then when was he shot?
He was shot behind the car.
Behind the car, when he was on the ground,
Yes, sir.
bleeding, already been cut,
It was
already
dark.
been stabbed.
Yes.
Tell me this. What do you think had happened to him after he got shot?
He laid on the side of the road.
Well, did you think he died?
Yes, sir.
Okay, so this is one step away from a murder, isn't it?
Yes, sir.
So why do you deserve deferred adjudication on this case? Tell the court that. Why do you deserve it? Because you almost committed murder. You see the man right there with his face bashed in and he has his left eye's not there anymore? Why do you deserve deferred for that?
Can't honestly say that I don't.
Thank
Or
you.
that I do.
Thank you. No further questions.
Defense, any other questions?
And I apologize, right? I did forget to ask you, we discussed it before, so. Did you want to clarify with the court, you were using drugs that day, right?
Yes.
But you weren't drinking?
No, I was not drinking.
You knew what was going on, Joshua, right? As the events are unfolding, you know what's going on.
Yes, sir.
You could have done something, right?
Yes, sir.
Why didn't you?
I wasn't in the right state of mind. I just been hit with a guitar. So I wasn't thinking clearly. GK, he told me to get the rope. He told me to do this, and I chose to listen to him. Whenever I should have told him that, no.
What gave DK so much power over you that you
It's not that he had
listened to him?
It's not that he had power. It's just that I don't know. He's a very intimidating person, and
Is DK a little man or a big man?
you know he's a big dude.
Did you ever know DK to be violent?
He always got what he wanted. Yes.
When DK was the one holding the gun?
Yes, sir.
Yeah, we need to make it clear that you understand. Okay. Even though you're saying you're not the one that shot Joshua. You're unclear who stabbed him. You helped, and the law says you're just as guilty.
Yes, sir.
You get that?
Yes, sir.
Okay. Despite that, are you asking the court for a chance to prove that you can change and you can be a productive member of society?
Yes, sir.
Thank you, Rep. That's fine.
No question.
All right, any other witnesses?
No, ma'am.
Any other witnesses from the state?
Nothing to say, John.
All right, with regards to the restitution amount, is there agreed upon restitution or no?
No, Judge. And if I can address that, we've been provided nothing as far as what these amounts come from. And so I believe, despite if there's proof that we provided, he owes it, he owes it. I mean, that's, but I think we need to have a restitution hearing on that. When it comes to the victim in the instant case, Mr. Lavario, who is the complainant in the UMV case that's being TIC'd. Again, it's a very big number he's alleging with no proof. I will also point out that in the discovery given to us by the state, Uriah is found in this gentleman's stolen pickup, and there are no tools there. He's not found with them or anything. There's also some conflicting statements that he gave, so I would require a restitution hearing on that one as well. But again, whatever he owes, that proof's provided, he owes.
All right, this is what the court will do. The court is going to deny your application, find you guilty, sentence you to 12 years in the prison, give you credit for any time served. There's a $5,000 fine, time and money will run concurrent. Take in consideration 2022 CR 7208, 2022 CR 7210. I can order the therapeutic community. It'll be up to them whether or not they place you in the therapeutic community. I absolutely have no jurisdiction over that. So if you would like, I could put that in the order.
Yes, ma'am.
There's an affirmative finding of deadly weapon. There's to be restitution, if any, and no contact with Joshua Sandoval and Ramon Lavario. Going to show you what's inside title trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. I know that 12 years is a lot of time. Honestly, anytime you do, whether it's at the Bear County Jail or wherever it's at the prison, that's a lot of time. But I did internalize everything that was said. I listened to all of the witnesses. If you have a drug or alcohol problem, you need to use this time away to get your life in order, to concentrate on what improvements you want to make so you don't be back here. The complainant in this case has permanent injuries, and those injuries will never go away. You can go to jail, do your time, get your life in order. You can even get a college degree at the jail. And I could be wrong, but I don't even think they have to pay for the degree. So you can get a free degree at the jail and work on yourself, figure out how you got in this situation and not put yourself in this situation again. Do you understand?
Yes, ma'am.
All right. Is there a victim impact?
No, Your Honor.
All right. Good luck to you.
Thank you, ma'am.
Yes.
That's your notice for your next. Court calls case People versus III.The.
Nimesh Ganatra, Senior Assistant Prosecuting Attorney for the People.
Hello, Tariq Samar, Tariq Day here.
Already, Judge Torshio Fleecer, Assistant Public Defender on behalf of Mr. Day.
He's there. Can you turn on your camera, sir?
I don't have any contract with a public defender's office.
You what?
I don't have any contract with the public defender's office representing me.
You don't have a contract with them?
Correct.
Yes, Judge. I reached out to Mr. Day to try to help pre-try this case.
Is this going to be a Bellinger's thing?
I think so, Judge.
Okay, go for it.
My understanding is that he had enough counsel that he's going to have, I believe, on his file. And I wish him good luck if that's the case, but I don't see another attorney here, so I don't know what's going on, Your Honor.
No,
Mr.
Day?
I'm defending myself. I told him that I would notify the court that I relieved him of any implied obligations to this case.
So you're going to represent yourself?
I'm defending myself, correct.
Okay, then you need to be here. Now.
Well, as I told the court, I requested a Zoom hearing because I have COVID. So there's no way I can.
In a vehicle with a hat on, no mask. Oh,
I am inside my vehicle right now.
What'd you say?
I said yes, because I'm inside my vehicle right now. I work outside. I'm away from the general public.
Did you go to the hospital regarding the COVID diagnosis?
Excuse me?
Have you been to the doctor regarding the COVID diagnosis?
It's against my religion.
Okay, so here's what you're going to do. Then I'm going to say, okay, you've got COVID. I want you here. When's our last block? 3 o'clock today. Wear a mask if you're going to represent yourself.
I can't make that. Is there a later date?
Oh, yeah, you can. 3 o'clock.
3:30, I can make that.
I'll be here at 3 o'clock.
Well, I'll be there at 3:30, and if there's any issue, then
okay. And at 3 o'clock, I may issue a bench warrant. Be here at 3 o'clock. I'll pass this matter. Thank you.
There's no bench warrant to be issued because this court didn't have.
Okay, I'll determine that at 3 o'clock.
The court
See
didn't
you at
have.
3 o'clock. Thank you.
This court does not have jurisdiction.
You're welcome, Mr. Feaster. Cut his line. Folks, why don't we do this? Give me about 3 minutes. I'm going to take a recess, then I'm going to come back because everything's going downhill, and it's those two guys' fault talking to each other. Orders in recess.
All rise.
May be seated. Let's call the case, People State of Michigan versus III.The.
In Michigan, Senior Assistant Prosecuting Attorney for the people.
What's your name?
Tariq Samar Tariq, the executive of the Tariq Samar Tariq Living Trust. Lad, owner, Tariq Wilson Estate.
Sir, you indicated that you wish to represent yourself on this matter?
Yes.
All right, you understand at your arraignment, you were given the charges that were filed, have been filed against you?
I was given a charge. So if there were any additional, I was not given those charges. The only charge I got was a fleeing and eluding,
fleeing and eluding third degree.
Third degree, correct. And if anything else was tallied onto that, then I was not told.
Okay. I have one charge.
Okay.
That is a felony punishable by up to 5 years incarceration and $1,000 fine plus court costs. The Secretary of State would be required upon your conviction to suspend your license for a period of 1 year. You understand that, sir?
I do, but I have some questions.
Well, as soon as I get through this, you have indicated that you wish to represent yourself. I have to advise you that there are some dangers in you representing yourself. You understand that, sir?
I do comprehend.
And you understand that if you proceed to represent yourself, that the court is not going to assist you to understand the procedures or anything regarding the court proceeding, that you will be responsible for that, and I will be holding you to the same standard that I would be holding the attorneys in the room in terms of even ruling on evidence or anything along those lines in regard to the procedure and the process. You understand that, sir?
Correct, I comprehend.
All right. You also, so I will ask you again, do you still continue to wish to represent yourself in this matter?
Yes, I will be defending myself.
You understand also, sir, that should you change your mind and could not afford to hire an attorney and wish to be represented by an attorney, the court would consider making sure that you are afforded counsel. You understand that?
I comprehend.
How do you wish to proceed on this matter, sir?
First, I want to like an oral motion for dismissal based on the fact of the lack of probable cause and also the lack of personal and subject matter jurisdiction based on the fact that this is a trust matter from the name to the private conveyance that was stolen by the third party Wall Street Towing and impounded on the colorful law actions of Officer Trowbridge of the Washtenaw County Sheriff's Department. Also, I have not been able to, as of Constitution Amendment 6, being able to face my accuser, with the state of Michigan being a fictitious entity and there's no injured party, there's no crime that has been committed. And again, to the probable cause of the initial stop and the arrest, cannot be proven. There was no probable cause for the arrest or stop. There was no warrant on hand for the arresting officer to conduct an arrest. And even more so, again, as I stated, this is trust property, so this court doesn't have jurisdiction to adjudicate over the foreign trust.
Done. Finished?
Oh, no, actually, I was also moving to place you and the clerk as fiduciaries over the trust. And I'll be able to supply you all with the adequate assurance certificate of security to settle and offset the charges.
Okay. Well, you will be doing nothing to me and nothing to my clerk. So whatever that motion was, that's denied. As to your other motion regarding all of that, quite frankly, it doesn't make any sense. We haven't even had the probable cause hearing. There will be a determination at the next stage as to whether or not there's probable cause regarding the charges.
I was told this was a probable cause hearing.
This is a probable cause hearing.
So I don't understand what you're saying.
I know you don't understand.
They're not having a probable cause.
Pardon?
You said that no probable cause was had, but then you said that this is a probable cause hearing.
You have not had your preliminary examination, at which there will be a determination as to whether or not there's probable cause to believe that the crime has been committed and you committed it. That is the next stage. That has not happened. So to the extent that your motion is even valid, which I do not believe that it is, and certainly you may raise it at a later date, but to the extent that it's valid, at least at this point, your motion is premature, and therefore your motion is denied. Anything else?
Well, lastly, I want to also put on the record, I wasn't able to provide all my exhibits based on, as I told you, I was.
You weren't able to do what?
Provide my exhibits.
To whom?
To the court to help for my defense, the evidences.
You haven't had a hearing yet.
I comprehend it. I'm just saying that I usually have my documents precede me before any hearings take place, and I wasn't able to because I was under the weather. That was my point. So they will be here, if not by the end of the day in the drop-off box, and you'll have them tomorrow. But you all will be served with the proper documents, and the taxes as well will be filed on the case.
Okay. Anything else?
No, not at this time.
All right. So how would you like to proceed next on this?
Entering a plea of demurrer.
Okay, you've already done that.
I've already entered a plea of demurrer. I'm not sure when that took place other than right now.
That took place on the arraignment on the complaint, sir.
I never pleaded demurrer. There was
You stood mute, you stood demure. You don't even know what that means. You're just using words and have no concept as to what they mean.
Demurrer and mute are two separate things, but that's neither here nor there.
No, they're not. You have no legal degree. They are not. They are not. They are not.
I'm not here.
They are virtually the same thing. So where do you wish to proceed now?
As I stated, my motion.
Do you wish this set for preliminary examination? Your motions have been denied.
I wish for the prosecution to provide the evidence that any of this needs.
You don't have discovery on this case. Is that what you're asking?
I'm not asking for discovery whatsoever.
So what are you asking for?
I stated that the prosecution needs to prove that a crime was committed, and under they also need to show and prove that there is an injured party for the crime to have even been committed.
As I've indicated, you will have that hearing. Do you wish to have discovery?
Discovery should be provided regardless. There's no wish about it.
Do you wish to have discovery?
Should be provided.
Don't play word games with me.
I'm not playing.
Mr. Allen.
Discovery.
Not play word games with me. You're playing with the wrong judge. You can smile and smirk all you want.
I'm not trying.
I'm giving you your warning. I will ask you again. Do you wish to have discovery provided to you?
Yes.
Do we have copies of discovery available that can be provided to this defendant?
No, Your Honor, I know that the PD was representing this individual. I don't have copies right now.
I got you. Okay. So are there copies of the police report as well as other discovery that's in the hands of the public defender's office?
I do see traffic stops and discovery videos onto our program.
All right. All right. Those need to be gotten to the defendant How soon can those be gotten to the defendant?
I can get those in hopefully by tomorrow around.
You have an address for him to send those to him?
Yes, I do. I can confirm it with him too.
All right. What do you have as the address? Do you have an address on, is it share?
I do, Your Honor.
Okay.
114
Okay, gotcha. All right, you'll make sure that that is sent to him.
I will.
You also have an email address so that all things can be emailed to him also.
I do, Your Honor.
All right. Very good. Sir, did you wish to then have another PCC or did you wish to proceed immediately to preliminary examination?
I would like to first have a jurisdiction hearing,
What kind of jurisdiction here?
personal and subject matter.
Okay. Go ahead and raise it because I can deal with it right now. What's the personal jurisdiction?
This court, as well as the state, lacks personal jurisdiction. I'm simply here under threatened arrest or coercion of you, saying that you would help put out a bench warrant for my arrest. The subject matter in regards to the name as well as the vessel that was used is again under it was conveyed and is held and protected within the trust. And according to Article 1, Section 10, Clause 2 of the United States Constitution, there could be no legislative laws that could intercede or to interrupt the functioning of a contract, which the trust is and is properly properly functioning at this time. So with that.
All right, so here's what we'll do because you're rambling again. So what we will do is you will put all of your jurisdictional arguments in writing because you're wrong. So we might as well get it in writing that you're wrong. Because I have subject matter jurisdiction over you and I have personal jurisdiction over you under the Constitution of the United States and the Constitution of the State of Michigan. So if you want to put your objections to jurisdiction in writing, you may do so, and then I will address those in due course.
Awesome. So that would be the next step. And I can get those in today.
No, that is not the next step. Either you're going to have another PCC. If you want me to set it for a hearing, I'll set it for a hearing.
Yeah, for the jurisdiction.
But I have nothing to set a hearing on. You have not filed anything regarding jurisdiction.
Okay, so for right now, as of this moment, PCC is fine. And then I will file the proper documents for the jurisdictional hearing. Gotcha.
So I'll adjourn the probable cause conference in this case, April 25th, 2024 at 3 p.m.
Is it possible to get another week for
person
to provide to accumulate my documents for my defense?
Is there what?
Is it possible to have that extended out another week so that I can provide my?
I'm going to set it 25th.
I mean, I was on the call. I've heard you give multiple councils extended times. So what is the bias?
I have no bias against you, sir.
Well, I'm simply asking for
I'm
a reasonable
setting the date of 2 weeks out. You can have your motion together, file your motion. I will be able to address your motion at that time so that we can get this headed to a PCC, to a preliminary examination.
Just for the record, I'll put it on the record that I object, but under threat, duress, or coercion, again.
Your objection is noted.
Right, and under threat and duress and coercion, I'll be here.
Is there anything else?
I said what I need to say.
Anything else from the people?
No, Your Honor. Thank you.
Bond will continue.
Am I waiting for paperwork or get it from the front? Pardon? Am I waiting for paperwork regarding the next?
No, you may leave.
Oh, is it being mailed, or I'm trying to figure out how do I get the paper?
You can check out at the front counter.
Okay, thank you. That's right.
Court calls the case, People versus Chloe Whitsett.
Edward Drukas on behalf of Chloe Whitsett, who is approaching, Your Honor.
I'm sorry, Your Honor, I'm dismissing my court-appointed attorney and representing myself.
Okay, so start with this. What's your name?
Chloe Whitsett.
Okay. And you're intending upon representing yourself in this matter?
At this time, yes, Your Honor, I am. I am dismissing the court-appointed attorney at this time, yes.
Okay, what's going on?
Until my family and I decide what law firm we are going to choose, I will be representing myself.
Okay, all right. So you need time to seek a attorney?
Well, not really, but I have a request at this time as I am representing myself.
Well, not until such time as I relieve Mr. Drukas.
Okay, thank you.
What I'm trying, I have not done so.
Okay.
So I'm trying to figure out what the issue is and what you're intending upon doing.
Dismissing the court-appointed attorney and representing myself.
Okay.
I'm sorry, at this time, I can't make it any clearer, and I don't
No,
understand.
You're not making it very clear to me at all. Because
Okay,
you're not listening.
I'm
you're just
confused.
talking. Are you going to hire an attorney?
Yes.
Or are you going to represent yourself?
Today, Your Honor, I'm going to represent myself. If my request is denied by you, then I will be hiring an attorney. I can't make it any clearer than that.
So you're gonna, so if I relieve Mr. Drukas, you're going to represent yourself.
Yes, sir.
So if they set it for a preliminary examination, you're ready to go?
This is I'm representing myself today. I don't know what all happens today, but I'm talking to the judge without the court-appointed attorney.
No.
Okay, well, I don't.
Don't listen. You don't you dare just lean on my podium and pretend like that. Not here. Okay, here's what I'm gonna do. I'm gonna pass the matter because if you come back up and start banging your nails on that podium, you're gonna be going with Mr. Allen. You may have a seat. Don't shake your head at me. Oh. Mr. Allen, might want to have a conversation with her and tell her that she better check herself before she comes back up here. Thank you, Mr. Drukas. Okay, so who wants to go next? Christian Philippe. Recalls the case, People versus Whitsett.
And Edward Drukas on behalf of Chloe Whitsett.
Your name?
Lucinda.
Apologies on behalf of my client for earlier. I did have an opportunity to speak with her during that break and go over the process of where we are, what's going on right now. She did tell me that she would like to obtain a new attorney. So in the meantime, I can assist her with getting a copy of the discovery, getting a copy of the videos, which I don't have yet. I was going to be asking for an adjournment today to obtain those. So ultimately, I'd be asking for at least a 2-week adjournment. And I talked to her about her behavior in court, and I think that she has an understanding of that and will abide by anything the court orders her to do. So with that, I'd be asking for an adjournment of today's hearing.
Is all of that correct, Ms. Whitsett?
Your Honor, I would like to apologize. I had complete zero understanding, but yes, that is correct.
What's up? Let me tell you something. I should have locked you up. You're lucky that I just took a deep breath and said, I don't know what's going on. I'm just asking her questions. And you come in here, I don't think we've ever seen each other. And you just come in here disrespecting me in this court. And I'm going to tell you something else. That man standing beside you right now, it's the only thing that saved you from going to jail. I had pretty much made up my mind that when I came back out here because of what you had done, you were gone. So while you may not want him representing you, he just saved you. But remember one other thing. Funny thing about judges, we have exceedingly long memories. You come in here acting like that on the next day, I'm not even going to ask any questions. You are just going to go. Are we clear?
Yes, Your Honor.
April 11th, 2024, 9 a.m. as your invite indicates. It's time the defendant's bond will continue.
Thank you. Again, I do apologize.
Kent Williams versus Lamia Grisham.
Yes, Kent Williams here, Your Honor.
Yes, Lamia Gresham is here.
Amaya, I'm sorry. I put the wrong place. My apologies. All right. Claim of 1,400 last week is
Correct.
owing. Grisham, do you dispute that?
Yes, I do. I don't believe that I owe $1,400, but I have no problem starting to pay rent this month.
So what's the 1,400 for?
I'm pretty sure my dad restarted his agreement that me and him had this year for rent, and I think he's been doing it since January. So January, February, he's counting that I didn't pay rent. But I had told my dad that I wasn't going to pay rent, and he's actually brought this up to me 2 years ago, and I've been able to live here with no problems, and this has never been such a big concern like then. But starting now, I can pay with no issues. So.
Okay, hold on. This is your daughter?
Yes, Your Honor. The disagreement occurred at the beginning of the year, and we discussed that when she was not going to school nor choosing to do much productive, that both her mother and I had talked to her and discussed and said that she would need to pay rent as part of, her ability to stay at our house. And so she said she refused to do so. We've tried to work through this and talk through it. And we came to a point where I said, look, you either need to pay rent or you need to move out. And she said, well, you cannot legally put me out. So this is how we ended up here, Your Honor. Would I have preferred it to be this way? No. But this was what she said, and therefore we are here at this point.
I would like the Your Honor.
Yeah, go for it.
Actually, this occurred when I graduated from my senior year. My dad had put an offer on the table saying that I would have to pay rent if I didn't and I didn't get a job. At the time, I didn't know what I wanted to do with my life, so I wasn't ready to go back to school and I didn't have a job. But I did get a job at Roy's and I did make about 3 payments to them. And I was like, I can't afford rent. Like, I'm not paying it anymore. So I like told them I wasn't going to be able to pay rent anymore. And it was fine. Didn't hear any issues, nothing. And then at the beginning of this year, he did bring it back up. But I was like, I don't really think I need to pay rent. Like, I don't get the point of it. So I didn't pay it. He didn't mention anything until May. He texted me. He was like, you're at $500. And I was like, okay. Like, I told him I wasn't going to pay it, but like, that was the end of the conversation. Nothing else. Hasn't mentioned anything. And then recently, me and him had gotten into an argument and he said that I owed him this amount of money. And I was like, I'm not paying that, Dad. Like, I'm sorry. You can take me to court. Like, I don't know what to tell you.
Thanks for that offer.
So then he like gave me this piece of paper saying that it was from the court and it wasn't from the court. And then the following week, I actually got the real paper and then it became a big thing. But like, I have no problem paying rent now. But before it wasn't a big thing until I told my dad to take me to court.
He called your bluff, didn't he?
Yes, he did.
Young lady, did you understand why your dad wanted you to pay rent?
Yes, I do. Me and my dad have talked about it multiple times. Multiple.
And you just don't want to listen to him?
I told him I didn't feel that I didn't like want to pay. Well, the conversation changed from me having to pay rent.
Hold on a second. How old are you?
Me, I'm 19.
You're 19.
Yes.
So this has been going on for about a year?
2 years.
So this $1,400 is from the period after you were 18?
This $1,400 started this year. So since January, I believe.
Correct.
Okay. And how old were you in January?
I believe 19.
18. She just turned 19 in April.
So from that time, why do you think you shouldn't pay rent?
At the time, I did make about 3 payments and I couldn't afford it. Like, I was working at a restaurant. I couldn't afford it. Like, I wasn't going to school, but I was trying to figure out what I was doing for my life. And then I recently just got a stable job and now I'm going to school. So I told him I still don't feel like I should owe the $1,400, but I have no problem paying rent.
Your Honor, if I could step in, I'm more than happy to work out some sort of agreement as long as that she understands that she needs to pay, because my whole goal behind this is to understand that in life, you have to go through and you have to pay for stuff. Nothing comes for free. You need to understand that when you go through, certainly you won't have someone as generous as I've been in terms of trying to grant you enough time to just get your stuff together. So I'm willing to work through some sort of agreement to make up for the $1,400. But the goal is for her to understand that, yes, you're ultimately responsible and you need to take responsibility for those things that you're given.
Young lady, do you think you can talk to your dad and you guys can work something out rather than have me impose something on the two of you?
Yes, I do.
Okay, now I'm just going to give you maybe just a little hint on how you should do this, because what your dad just said is absolutely correct. You don't get things, people don't just give you things. Rent is $200 a month. Your dad is trying to teach you a much bigger lesson about life. Right? I would suspect I don't know your dad, but I would suspect that it isn't about this $1,400. When it's all boiled down, it isn't about that. It's about you. Okay, now, at fear she may be watching this on YouTube, I will say this. I had one of my own like you about 6 years ago. You're hard to deal with because you have a different view of the world that I'm not sure that it fits. All right. But if he's willing to sit down and talk with you, take that opportunity. Okay, young lady?
Yes.
All right. You get one dad. He's not going to be around forever. And so what he has to do is he has to try to teach you as much, stuff into your head as much wealth and information and knowledge as he can within the period in time that we are allowed to grace this earth. And that is what he is doing. So realize that that's the central focus. It is not, I don't get the sense to punish you at all, to make you feel bad at all, or anything. But it's to give you something so that when you head out there into the real world, you have something to rely upon on that journey. You follow me, young lady?
Yes, I do.
All right. So I'm going to give you guys 2 weeks to get this whole thing worked out. Dad?
Yes,
I'll just say to you, I had a 19-year-old, not kind of like this, but kind of like, they come back around. You'll be okay. All right. You already look like you lost your hair, so you'll be all right. You ain't got much more to go. Okay.
Thank you, Your Honor.
October 6th, 2023. What time? 10 a.m.
Okay.
11 a.m.
It's 11 a.m. Excuse me.
11
Yeah,
a.m.
no need for you guys to get here early.
Okay, thank you.
All right.
Okay.
Thank you.
Thank you, Your Honor.
We have one case remaining today's docket, 21-37916, the state of Texas versus Lynn LaSalle. You're Mr. LaSalle. Come on. All right, the defendant is present with his attorney, Mr. Burbank, and the state's attorney. Earlier in this case, the defendant entered a plea of guilty in this case. A pre-sentence report was prepared. Have the parties had an opportunity to review it? And are there any corrections or changes to it? State? Nothing, state. And defense? Nothing. Then it's made a part of the record for all purposes. The agreement in this case is that whatever sentence shall not exceed a cap of 5 years in prison. So I guess we're looking at no less than 2 nor more than 5 years in prison. I guess deferred or unadjudicated probation is an option. Regular probation, I guess, is an option. Okay, go ahead.
Your Honor, we were here before. We took a recess in reference to some issues. You wanted us to take a look at it. In between that time.
This is some letter of.
This is from his new employer, Judge, since the last court date. And he has been hired on as a department head, supervisor at Turbo, whatever, over in Houston. And that's to show that
Turbine pump.
right on that. Also, Your Honor, I have been in touch with the complainant, and I know what the video shows. It shows that they got into something that he shouldn't have not done. He does have a past, I think, that had come up before in front of you in reference to other instances.
I see a criminal mischief.
Right, and then, well, there was also some family matters that were discussed before. He still has a young child. He's the primary caregiver over in Houston for, she's a minor. And it does involve the child and the mother. I think he probably just took the wrong course of action with mom. But he has had continuous, though she says, and I'll be very frank with the judge, she says, well, he's not letting me see her, but he is living over in Houston. I believe she's over here in Beaumont, or in this area of Jefferson County area. But this all started over the care and condition of the child, and that he felt that she was not being taken care of properly.
Who?
The child was not being taken care of properly by mom. There again, I think he took the wrong steps. I think he admitted that he does have a history of kind of taking the wrong steps, and because it's right there in the PSI report that the state and you pointed out the last time we were here. I'd only asked for some consideration in reference that he needs to be corrected and punished. If he goes to TDC, there are more people than him that are going to be hurt, and specifically is the daughter or the child. He does have some other family members that, like today, are taking care of her. But he is the primary and has been taking care of the child. You do have the power of deferred and to review every couple of months or every 6 months or so, or weekends. You know, he is over in Houston, so you have to drive back here to Jefferson County. And then I think we did talk about shock probation, Judge. And it's my understanding, for the record, that because he has a prior state jail felony, but he would still be eligible for shock probation. Is that your understanding, Mike?
Yes, sir.
But I would just ask that you take it all in consideration. You know, he did what he did, and there's no getting around that. So if you have any questions of Mr. LaSalle, then I'd be more than happy to answer them, Judge. But I'll represent to the court after the last court hearing. I called mom at least once, maybe twice, and it wasn't what he did. It was, how am I going to get access to my daughter? That was the whole crux of it. And after advising her, and I will tell you that, well, maybe you should get an attorney or somebody to go on out and get a family court order, which they don't have. Maybe it would kind of correct some of this stuff. And I think it went through one ear and out the other. So.
The elephant in the room here. A couple of elephants are in the room here.
I wasn't going to punch my ticket on that one, Judge.
This isn't the first assault on this lady. You pleaded guilty, I presume, but you were convicted, placed on regular probation in 2019 for, let's see, assaulting Jacqueline Frank. The same complainant here. Let's see, by scratching her face with your hands, and at the time there was a family member. And I'm looking here that the probable cause affidavit was again, let's see, it was communicating with the defendant, leaving work, advising him she was coming to get her daughter. LaSalle kept telling her he was bringing her, found LaSalle in the parking garage of the hospital. LaSalle appeared intoxicated, used his right arm to wrap around her neck and telling her to shut up. Then let her go. She attempted to grab her child. He began to claw at her face and eyes, kept swinging at her with his fists, but missed due to his intoxication. The complainant had a large bleeding scratch on her right lower arm and also multiple red marks and slight bruising on her face and neck. Her mouth was bleeding from a scratch on the inside, but wasn't aware where the blood was coming from. Okay, so a big deal was made about this. You come into court with a bunch of strangers who now enter into your personal lives because you aren't acting responsible and peaceful. Are you married to this lady?
Yes, sir.
Okay, well,
And if I may,
sometimes
Judge, for one thing, and when all this happens, which has happened several times, this is what was presented. This is from her, and here, that's a mistake. I don't understand why.
Well, because we all know what happens is, and it happens in this kind of relationship, and it never happens from the male's point. It's always the woman, but the woman's kind of stuck in a situation. I sympathize with them. I've been in a relationship for 40 plus years, and you have good times, bad times, great times, actually. But in difficult times, it's worked out responsibly. I don't go scratching and punching and threatening. And some of these people are put in an environment, they're victimized to where they really don't have, that they want a relationship that's peaceful. But you make this a living hell for this poor lady. So we made a big deal about it. You were put on probation. And here you are. Let's see. Didn't take very long. You were placed on probation for a year in 2019. So I guess you were released in 2020. So let's jump ahead to June of 21, a year later. Opens her vehicle, grasps her by the throat with both hands, throws her keys on the ground, grasps her by the hair, drags her, causing her to scrape her arms and legs. Well, that almost seems familiar. Held her down in the parking lot by applying pressure to the back of her head, causing injury to her face. Hold on, though. Where's the child during this? Right there at the scene? I'm sorry. Let's see. Beating the truck and shouting at their daughter.
My daughter was.
No, I'm sorry. This says Lau came to her home on Harding Drive, began beating on her truck window and shouting at their daughter. He then followed her to the Conoco located at East Lucas Drive, reached in the window of her vehicle and grabbed her by the hair. No, when I'm through, Mr. Bully, you can speak. I tell you, guys who beat up women and girls, pick on girls, they tend not to pick on guys, but you push around girls. I don't like that. That's you interrupted me again. You're a bully. You like to have it dominating your way. But in here, we have the rules. You'll get a chance to speak, Mr. Bully. But you've struck my sensitivity. First time, shame on you. Second time, shame on me if I don't hold you accountable. Well, you don't bully people, especially people you claim you love, who are women. And I don't see in your criminal history picking on guys. Isn't that interesting? I see a possession of marijuana, possession of controlled substance, driving while intoxicated. That was above 0.15. You have no self-discipline. You don't have self-discipline at all. There's the assault, disorderly conduct, failure to appear, 4 public intoxications. And here we are. Criminal mischief, you were placed on 2 years deferred or unadjudicated. Pull that up, please, that felony. I'm kind of interested in what the facts are on that one. Did that have anything to do with this lady?
No.
The criminal
This was
mischief?
a different woman.
What? A different woman? But these letters, I get them all the time from women who are battered women from the relationship. And, you know, I don't know why they stay in the relationship, but they shouldn't be punished for that, for trying to make something work. There's no crime for trying to stay in a relationship because they would like it to work, especially as their common child between both of you. Yeah. In spite of you and your criminal actions, I'm not surprised that they're trying to salvage a family. You, on the other hand, are working vigorously to dissolve a family.
I just had the indictment.
Let me see it.
You want the PC?
Yeah.
I'm printing out the indictment, but I did not.
Let's see, destroy an automobile by jumping on and kicking said car, throwing an unknown object at said car without the consent of Carolyn Evans, the owner of the vehicle. Another woman is a complainant, another girl. And it's a girlfriend-boyfriend relationship. You just don't know the meaning of love, do you? No, you don't. It has nothing to do with violence. But this is the 3rd female that you are in a relationship with that you've assaulted or was involved in assaulting your property. You observe the defendant exit his vehicle, go to the apartment. He was yelling, beating on the door, damaged the property that was on the porch. Then you were witness to go to the car, cause over $2,000 worth of damage. Then get in your black Chevy Camaro and not stand around and try to explain or fix the mess or wait for the police, but you fled. You fled. You don't handle your issues at all well. And this is the 2nd assault of this same woman. A 3rd involvement of some kind of assaultive behavior to another woman, a 3rd time. But once again, that's somehow you just feel like you were the dominant species and you forgot that we're all in this together. And a lady has as much rights to live peaceably as you do, in spite of your rules of behavior. So you see, I don't like these facts. And it's not like I don't have experience in dealing with relationships with a woman. You work things out, but you don't damage their property. You don't scratch their face. You don't grab them by the throat with your both hands and by the hair and drag them. So, anything you want to say?
I apologize for everything that I've done, but
Now, how do you take it back? How do you fix it? You're supposed to fix it by, if you make a mistake, you learn from your lesson. You go, I touched the stove, and it burnt my hand. But you keep grabbing at the stove. You know it has consequences. a bunch of strangers now, me, for example, are in your life, your personal life, because you are irresponsible in dealing with your personal life. And it's one thing if you want to just beat the heck out of yourself or scratch yourself or, that's bizarre, but not others. In front of children, they've got to see this. They've got to see the results of it. Don't tell me they don't. But this is the third time, sir. I just.
Judging them.
And it,
And then I also pointed out the.
you were placed on probation, then pleaded true on this. This was that criminal mischief. Then you
Yes, I
pleaded
also printed out the motion and it's.
true to some violations that resulted in of probation. So you've been on probation twice, right?
Yes, sir.
Now, for this, number one, for this state jail felony on the criminal mischief, and it was revoked. And then you were sentenced to 16 months in the state jail. Then this assault family violence. You were on probation for that. And it doesn't look like you were probation for 1 year. That doesn't look like it was revoked.
No, sir.
And then so here we are. You were on a possession of marijuana back in 2008. That was a misdemeanor. It was revoked. And then looks like there were two deferred probations, a possession of marijuana and a possession of an unknown controlled substance in misdemeanors. They were both revoked at probation. Your DWI, it looks like you served that out in 13. The family violence in 19, you served out. The criminal mischief, you were on probation and that was revoked. We just kind of run out of chances, don't we? When you're doing the same thing or similar. What state say?
Judge, due to the limited injuries on the victim, I put a cap of 5 years on this. Would recommend the 5 year. I don't think I need to argue anything more. You've kind of covered all the bases.
Okay. Or anything else? Any rebuttal to that?
No, Judge, I mean, there's no argument with what you said. No argument with what the state said. He does have a past.
Well, this is the present.
Well, in the present, and then you could kind of see with the complainant. I don't understand her.
Which but we see this. They're made to feel like they're the bad person. I know how that works. It's a twist, but the grand jury didn't indict her. They indicted you.
But even with all this, Judge, she still didn't take any steps to get her child back. I mean, here's because there's some precedent that says if there's family violence, the family court has to take that in consideration in reference to designating the conservatorship of the child. And she's never done anything, but then she turns around and writes something like that. I don't understand it because we saw what happened between both of them. And then when I talked to her, it wasn't, he's no good. He needs to be locked up. It's, when do I get to see my daughter? I mean, I want to see her, or we have to come to some arrangements, or that's what I want is something that I can, and you do. You shake your head saying that's not correcting any problems. And
I've seen it. We've seen it over and over again. Yeah. It's victims have lost trust
with the way the system works, especially in family instances. They don't know who to trust anymore. This is the second time he's assaulted her. She's going, what's the system doing to help me keep from being dragged around and my throat choked? I can appreciate reluctance of her to turn to who's supposed to help me here. Just terrible, Mr. LaSalle. You ought to be the poster child for breaking up families, not putting them together, sir. Really. I've never, it happens, but it's terrible. I mean, a family is one of the most wonderful gifts we can all have, but you don't take a precious gift and choke them. You don't scratch their face. That's just terrible. And this court stands for something different from that. Anything else? If not, I'm going to find you have pleaded guilty here voluntarily. You are mentally competent to do so. You understand the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 here, admitted in your plea hearing, to support the indictment, to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt of this third-degree felony. I'm following this agreement. You were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. And you will be given credit for all time that is credit worthy. You don't continue to commit assaultive behavior, especially on family members, and expect the punishment to get lighter. It steps up because you're not getting it. It's not getting through you. That if you have an anger management problem, it's not for a bunch of strangers to force you into that. You need to take your own responsibilities and independently go help yourself like everybody else does. We're all imperfect. We all make mistakes. It's how you deal with your mistakes and fix them until you ring up a lengthy criminal history. That's the difference between responsible behavior and irresponsible behavior. You have handled relationships irresponsibly, and a family, families are very important. I do all I can to try to keep them in a unit, but this is like a concentration camp, the way you handled your responsibilities. You've got women, it's consistent. Women are the ones who are assaulted by you. That's no way a gentleman acts. You're not acting like a gentleman, sir. You're a bully. Bullies, when they step over the line, they will get punished. And I beg you to start acting responsibly and treating ladies with the respect that they deserve. When that happens, a wonderful team family unit blossoms. You are not helping the growth of a family unit. You're only working against it with violent behavior. You need to stop that. You will be held accountable. All right, that is all. Do better, sir. All right. You ought to be the poster child for breaking up families, not putting them together, sir.
Who's first?
Mr. Marshall first. Mr. Marshall, come up to the door.
His mother in the courtroom.
All right, this is the People versus Theodore Marshall.
Good afternoon, Your Honor. Jeffrey Thiant on behalf of Mr. Marshall, for limited purposes of arraignment, we wait for all readings, stand mute.
I'll enter a not guilty plea on his behalf. Mr. Marshall, You have a right to remain silent. Anything you say orally or in writing can and will be used against you. You also have a right to have an attorney present during any future questioning and any future court hearings. If you can't afford an attorney, one will be appointed to represent you, and I'm signing the order for appointment now. You have 2 court dates within the next 21 days. The first is your probable cause conference. That will be via Zoom on 4/8 of 2024. The following week on April 15th of 2024 will be your preliminary exam. On that date, the prosecutor must show that a crime was committed and probable cause exists to charge you with that crime. Do you understand that? Do you understand that? Is that a yes or a no?
Yes, Your Honor.
Oh,
Yes.
okay, thank you. I have to be able to hear you for the court reporter. All right, Mr. Fanjois to bond.
Judge, no history, no holds. His mother's in the courtroom. The address, which is a new address, is where he'll be residing. And I've explained the court's contact provisions to him, and would request a personal bond on this matter. And I spoke with his mother earlier today, and she's back here this afternoon.
These are very serious allegations.
They are, Judge.
The 15-year felony.
We have 2 19-year-olds, Judge.
Is that Pine Street where the 2 of them were residing, or is that? Are there children in common?
Yes.
They're married?
Yes.
All right. All right. And ma'am, can you stand and say your name real loud?
Marshall.
Can you spell your first name?
M-A-R-C-H.
Okay, and then Marshall, M-A-R-S-H-A-L-L?
Yes, Your Honor.
All right, and this is your son?
Yes, Your Honor.
Is Mr. Marshall able to reside with you?
Yeah, sure.
He'll be with you because he can't go home.
With me in my home or with his dad in his home?
All right. I'm having him stay with you.
Okay.
Because he's going, do you have a landline?
Yes.
All right. I'm giving you a $75,000 personal bond with a GPS tether. I want to be really clear. I know the attorney told you, but Mr. Marshall, you're young. If you mess this up, I want to be clear. You will sit in the Wayne County Jail, and it is not nice. If you don't like it next door at Taylor Police Department, you're going to hate Wayne County. If you do not follow my no contact order, you will sit in Wayne County for weeks at least. You're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. You're to immediately notify the court of change of address or phone number. You can have no contact with Kashmir Randall, 0 contact. That means you can't call her, write her, email her. You can't send her anything through social media. You can't comment about her on social media. You can't have anyone else do any of these things except for your attorney. You can't send her blank messages. You can't use apps on the computer that allow you to generate phone numbers to contact her. This is an order. If it's going to be changed, I will be the one to change it at a future court hearing when both parties are present. If you see her at a party store, or if you see her at a barbecue or at any sort of event, a store, you're to turn around and walk out immediately. Do you understand me?
Yes, Your Honor.
If you violate this order, you will sit in the Wayne County Jail. I will turn that $75,000 personal bond into a $75,000 cash bond. You're not to enter the premises at 12707 Pine Street. I will allow you one visit to obtain personal belongings if you are accompanied by a police officer. You can't possess or have access to firearms. You cannot purchase or consume alcohol or illegal drugs. And those are the terms of your bond.
Judge, it will likely, given the time and the weekend, it'll likely be Tuesday, maybe Wednesday before he gets released.
I understand that, but I'm not comfortable. I'm giving him a personal bond on a 15-year felony assaultive case. He's getting the GPS tether.
Thank you.
All right, sir, sit tight for a bit.
Wait, can I say something, please?
Sure.
Your Honor, please.
Officer Ziegler, we'll need that form signed, please.
Okay. Just have her come over to the front desk.
Thank you.
Thank you.
All right, Your Honor, we're going to give Mr. Whitler a shot again today. His attitude hasn't changed.
Does he have pants on?
He does. He's missing his shirt today.
That's okay, I'll take it.
All right, Mr. Whitler, come on up here to the door. Mr. Whitler, come to the door, please. There we go. Fully dressed, that's perfect.
Thank you. Good afternoon, Mr. Whitler. Sir, you've been brought to court on a misdemeanor charge. There are two. There's interfering with a police officer and a larceny case. Both are misdemeanors punishable by up to 90 days in jail and a fine of up to $500. On the larceny, it could also be 8 times the value of the property. You have a right to an attorney. If you cannot afford an attorney, one will be appointed to represent you. You have the right to a trial, and at that trial, you have the following rights: to call witnesses to speak for you at trial. You can get an order signed by the court to require witnesses to come to court. You have a right to see, hear, and question all witnesses against you at trial. You have a right to be a witness for yourself or to remain silent. And if you chose not to be a witness on your own behalf, the prosecuting official could not comment on your refusal to testify. You have a right to be presumed innocent unless proven guilty beyond a reasonable doubt. You also have a right to a bond. Mr. Whitler, is there anything you want to tell the court with respect to a bond? Seeing nothing? Here's the thing, Mr. Officer Ziegler, I'm holding this arraignment. If he refuses to participate, I'm not going to call him back every day. At some point, we have to have a hearing. And if he doesn't want to participate in it, that's his right. But that's what we're doing. So it was read on the record. I'm indicating that Mr. Whitler refused to come to the door and lay down in cell. We tried this yesterday. We'll do it forever. Mr. Fanto, I'm going to ask you to stand in as standby counsel here. I know that Mr. Whitler's refused to talk to either of us, but with respect to bond,
Judge, I don't have any confirmation of his address, showing on the files a Toledo address. The, he has hold Southgate and Allen Park. And it looks like his last conviction was a 2021. If the court's not inclined to do a personal bond, I'd ask for it to be marked medical for mental health evaluation.
yeah, and can you approach real quick, Jeff?
Are we done with Mr. Whitler?
We are done. Yes, thank you.
Well, what do I put for a bond?
His $500 cash bond and his file will be marked navigator for the mental health program in the Wayne County Jail, mental.
All right, thank you, Your Honor. You have a great weekend. Good holiday.
Yeah, you too. Thank you. All right, Anthony Terry.
Kelsey Hunter, on behalf of probation.
Good afternoon, Your Honor. Jeffrey Fanto on behalf of Mr. Terry. I spoke with Mr. Terry, prepared to interview guilty to the first two allegations. The missing the testing date, Judge. He had called, he indicates that he spoke with the testing folks. They were apparently late updating in that particular day. So he won't admit to that. He'll acknowledge the first two. He understands he has a right to have a hearing and is prepared to waive that right.
Okay. We'll get to the third one in a minute. So you understand it's your fourth technical violation? I could just put you in jail.
Yes, ma'am.
For the, whatever the maximum was at this point. You understand that?
Yes, ma'am.
Did you go over your advice of rights form with your attorney?
Yes, ma'am, I did.
Did you understand it?
Yes, I did.
And did you sign and date it?
Yes, I did.
You understand, Mr. Terry, that if you enter a plea of guilty, that you'll be waiving your hearing rights. There will be no hearing of any kind.
Yes, ma'am.
And is it still your desire to plead guilty knowing that?
Yes, ma'am.
Did you fail to attend treatment as directed by therapists?
Yes, ma'am.
Did you fail to attend community service on March 2nd of 24?
Yes, ma'am.
Okay. When you say fail to attend treatment as directed, did he miss an appointment?
Yes, Judge. He was
One. He missed one appointment.
Then
two.
he rescheduled it, Judge.
One with a therapist, one with a psychiatrist. The therapist had to be the one to call him. She called him the next day on 3/6. He said he'd call her back. As of my appointment with him on 3/14, he still did not reach back out to the therapist to reschedule.
What are you thinking?
I thought there wasn't a plan set with her at that time because my therapist has switched twice now, and I screwed up.
Mr. Fanto, what are your thoughts?
The the therapist switching is a problem that we certainly understand that is happening from time to time. He wasn't sure of the plan, and I had a conversation with him that whenever he meets with Ms. Havner or myself or the court or his therapist, his last words when he leaves those is to make sure he understands everything each party wants. And for his therapist meeting, it's okay, my next appointment is on such and such a date. Is that correct? So that he, does that. He didn't check his email because he's in a job search situation and gets a bunch. And so I offered a workaround for that, and he's going to create another email for his court-related matters so that he can keep track of those much more easily. Just a little bit of organization. I don't think it's a intentional thumbing of the nose, but it's just a little bit of organization.
What were the prior violations?
The first one was increased levels of testing. The second one.
I mean, what the violate, is it just okay, let's see.
I think he got community service for the first violation. He got court watching for the last two violations, but they have been due to testing. Either increased levels the first one. I think the second one was he missed a test, and the third one he took CBD gummies.
Mr. Terry, you're sitting here, you've sat here and done your community service. I generally think I'm pretty reasonable.
I agree with you, ma'am.
Right? I'm not out to get anybody.
No, ma'am.
I mean, I treat everybody that comes in here fairly.
I agree with you.
But like you have to recognize, like, this is not, you're on probation and you're an adult. Like, it's not our job to make sure, I mean, you'll get violated if you don't do all the things, but Kelsey's not your nanny. Mr. Fanto's not your nanny. Your therapist isn't your nanny. Like, this is your responsibility.
Yes, ma'am, I understand that.
And there are certain benefits you get out of this, and I expect you to take advantage of them. You're gonna go, I mean, you can't just cancel these appointments. It drives me crazy at the guidance center. Do you know how many spots the guidance center holds for us so that people that are in my treatment court program or on probation here can get services? And when you don't show up, they've taken an hour of their time, right? They can't schedule anyone else when you don't show up. They can't call someone and say, hey, come right now, I'll see you now. Like you have the privilege of being at this court where we can get you in fairly quickly, right? But that is so inconsiderate of professionals' times to not show up to those appointments. It's frustrating for them. It harms other people that come into this court, because if nobody ever shows for their appointments, how many appointments are they going to hold for our people?
You're right.
Like it's out of respect to these people that make time for you and understanding, like, there's no one else. It's not McDonald's. There's not someone else in line, right? Like, they can't just open their door and be like, well, I guess you come in. That's not how it works. It's an appointment with a medical professional. You have got to show up for those. It is so disrespectful to not.
I would note that he reports that he tested the next day, after he missed the test.
Yes, he did.
On the 321 test?
Yes.
So they were a little late to updating the colors. However, the date it said 320 instead of 321. So Mr. Terry should have been aware that it was the wrong date. And there's also a website that they can check.
Yeah, but nobody, I mean, Kelsey, like, I get it, but nobody, if I had to call a number every morning and I call the number every morning and it's like, today is the such and such a date, these are the colors. I'm just listening for tan. I'm just listening for scar. Like, I get that. Like, it is your responsibility, but ultimately, like, if you went there and you checked and it said you were good for the day, I wouldn't expect anybody would listen to the day.
Yes, ma'am. I also even sent Miss Kelsey a screenshot of my call log, and I asked the guy downstairs what happened the day before, and that's he said they were updated late. That's why I missed on the 21st.
All right. I mean, I can't hold that against you. I mean, and really the most problematic thing for me is you have to go to these appointments.
Yes, ma'am.
Because it's not just our time. Have you been
Understand.
lectured enough? Do you understand how important it is?
I do.
What's his work schedule? The recommendation is for a day of jail forthwith, verification of an appointment within 7 days, continuing as directed, and all other conditions would just continue.
I think you already have your appointment set, right? Your next therapy appointment.
Yes, ma'am, I do. It's April 14th, I want to say. I got the text on my phone.
And you can provide that to Ms. Hadley.
Yes, I can.
Have you seen it yet?
No, I have not.
All right. So
Good.
for the,
He does work tonight, but
I work Monday through Friday. And I'm off Friday afternoon because I work the night shift, and then I'm off Saturday, and then I go back Sunday.
has he done any jail yet?
No, Judge. Yeah, the first sanction was community service. The last two were court watching.
is the garden starting up soon, Judge?
April 20th, Saturday.
Saturdays are good days for him to do that sort of thing.
This is your final. I mean, you should get some jail time. When did he get put on probation?
It was right before the holidays, so it was sometime in December. I wanna say.
Oh, this was his 8/16/23. Oh, that's when he was referred. Did he go into warrant status? Yes, he did. Mr. Perry.
I could be wrong about the date, Judge, but I believe it was, I believe I had ordered sometime right before the holidays, but I could be mistaken.
It was October. October of 23. You're on your 4th violation. I've given you additional community service. So one was driving when you weren't supposed to. The CBD, which I do think the numbers were at like consistent with that, right? On and the gummy or whatever it was.
Yeah, he admitted that he used it, he just thought it was THC
Yeah.
free, but we had the discussion, he's responsible for what he puts in his body.
All right. This is it. Next time you're going. 2 days community service plus 420 at the garden. So that's 20 hours of community service. You're gonna provide verification to Kelsey of your next therapy appointment. Thank you, within 7 days. And all of their conditions will continue. And all of that garden time and community service must be completed. He could do Saturdays, right?
Yes, ma'am.
All right, so he has next 2 Saturdays?
For DPW?
Yeah.
Yes, I can put him on.
Next 2, I mean, I don't know if they've got time or to add them for this week, but if not this week, the following 2. I don't know if they're doing it over the holiday week even.
Judge,
know they're
I
not
was
ready.
scheduled next, not this following, but the next Saturday anyway, so if that,
Yeah, I mean, that doesn't count. You have to do
That's what I was
20, you have to do 2 days in the next 3 weeks, right? The
okay,
next, not this Saturday, the next 2 Saturdays plus 420 at the garden. And that, I mean, this is in addition to your regular community service. So it's not going to count towards your hours because it's a sanction.
I understand that.
All right. All right, we're all set.
Thank you.
I'll call him because I have like.
Pamela Peel versus Nancy Gerler.
Your Honor, Nancy Gerler, appearing on phone Zoom.
All right, and where are we on this case?
I believe that Hawk was still out there to help me with this money judgment. And I checked back in with Hawk. They, Ms.
Ma'am, they
Hill had
won't
not-
help with the money judgment. They will help you maintain your tenancy by paying if you're gonna remain in the unit. But you're out of the unit now.
Sir, Ms. Peel did not return the calls on December 19th or January 3rd from Hawk, reaching out to her to try to assist with this situation. They closed the case. There might have been help from them and their affiliated agencies, but there are 4 occasions when I attempted to get help from other agencies, including the Department of Health and Human Services, when the situation where fraud might have been done in the name of another tenant wasn't cleared up for me either. So no, I do not feel that I owe the full judgment here. I
Then here's
have done.
All right, that's
everything
fine.
I could.
Ma'am, that's fine. So here's what I'm gonna do. I'm gonna set this for trial. Both of you need to appear in person. And I'll just have a trial. You guys need to bring all your paperwork. Because what you're explaining to me, ma'am, would be rental assistance if you were going to stay in the unit. You're no longer in the unit, but you feel that you don't owe the money. If you don't owe the money, then that's gotta be hashed out and we're gonna have a trial. Emily?
March
7th at 9 AM.
I'll set your non-jury trial, March 27th. 2027, 2024, 9 AM, that is in person at the courthouse.
Your Honor, you do realize that I have great difficulty being in Wi-Fi and all of the.
You have
things
great
that are-
difficulty in what?
In being in your courtroom because of all of the electromagnetic frequencies in your vicinity as well as the courtroom. That's why I'm on phone Zoom every time.
Ma'am,
suffer
I'm
physical.
setting it in, ma'am. I'm setting it in person. If you send me something medically that may make me change my mind, then I may let you appear via Zoom, but I'd have to have something from a doctor that the court can check out. Otherwise, I will expect both parties in person.
Yes, Your Honor, I will present to you that evidence, and I appreciate your consideration. And
I'm making it
sir, sorry.
right now that this is set for non-jury trial in person. Pamela Peel versus Nancy Gerler. If people kind of get out of your way, go ahead. William, state your name, please.
Good morning, Your Honor. Pamela Peel.
All right. Miss Gerler, are you there?
Yes, I am, Your Honor. I am present. Thank you.
Okay. Can you state your name for the record, please?
Nancy Rose Gerber.
Thank you. All right. Have you seen? All right. Have you two talked at all in terms of resolving this? Or where are we on that?
No, we have not.
How much is your claim?
I'm requesting a money judgment of $12,406, which includes unpaid rent of $12,950.
12,900.
Out-of-pocket court costs.
Hang on, give me the rent again.
Oh, yeah. $12,950.
Okay.
Which is on the balance statement that I gave Nancy Rose. Out-of-pocket court expenses, $215, court serving fee, $68. And then after we inspected the house and stuff, I added cleaning fees of 5 hours at $20 an hour, 2 extra days rent at $34 a day. And to the amount of, that totals $13,401.
$13,401.
I then deducted the security deposit that she had.
Okay, which was how
For
much?
$995. And
How much?
it's up to $12,000.
How much was the security?
$995.
All right, and then that's how you get to the 12,406.
Yeah.
Okay, so out of the gate, you're going to have to add $2.55 because the service fee, as the court has it, is $70.55, not $68.
Oh, okay. Oh, I thought it was,
The
okay.
what's also going to come off of the total amount is going to be the 5 hours of cleaning.
Pardon?
The 5 hours of cleaning. So the $100 that you put on for cleaning also it needs to be deducted.
From the security deposit? Or I
Probably
put
don't
it
want
in
to
the-
do it that way, but it's going to have to be deducted off of your total.
Oh, okay, so I can't do that.
Can't do that
Okay, all right, that's fine.
that way. And then the 2 days of rent, that was for what?
Nancy Rose was unable to move out on the 31st as the judgment requested, and she stayed till midnight, February 2nd.
All right. Ms. Gerler, do you agree with that or no?
No, Your Honor. I do have some comments regarding what?
Well, I
Ms.
understand you have comments. I'm dealing with just this issue. Were you there the 2 days beyond the 31st?
I was there the 2 days beyond the 31st. It was my understanding I had up to 10 days to vacate, and did not believe that there would be an additional sum for those 2 days.
which were spent cleaning, and professional cleaner did clean the house on
Okay,
two
okay,
occasions.
it's fine. I'm dealing with this one by one. And so I'm just telling you. You're saying you did occupy the unit those 2 days?
Yes,
For
I
whatever
did.
the reason. Okay,
Yes, you're,
all right. Okay. Now I'm gonna ask a general question, Ms. Gerler, and I need a very, not a highly specific answer, but just this. Of the $12,406, is there any amount of that you believe you owe?
Your Honor, what was in contest at our last hearing was my stated concern that I had enlisted the help of Miss Biles at Faith in Action. And we could have been brought current at the first problem, and it was just shy of
Miss
$3,000.
Gerler.
Sir, I just want to.
Listen very closely to my question. Of the $12,406, which is primarily consisting of rent, is there any amount you believe that you owe or admit that you owe of that amount of rent?
Sir, if we were able to subtract the 3,000 she might have gotten, yes, then I would say that I am responsible for the balance.
So what your claim is that if the 3,000 had been paid by the outside agencies, what you would owe at this time would be the $9,406.
If that is the
Right?
balance, Your Honor, yes.
Okay.
Your Honor, when I talked to when Faith in Action approached me, they offered $800.
How much?
1 month. And nothing was.
They offered
provided.
what?
They offered 800 toward her rent. for
Right.
1 month. That's all I knew
understand,
about.
but what I'm getting at is, and I think what Ms. Gerler's getting at is, had Faith in Action plus what would have been the other agencies of Hawk and the like, she would have gotten a maximum of 3,000. I think that's what she stated the last time. That's what she continues to state at this time.
Okay.
All right. So
And
while she's pointing to one agency, I understand what Ms. Gerler's indicating, that there's this other agency. All right.
May I respond to that?
To which?
To the $3,000.
I don't, okay, first of all, here's the problem, ladies. You're fighting over stuff that doesn't make sense to me right now. Okay? And let me tell you why. Ms. Gerler admits she would owe the 9,406 in essence, and I appreciate her candor on that. There's now going to be argument over this 3,000 that Ms. Gerler says, because you're saying that they were only going to pay 8. I get where Ms. Gerler's coming from, because what I just said. Here's the problem with all of that. The problem with all of that is there would have been no payment with these programs if the tenancy wasn't going to be maintained. So the 3,000 wouldn't have come in. But I understand Ms. Gerler's point that, okay, it may have come down to this point, but if you had taken that money at this point, then I'd be 3,000 to the good, basically, is what she's indicating. All right. So let me just.
I never got anything in writing to that effect. And they never said that to me over the phone. I didn't know about Hawk. I didn't know about any of them.
Okay. I get that.
Okay.
What are you guys really fighting over?
I just want to be paid the rent that I'm owed.
Okay.
And that she promised to pay each
Okay,
month.
and Ms. Gerler,
Yes, Your Honor.
are you working?
Not at present, Your Honor.
All right, and so
I only have Social Security income.
that's what I thought. You have Social Security,
Yes,
the SSD or SSI? Which one?
SSI. sir.
Okay,
I'm 68.
and got it. So how much is that per month? There's a reason why I'm asking.
$1,137 monthly, Your Honor.
137 a month.
1,137.
Yeah, yeah, I got it. I got it.
Okay.
I probably got it. 1,137 a month.
Correct.
Okay. So I can sit here through a trial. You can put on your proofs. You can do whatever. She's admitting basically to almost 3/4 of what you're saying anyway, right? Because if she's admitting to the 9,400, the 3,000 may be a question, but I've said what I've said. But here's the bottom line and why I'm trying to figure out entirely why we're here. And let me just, and I'm going to do this just in terms of the practicalities of it. All right. We can go through the trial, and I don't mind. You guys have my time. I can sit here through the trial. The cold-hearted reality of it is Miss Teagle, you come down to the end, and let's say, just by hypothetically, and I'm not saying this is the way I'm finding, I find entirely in your favor. And I give you that judgment for the 12,000 plus. Let's just say I do that. How do you intend to get that money?
Your Honor, it was a matter of principle.
Okay, I understand. There are principles all over the place, and people can fight on principle or whatever. My question is how would you intend on getting that paid? You told me you want the money. I get it. But how are you going to get that?
Well, I don't know, but I also make about the same amount of money in Social Security as Nancy Rose does. And that income was I depended on. And I worked hard and
I appreciate all of that.
Okay. Just one.
I'm just getting, no, I know.
I'm not rich.
I'm not saying that you are. The reason I asked about her income is because that's where any judgment you would get would come from. Right? But you can't garnish her SSI until potentially at least there's an argument that it would be transformed into something else. If that's indeed all her income, go ahead.
Well, I know Nancy Rose is a psychic and she does a lot of readings in the past. And it's not always, above board. So she does have other income, which I know to bring that up.
So what do you want me to do? You want me to give you a judgment for the full amount?
I don't ever expect, she gave me her word that she would pay.
I asked a question. How come nobody just answers my question? Do you want a judgment for the full amount? You want to sit here through a trial? If that's what you want to do, let's do it. I'm trying to just give both of you the practical realities of it. That's all I'm trying to do. But if you want to sit here and we just go through the time of doing it, that's why I'm here. Let's do it. Mr. Allen, swear her in. I mean, it makes no sense to me. It's a waste. It becomes a waste of time that you two can't resolve this.
May I speak to my husband for 1 second?
You want to speak to
My husband?
your husband? Go for it.
All
Go
right.
ahead. Talk to him. All right.
I will accept the $3,000 that you're proposing.
The 3,000 deduction.
Yes.
Okay. Ms. Gerler, did you understand what plaintiff was indicating?
Yes, Your Honor, and that is a satisfactory conclusion. Thank you.
All right, so I'm going to enter a judgment total amount. So here's what I'm going to do. I've got your total figure, but the way that it would add up is, can you do this for me? Actually, it's going to be 70, 55. Take $9,406.
Your Honor?
No, that's not right. Hang on one moment.
Okay.
I have rent. Let me just go through the figures so that we're all clear on everything. So I'm going to have a total rental amount of $12,950. But
Your Honor,
where
that's
I'm
not
gonna, but hold on a second. Hold on a second. Where I'm going to take the rental amount off, the 3,000 off, is I'm going to take it off of that figure.
Your Honor, the rent figure given is not accurate.
Which part is not accurate?
The rent itself did not come to 12,900. Should be 11,900 and the change, not 12,000. That's adding another month's rent that was not applicable because she received the security deposit for that.
Well, no, I haven't gotten to that deduction yet.
Oh, I'm sorry, sir.
Okay, so just let me get through the figures, and then if anybody has a dispute, given what you've said, then we'll do it that way. So what I'm gonna do is, I've got a $12,950 for rent. I'm gonna deduct the 3,000 that we were talking about at that point, okay? This will probably make it easier. So now I'm at 9,500, or I'm sorry, no, 9,950. Okay, everybody with me so far?
Yep.
Yeah.
I'm then going to add to that figure, there is going to be 2 days of rent at $34 a day. So I'm going to add 68 to that figure. So then I'm at 10. You with me, Emily?
I'm sorry.
You're not with me? Will you pay attention to?
I am paying attention.
Okay, take 9,950 plus $68, because I'm just gonna get the rent part out of the way. I come to 1018. Okay, so then I come to $10,018.
I thought it was $10,301.
Hold on. No. Everybody just stay with me in my math, okay? I took the 12,950, took off the 3,000 we talked about. That brings me to $9,950.
Mhm.
You're also claiming $68 of rent.
Okay.
That brings the figure back up to $10,018.
Okay. Then the court fees?
Ma'am, please. Without talking, just let me get through it and then we can back it off. Then I'm going to subtract out the security deposit, which was how much?
$995.
That's right, Miss Gerler. It was $995, correct?
That is correct, sir.
All right. So then, Emily, help me. I come to 9023.
Sounds good.
Okay. That then is the total judgment amount, and now I'm gonna add the cost in. And the costs that are added in that the court has is $215 plus $70.55 service fee for $285.55. Add those costs in, I come up with $9,308.55. That is the judgment amount and how I figured it. To the plaintiff, that figure is acceptable to you?
Yes, it is.
Ms. Gerler, is that acceptable to you?
Yes, it is, Your Honor.
Wonderful. All right, so what I'm gonna need, yes, ma'am.
May I ask Nancy how she intends to pay that? Or if she, and what time frame can I expect?
Well, let me do it this way. Ma'am, did you want to enter into a payment plan at this point? Or do you want the judgment to enter and then you can file for, she could try to collect and then you file for, come back, and then I have to decide what the payment is? How do you want to do that?
Your Honor, there's no commitment that I can make at this time. I am not working. I have lost all the phone numbers affiliated with my business. I have had chronic problems with chronic illness and even finding a permanent place to live. I
Got it.
certainly hope
Okay.
this changes in the future, and I will make every effort to pay towards, but at this point, I can make no commitments because I literally do not have it, nor secure or stable additions to the Social Security income that I get.
So what that means is that you're left to the
Okay.
collection procedures that
All
you
right.
can.
That's fine.
The court will enter a judgment. Judgment amount is $9,023. Cost of $285.55 for a total amount of $9,308.55. All right.
Thank you.
You'll need to fill out a money judgment form out at the counter, and then once I get it, I'll sign off. Arbor One West versus Rosa Bannock.
Carol Wolkoff on behalf of the plaintiff.
Hello. What's your name?
Bannock.
Okay. Well, we've done some things on this. Where are we now on this case?
So, Your Honor, this is one where we had agreed to move the tenant to a new unit. I had asked for escrow to be released, and you told me we needed to trust you, and you were going to be like the IRS. Do you remember? Okay, so.
I do. I do.
Okay, at this juncture, I know, and Amy can speak more to this, Amy too, that they've been trying to reach Ms. Bannock and have been unsuccessful in reaching her because they want to confirm that she'd be moved from Arbor West to Arbor One and that she's okay with that, et cetera. So they just haven't been able to reach her. And Amy, if there's anything you wanted to add to that.
I haven't gotten any calls from them at all.
Yeah, I don't know if we don't have a correct number on Miss Bannock, but I also posted something to your door. We just got an apartment available, Your Honor, that we can transfer her to, but we have to turn it. And we need to talk the details with her to see if it's something she would be interested in, because it's a completely different style, price, and area. So we needed to know if she would come into our office so we could discuss it with her. Would that be something she would be able to do?
I can do that. It's just nothing has been posted on my door.
Okay.
Yeah, we don't have a problem.
Sure, we have
Yeah.
the right unit here because I know they posted something and I asked them to go back again yesterday. I mean, so something's not working here.
Well,
I would almost
unfortunately-
ask, Your Honor, if Miss Bannock has a telephone and she wants to call Amy right now, I don't want to just keep kicking the can here because it seems like we're having some communication issues.
Yeah, we got some bad kids in the building, so they probably ripped it off my door.
Okay.
Yeah.
That can
Bad kid.
happen.
Bad kids in the building. It was probably him. No. All right. So can you give her a piece of paper to write down her number? Because they may not have a good number. And I don't want to broadcast it out there. And then what will happen, if with your permission, we'll put your number in so that they can see your number and
Thank you
get
very much. And I'll reach out today so that we can talk about the details.
There is, how much is in escrow? There's a
$39.80. There was an $80 payment made yesterday.
$39.80. Okay. So in terms of what she owes, and even coming into April, I have $39.80 in escrow.
And I have a balance of $4,055.85. So we're very close.
Okay. So if we can get her moved, if I put this to the 12th, we should be all settled and everything, and then be able to get this money out to you.
Okay. You know, I'd ask for
Okay.
you to release it right now, but I'm not going to waste my breath.
Oh, you can ask.
I know the answer. I know you will.
And I
enough.
want you to ask so I can say no.
I don't feel like getting the rejection right now. Okay. Let's move.
Okay. April 12th, 2024 at 10 a.m. Okay. So they're gonna get in touch with you. We'll get this done.
Okay.
Okay. Thank you. Court calls the case of Mauer Apartments versus Tia Owens,
For the plaintiff, Your Honor.
AKA Teddy Owens. As soon as he'll get out of the way. Your name?
Tia Owen.
All right. All right, where are we on this case?
Well, Your Honor, we're at a pretty substantial balance, but Ms. Owens has made a smaller payment today, made a payment last week. She has applied with Hawk, but is quite a ways out. Is there anything you can add to that?
I did just speak with her and she's assisting me with getting a sooner appointment. My appointment wasn't until May 14th.
Okay. And so what's happening? Odd system. People who are here, when they call in and they have the appointment, what Amy's doing is talking to them, moving their appointment up to prioritize their case. I don't know why that system is set up. Do not look at me like I set it up, Mr. Friedman.
No,
I didn't.
I know you didn't.
So she's gonna get a sooner appointment.
I'm all for April 12th.
Good enough. I'm a little gun shy because I had luck off first thing this morning. April 12th, 2024 at 11 a.m. Okay, ma'am. Thank you. And you've already talked to Amy. Okay, fantastic. Thank you. Court calls case of townhomes on Robbie Lane versus Janella Smith. Been here all morning.
She's making progress too, Your Honor. She's made an escrow payment, going to make another one on the April 2nd. And so there seems to be a disconnect with DHS. They're claiming that my client hasn't furnished them with a W-9 and we have. So she's emailed me information that we can deal with DHS and try to get this straightened out. So to summarize, how about April 12th at 11 a.m.?
That work for you? How much is she owing at this point?
A lot.
Yeah, that's
A lot.
Okay.
I'm being honest.
No, I appreciate it.
I don't know if I have the ledger in front of me, but it's
It's in the upwards of about 5,000.
yeah, it's
okay.
Well, yeah, yes, period. However, with the escrow she paid and then the escrow that she's going to pay in April, it's not increasing.
Got it. I think that's what we're, all right. April 12th, 2024, 11 a.m.
Thank you.
All right, thank
Have a good
you.
one.
You do the same.
George Cantu? Is the attorney here for George Cantu?
Yes, there you are.
All right, come on down. Court is calling counsel. You're on this side, your client's in the center. And you all act as though y'all trying to buy Diana's equipment. Court is calling 2024 CR 0411, State of Texas versus George Cantu. Can I have the parties announced for the record for the state?
Daniel Escobar from the state of Texas.
Defend.
Alfredo Ortiz for the defendant, George Cantu, Your Honor.
Are you Mr. Cantu?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your client?
Yes, I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Cantu, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, we do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, sir.
All right, as a habitual.
Yes, sir.
And so this tampering with electronic monitoring device, what is that, a third degree?
It should be state jail, though.
Okay,
I was looking into it. I know that the statute does have the third degree language, but
Mhm.
that's it. It was a intensive supervision. There was no language like that in our side.
okay. All right. I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it?
Yes,
Did
ma'am.
you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with tampering with an electronic monitoring device under intense supervision? That's a state jail felony, the way it's been indicted.
Yes,
The
ma'am.
range of punishment normally would be anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
All right, you can unfold your arms. You get people nervous when you do that, okay? If the state is able to prove up the enhancement allegations, then this would be a second degree punishment. The range of punishment would be anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
In my opinion, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, he is.
Mr. Cantu, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney and did you understand it? According to the plea, punishment is to be assessed at 5 years in the prison. You agree that you've been convicted of 1 or 2 more felonies for enhancement and there are no applications. Did you understand that to be the plea?
Yes, ma'am.
Did you review the paragraph entitled Waiver of Appeal with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, there has not, Your Honor.
And did you understand that to be the plea, a cap of 5 years?
That's correct.
All right. And state, is that the plea, the cap of 5 years?
Yes, yeah.
All right. And to correct the record, the plea offer is for a cap of 5 years in the prison. Did you understand?
Yes, ma'am.
All right. And to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty, ma'am.
State, any evidence?
State offer states to go one in all fashions.
Any objection?
No objection.
Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. And with regards to the both paragraphs of the habitual offender enhancement allegation, how do you plead, true or not true?
True.
And that's true to both of the enhancements?
Yes, ma'am.
All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. The court will find the enhancements true based upon your plea of true and based upon states exhibits 1 and attachments. Do y'all wish to proceed with sentencing?
Yes, Your Honor.
All right, anything you wish to say on behalf of your client?
Yes, Your Honor. We filed a motion to reduce this state of jail felony to a misdemeanor punishment, Your Honor, 1244A. We want the court to consider the circumstances regarding the offense, Your Honor. November 7th of last year, Mr. Cantu informed his parole officer that he had problems at home, and that he was living with mom and he couldn't stay there no more. So he informed his parole officer that he was gonna take off, unbuckle his GPS monitor, that he couldn't stay there no more. That was November the 7th. He left the equipment there at his mom's house and that was not damaged or anything. 10 days later, November 17th, he self-surrendered to the parole officer. And he was taken to custody and taken to the Bexar County Jail, where he has been there since he was arrested, Your Honor. I want the court to consider that he is not a violent person. He has the criminal history that he has, a lot of it can be attributed to his drug abuse illness. He has never received any treatment for that, Your Honor. So we're asking the court to consider all these factors and sentencing Mr. Cantu, Your Honor, and sentence him to a year in the county jail, Your Honor. And I think Mr. Cantu likes to address the court.
All right, so legally, this cannot be a 1244. So you want to raise, I'm sorry, you're already under oath. So it says in the police report that the device was removed on November 7, 2023. And it was reported as being removed on November 8th. And when I say reported, that's not you reporting it. That's just parole became aware. So what would you like to say?
Well, I took the monitor off on the 7th, and the warrant was issued, I think, to the 8th, the next day.
Okay. And did you turn yourself in on the 7th?
Yes, no, 17th.
All right. Any questions?
What do you like to say to the judge regarding sentencing?
I mean, I just got a severe drug problem, a bad drug problem, and it really needs help, Your Honor.
Is that why your mom didn't want you living with her anymore?
Yes, doing drugs.
Okay.
I'll pass the witness.
Nothing to say, Judge, just sorry.
All right. Well, what I can tell you is I've done parole hearings in my past as well. And I know, and you correct me if I'm wrong, all you have to do is pick up the phone and call your parole officer. And in actuality, I think parole is easier than state probation. So did you pick up the phone and call your parole officer and say, I'm in the throes of my addiction. I need inpatient treatment?
No, ma'am.
Did you call them at all, telling them that you needed help?
No, ma'am. Called them after, cut it off.
Okay. All right. This is what the court is going to do. The court is going to find you guilty. Court is finding the enhancements true. The court is going to sentence you to 5 years in the prison, give you credit for any time served, and this will run concurrent with parole. Showing you what's entitled defendant's rights. I'm sorry, trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. So I want to let you know that I did listen to your attorney's argument. I always internalize what I'm hearing, but at some point you got to be responsible for your actions. You understand? All right, good luck to you.
Thank you.
You're welcome. Who is here for Albert Bishop?
All
right, where's Mr. Bishop?
He's in the box right there.
Come on down, Mr. Bishop.
Come on down. Here.
And probation, this is an application. Court is calling 2024 CR 1174, State of Texas versus Albert A. Bishop. Could I have parties announced for the record for the state?
Jason Garrett, hand you on.
Defense?
Charles Gold for Mr. Bishop.
And are you Mr. Bishop?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Bishop, I'm showing you what's entitled Application for Community Supervision or Deferred Adjudication. Did you review that with your attorney?
Yes,
Did
ma'am.
you understand it and did you sign it?
Yes, ma'am.
Did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
You already know.
Mr. Bishop, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense of stalking? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine.
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial?
Yes,
A
ma'am.
right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that I'm sorry. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I think he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Bishop, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
I believe so.
Well, I mean, either you are or you're
Yes,
not.
ma'am. Yes, ma'am. Sorry.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $1,500 fine. State recommends deferred adjudication. They're taking in consideration 727710. There's to be no contact with Tricia Robles, and you're not to be within 500 feet of Tricia Robles, and you're not to go to McDonald's at 101 Alamo Plaza and be within 500 feet of that location.
Yes, ma'am.
Did you understand?
Yes, ma'am.
Did you understand that to be the plea?
Yes, ma'am.
Defense?
It is, Your Honor.
State?
That is, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the agreement. The state is requesting that your community supervision be for a term of 7 years. There be a TAP evaluation, 200 hours of community service restitution, and no contact with Tricia Robles or McDonald's at 101 Alamo Plaza. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence
Yes, Your Honor, state exhibit one with all the attachments.
No objections, Your Honor.
showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor. I would like to address the court about the fine.
Yes.
He's homeless. We would ask that you probate the fine, the fine, until he gets a job or gets set up. We would ask that since he's been homeless.
All right, why are you homeless?
Just doing things for my community, the homeless community, being an activist and prevent.
No. Why don't you have a place to stay?
I guess for people's sake that I don't like being a burden to anybody.
No, I mean, if you get a job,
I know.
no, here's the thing, listen.
Yes, ma'am. Yes, ma'am.
If you get employment and get an apartment and pay the monthly fee for the apartment, guess what? You're not a burden. It's a business transaction. So why are you not engaging in business transactions for a place to live?
I have no excuses to give you. I'm in the process of getting that together.
So why are you homeless? Like, when did this start? Have you always been homeless?
The point of beginning to now, I've been homeless for about 3 years.
Okay, so what were you doing before you became homeless?
Couch surfing.
All right, so why don't you have a place to stay? I still don't understand why you're homeless.
I have no excuses to give you, and I present them to you. And now I do have a reason, a purpose to stay off probation, to pay for myself. Meaning invest in myself.
Okay, counsel, do you know why he's homeless? I mean, sometimes people are homeless because they start using drugs and people are just done and they say.
I think during the time, Judge, no, not necessarily.
I've been sober for about going on my 13th year. I've never done heroin. I probably smoke weed for my anxiety. Because I do have bad anxiety. A drug problem. I'm too poor to have a drug problem. not to make fun of anything.
Yeah.
I just don't have the money to invest into a drug.
So I'm trying to figure out, how can he do well on probation? What is his plan?
To get myself on the ball for probation.
But how are you going to do that?
Getting a job, if it even means for right now, getting paid on,
Didn't you say something about Haven for Hope?
Yeah, Haven for Hope, or the means to an end to get a job. I mean, that should be easy. A purpose? Well, I had no purpose. I had no family to speak of, no kids to speak of, nobody to take care of. And when it comes to investing in myself, well, now I have a reason. So if you give me a chance, of course I'm going to do what's right. I always do what's right.
All right, so here's the thing. No less than 2 times, this person at McDonald's said that you've been bothering her and she doesn't want you there anymore. Is GPS appropriate in this case?
Well, at least additionally, it should be, Your Honor.
I don't know about that, Judge. I think wasn't this followed at large and there was nothing going on at the time?
No, I really get every time she says the name, I really can't picture who the person she's kicking.
Well, it's the person where you keep going to McDonald's at 101 Alamo Plaza. She said you were trespassing. She didn't want you there. And it says, victim advised that the same patterns of malicious behaviors were directed towards victim by suspect. That's you.
Yes, ma'am.
They're saying that you would criminally trespass from the restaurant and would typically direct these gestures at her through a large store front window from the sidewalk. These behaviors occur several times a month and cause her to feel unsafe and anxiety. And then that was in August, and you also have the one from October. So I think he needs to be on GPS. How old are you?
20, I'm about to be 52, man.
Yes.
If I really don't need to be on GPS because I really don't have nothing bad against her. She's a manager at McDonald's. Maybe I flicked somebody off through the window that was in there. But really,
All right, see, why are you telling me that she's the manager at McDonald's and you just
Well,
told council you don't even know who she is?
well, I don't know who she is personally to say, but I know after speaking to her, when she gave me, well, yeah, she's the one of the managers at McDonald's.
Judge, I just think that, I mean, we can delve into this, but I think that he's homeless, and I think I'm asking about the fine. And if we can waive that, and I don't think how he's gonna pay for GPS. I think that can graduate if we need that later on, but there's been times when it hasn't. I say he's gonna be watched over for a while.
He needs GPS. I mean, I understand the situation that people are homeless. I do. But that doesn't give everybody a pass to do whatever they want to do.
Can you give me a chance to prove myself before you put me on monitor?
No.
But then, don't I need to pay some residents for monitor?
What I'll do is we'll see if the fees can be waived, but you need to be on GPS monitor. And we can't do a wait and see if you're going to do well or not, because if you're back at that McDonald's, I want to know about it.
Okay.
And the only way to know about that, because you say you're homeless, is for GPS.
So
and do not cut off this monitor. You understand?
So the GPS is just to see if I'm in the area of the place?
Yes. What type of GPS do y'all want? Partial tracking?
None.
Oh, it's going to be GPS.
I believe at least tracking, so that, I mean, if he is homeless, obviously, that he shouldn't be. I think the state's position is that this particular McDonald's, this particular individual was scared for her safety. And I don't know if you read in there, Judge, is that one of the times this happened, an officer was standing with this individual when it happened.
Mm-hmm.
And so that's the brazenness of that in front of an officer is more concerning to the state. You also, Your Honor.
Can I speak on that?
I don't know. Does your attorney want you to speak on that? All right, it's a $1,500 fine. That'll be probated. 7 years deferred adjudication. There's to be GPS tracking. No contact with Tricia Robles. No contact with McDonald's at 101 Alamo Plaza. And you're not to be within 800 feet of McDonald. I'm sorry, you all asked for 500 feet. I think it should be 800. Any objection to it being 800 instead of 500 feet?
I wouldn't know where.
No problem.
Okay. And you're not to be within 800 feet of the McDonald's at 101 Alamo Plaza or Tricia Roberts. I'm sorry, Tricia Robles. There's to be regular reporting by Zoom or in person. Regular random UAs. Proof of employment within 45 days of release. There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors. There's to be a TAP evaluation in custody. My understanding that's 2 weeks. Follow TAP recommendations. Field visits. 1 time per month for 3 months. And then at probation's discretion. Probation, is there anything else he needs? Yes. All right, and then there's 200 hours of community service restitution. That'll be waived if you are able to get a certificate or some type of education from a trade school or somewhere else. You understand?
Yes, ma'am.
Is there anything else you need from the court to be successful?
I believe I'm being released on, I have to monitor.
You are going to be in custody for 2 weeks for a TAP evaluation. Anything else that you need to be successful on this probation?
So I'm gonna be put back in jail for 2 more.
Yes, you are. Anything else you need to be successful on this probation?
Okay, so do I, how about?
Sean, you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that with your attorney? Did you understand it?
Yeah.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Partially.
All right,
So
what don't you understand?
when I'm gonna be released.
What I told you is you're going to stay in custody
Mhm.
for the TAP evaluation. Once the TAP evaluation is done, if the TAP evaluation recommends that you go into inpatient treatment, you're going into inpatient treatment. If the TAP evaluation recommends that you be in outpatient treatment, then you will be released.
Okay, and that could be up to 2 weeks.
It depends.
Okay.
All right, thank you. Stay away from there. You understand?
Yes, ma'am.
Well, there you have it, ladies and gentlemen. Ladies and gentlemen, I bring you from the gallery, Judge Fleischer, from his Wednesday docket before he went on vacation.
Judge, we have an arraignment whenever you're ready.
Yeah, yeah. Come on.
Page 22, Wheeler, come on up.
Give me 1 second. Let me just give me this arraignment done real quick and then we can get it done. Davion Wheeler. Mr. Wheeler, you're charged with possession of marijuana. It's elevated to a class A misdemeanor because it's in a drug-free zone. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews in the state of Texas. If you cannot afford a lawyer, lawyer will be appointed to represent you. Does he reek of weed right now?
Yes, he does.
You reek so bad, I think I'm gonna get high just from you standing in front of me. Okay, please.
Yes, Your Honor, on 4/24, officer at Teeny's Food Mart in Harris County, Texas, saw a defendant making hand-to-hand transactions with an unidentified male. Officer believed the hand-to-hand transaction to coincide with the possession and distribution of narcotics and or marijuana. The defendant observed officer and placed a clear plastic bag that contained a green leafy substance inside the front of his boxers. Wheeler turned around and attempted to flee the scene. Wheeler was advised a dog would be deployed and stopped when he heard the dog barking. Wheeler was detained without incident. The green leafy substance was retrieved from Wheeler's person. The green leafy substance weighed at 0.5 ounces. Teeny's Food Mart is in a drug-free zone.
So this gentleman here was on bond for a case and he not picked up a new case. Did he have the bond conditions to not pick up any new cases? Wheeler. We tell you not to pick up any new cases while you're on bond. Otherwise, the PR bond that you get is revoked and you get put into jail. You were on bond for criminal trespass. You've now picked up another case. And also you're here and you reek of weed so bad, you must have just stopped smoking right now.
Judge, actually, it's the other way around. He was on bond for the PON.
That arrest was out of April 24th, 2024. And
Oh, I see.
He picked up trespass April 24th.
Okay, so we're here on, I thought we were here on the weed case. So we're here on the trespass then.
Judge, because he never, so before he approached this court on the marijuana case, he has since picked up the trespass case. But he was on bond for the marijuana case before he approached here and picked up the trespass.
So I'm sorry, so he's charged with the criminal trespass here, not the weed.
Both.
Both, right, but what, the reason he's in front of me now is for a criminal trespass, because that's the new case though.
It's on both. He's never approached, he's never been here on the possession of marijuana case. That happened April 24th. And then on April 29th, he picked up the criminal trespass. He never approached this court on either case.
I have here that he signed conditions of bond on 4/24, not to pick up any new cases, and now 5 days later, he's picked up a criminal trespass. I mean, am I wrong?
Oh, you're right, yes, April 20th.
No.
April 25th, it has judge's signature, yeah. It says, yeah, the defendant shall commit no crime and shall not engage in conduct that could result in his or her arrest.
It's not looking good for you, Mr. Wheeler. It's Altamirano, right?
Yes, sir.
Welcome back. Mr. Wheeler, I'm revoking your bond and I'm keeping you with me. He goes with you. Can you please appoint Mr. Wheeler a lawyer, and then we will talk about what's going to happen, please? So. What is it? Okay. Do you mind reading what happened on the trespass, Val?
What was that?
What happened on the trespass?
So the trespass, that was 5 days after the possession of marijuana.
Correct.
He was trespassing the same food mart as the possession of marijuana. So.
So he had notice prior to.
Yeah. And then April 29th, it's Chinese food mart, same food mart as the possession of marijuana. Also noticed when the was loitering, approximately an hour later, they came back. They were still there without any attempts to purchase anything. As deputies were approaching the food mart, the males walked off. This male was detained. Officer identified him. Deputy Riley, which was the arresting officer in the possession of marijuana case, 5 days prior, advised that he had arrested this defendant on 4/24 for possession of marijuana and advised David not to return to the location and gave him a verbal trespass warning. They also spoke to an employee of the Chinese food mart. His name is Jasper Guerrero. Who also advised that he told both males to leave the location and they didn't leave. And he wanted to be charged with trespassing.
Okay. Was he here with family earlier? Do you know? No. He may have been here with family. The one that we took him back earlier? So I don't know if you want to talk to mom and stepdad there and back, or outside perhaps, if you want to talk to them and then come back and we can try to figure something out. Okay, tell me. On who? Okay. So what I did was I revoked his bond and I set it at 2501 on each of his cases.
2501?
Correct. I suspect that I speak. He came here high. I mean, he smelled so strong of weed, I almost got high. Not only that, he picked up another case while on bond. But I'll do this though. If he's not able to bond now, after a couple days, we'll talk and I will. Okay.
Then I was going to be her.
Tell me. Is that mom right there? Mom, you mom? Come on up. Hi, thank you so much for coming. The problem is that, so he picks up first a possession of marijuana. We tell him as a court, don't get into trouble. Don't pick up any new cases. If you do, we're gonna yank your PR bond and we'll put you in jail. So not only did he come here and pick up a new criminal trespass, the problem is he's going to these, allegedly going to these store marts and hanging out with other people. And I don't know if they're selling weed or whatnot, but is that what they're saying here? That he's selling weed? And then he comes here reeking of weed too. So if I don't do something, it's going to continue to happen. It's like my child. If I say, hey, you know, if you know what I mean? I have.
I woke my son up. My son was not smoking weed and I smelled weed. I woke him up and got the Uber myself. What you smell, I don't know. I washed his clothes. He did not smell weed. He was home last night. He didn't come here high. I can vouch for that strongly myself. I can also tell you when that camera footage comes, they got my son from across the street, up the street on his way and took him back to the store and set him there. I walked to the store and watched them 30 minutes while my son sat in that car. My son was not on the premises when they got him. I'm not making excuses. He has to learn. He will learn because I won't let up on him. I won't. But the truth.
So how do we curb this behavior then? How do we make it stop?
She's on himself right now.
Say it again.
Battling on himself right now. He's scared. It's not his life. He's not made of this. I didn't raise him this way. I think, honestly, this is enough. Because I told you, I tell him, when they get you, there's nothing mama can do.
I want to punish him. I don't want to punish you. And the problem is that if I put him in there, you're going to pay to get it out. And it's really not punishing him. It punishes you for having to spend the money to get him out. And I don't want to punish you. So what do we do to get through to him? You tell me, because you know him best. What can I do?
Give him a chance. Send him.
We did though.
He has to be in school. He's been slacking on his school, reinforcing school. I want my son to educate. This is last year. Like, excuse me, I'm sorry. My emotions. This is last year. And like I say, this right here is a wake up for him. He needed this. If he doesn't get anything, he needed this. It's a wake up call. I tell him.
Where's he going to school?
Not Decaney, Momentum High off of TC Chester, not too far from our home. Yeah.
So he's been slacking on.
He's been slacking, yes he has. I will admit to that. He's been slacking, but I haven't been letting up. He's been slacking though, and it's to a point where I don't want to be those, but I just don't even have it, you know.
So let me ask you this, because what I'd like to do is, no drugs, no alcohol. He must attend school full time. And what I want is proof that he's been in actual attendance 2 weeks full time in school. And if he don't, then I'm going to put him in jail and I'm going to make his bond extremely high. And we'll use that as bait to get him on the up and up. And I'm going to tell him now that I'm going to test him in 30 days from today. And if he tests positive 30 days from today for marijuana, likewise, he'll go to jail. But you got to be with me on this.
I'm with you, because everything you're aiming at and trying to get him to do is what I've been.
So, but if you tell him, if he knows that you're just going to bond him out, he's not going to do anything. So we have to be on the same page that if I threaten this, you have to be with me, because if he knows that he messes up and he gets out and I put him in and you're going to bond him out, there's no teeth in the threats.
I need your help on this. I want my son to graduate. I really do.
So if I bring him out, I let him out today, you and I are on the same page. That no dope, school full time, he cannot hang out with the same people.
Yes.
You want a curfew? Okay, I can put a monitor on him so I know, do you work? But do you work?
I work.
Okay, good. That way, because when the cat's away, the mice will play. So, okay,
And
All
that's
right.
he's my oldest, so it's a lot of, I have him young, you know, it's a lot of.
As long as you are,
I'm telling you, once I can hold it, it's nothing I can do. It's nothing I can do. And today it showed it. So he's experiencing it right now back there. It's nothing I can do.
all right, we're on the same page. Do you mind bringing them up? So I'm gonna test him 30 days from today. So June 1st, he gets tested. And then in 2 weeks, I need him back here with proof that he's gone to school every day, full time. And if he doesn't, I will put him in jail and I'm gonna make his bond really, really high. But, and then if that's the case, I'm not gonna leave him in there to rot. What we'll do is just a little bit of jail therapy, 2 days in there, so he gets the message. And then if he messes up, which hopefully he doesn't. Okay?
I'm a bad kid. I honestly feel like he'll get it.
I will give you my card. If you have any issues, you can get a hold of me or Sonia knows how to, and then I'll put the fear into him. And hopefully we can get him to graduate. For sure. You tell me, do you want 9 p.m.? 9 p.m. curfew? Yeah.
Dark? I don't eat after 8, so I'll be sleeping.
Do you want me to keep you? You need to make a deal with me right now because you've been failing me over and over, and I'm not going to do it again. I am putting you on severe conditions now. The only reason that you're not going in right now is because of your mom. But I'm going to tell you now, Mr. Wheeler, you muck with me 1 iota, I'm going to make your bond so high, you're going to flip and she's not going to get you out. You will be stuck like Chuck. Do you understand? You are going to go to school full time. And I want proof in 2 weeks that you've gone to school every day from 8 in the morning or 7 in the morning until 3 when it lets out. And if you don't go to school one day, I'm going to homeschool you myself in the jail. Do you understand? No more smoking weed. I'm going to test you 30 days from today because weed stays in your body for 30 days. I will test you on June 1st, where it should be out of your system if you don't smoke from today on. If you smoke after today, you are guaranteeing yourself a jail stay. Do you understand? You are not to have any communication with any of the people that you hang out with at the store, and you're not allowed to go back there. And I'm putting a monitor on your ankle so I know where you are at all times. So I will know if you're at school or if you're toying with me. Do you understand? And I'm giving you a curfew from 9 p.m. to 6 a.m. You can either have it this way or you can go to jail. What do you want to do? If your mom tells you to jump, you better ask how high, because you give her one problem, I will put you over my knee and I'm going to spank you like a little child, but I will do it with a ton of jail time. Do you understand? I'm not playing games, and I'm tired of your behavior. And I'm going to give your mom my card so she can call me directly if she ever has any problems with you. Do you think she wants to be here? Do you think she wants to be in court? She could be at home making money, but now she's got to spend the next 5 hours spending money coming downtown on multiple occasions, pay for parking, because you act like a knucklehead. Not only that, if you don't graduate from high school, have you seen all the people back there? You know what they are? Children that never grew up. People that have no self-control. That's what we have back there. They will amount to nothing for the rest of their life. They will never have a pot to piss in. They will never have money. They'll never go on vacations. They'll never buy a Lexus, a Mercedes Benz. They'll never go to Fiji. That's what life is about. Life is about buying nice things, going on expensive, lavish vacations, not going to court over and over. You understand, Mr. Wheeler? This is the only chance that you have with me. You can either make it and do with it well, or I guess I'll just play with you over and over. The choice is yours, but you only get one choice. You'll never get another shot with me. You understand, sir? All right. Mom, here's my card. If you ever need anything, you get in contact with me and let me know how he's doing. And I want you here in 2 weeks to show me where you are in life. And I promise you, in 30 days, you'll get a drug test. All right. Thanks, Mom. Thank you, son. I'm gonna say something else. Eddie?
Page 8, Harrison, come on up.
We have an arraignment real quick. LaDarren Harrison. Mr. Harrison, you stand charged with the offense of criminal trespass and terroristic threat. You're facing up to 6 months in jail and or a $2,000 fine on both of your cases. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews with the state of Texas. If you cannot afford a lawyer will be appointed to represent you, sir.
On the 4th, April 5th, 2024, officer were dispatched to a leasing office in Harris County, Texas. Officer arrived and met with CW, who stated that individuals had forced entry into vacant units of the property. Deputies ID'd suspects and issued them criminal trespass warnings. Later in the day, defendant returned to the property leasing office stating he left money inside. Defendant became aggressive towards staff and threatened to kill a male for refusing to allow him to re-enter the unit. The staff was afraid and state that the defendant was wearing a bag and reaching into it while demanding to be let inside on April 8th. While deputies were checking, the complex maintenance staff flagged officer down, stating the defendant fled on foot from a vacant unit. The deputies located the defendant on a nearby roadway. Defendant was detained and transported. I'm not sure, I believe this was a juvenile offense, 2016 bird of habitat, 12 months to 314, I believe this was saying.
So he has a burglar of a habitation as a juvenile?
I believe that's, am I reading that correctly?
I can check it out. What was it?
Yeah, that's
Harrison.
Harrison.
Big one, Harrison?
Yes.
Okay. What was the question, Judge?
At the bottom of is that a juvenile offense, 2016 bird?
Yes, that's a juvenile offense, 2016 bird cap, 12-month probation out of the 314 court, and then he has another criminal trespass out of this court in 2024. That's his history.
Mr. Harrison, let's go through your history. In June of 22, you picked up a criminal trespass. I had to revoke your bond on 4 different occasions because you failed to appear. In August of 22, you picked up an evading arrest, and I had to revoke your bond 4 times because you failed to appear or violated conditions. Now you've picked up another 2 cases, and you failed to appear when you were supposed to the first time, and they gave you yet another free bond. Tell me, why should I not just put you in jail for your multiple failures to appear?
I'd be trying to get to court, sir, and it'd just be hard for me because I'm homeless. So it'd be hard to get to court. But I'd be really trying to get to court.
Where are you living now?
I'm in motels.
How old are you?
I'm 23. I really don't got nobody like this, sir.
Do you have any parental figures?
Yeah, I got my mother. She stays in Conroe. Like, I'm thinking about moving out there with her, trying to get my ID so I can get a job.
Why wouldn't you? If it's a stable place to stay, why wouldn't you do it?
I don't like stressing my mother like that.
Come on. Or is it more that you want to do your own thing and she's not liking it?
That's not it.
I'm not playing this game with you. I'm not going to do it again.
Yes, sir.
I'm going to give you a lawyer today. But if you ever fail to appear, I'm telling you now, I'm going to light you up and I'm going to make your bond so high you will not get any more PR bonds at all. You must appear in court and I will not let you play this game again.
Yes, sir.
How long did you spend in jail for the first 2 cases? Was it quite a while? Is that what you want to do again? And don't fail me again. Do you understand? Can you reach out to the MAC for Mr. Harrison, please? I'm going to have you sign a reset, and then I'm going to have you take a seat in the jury box. You will never get another free bond, Mr. Harrison.
Okay.
I want to, when we get the lawyer for Mr. Harrison, have a powwow with the lawyer to figure out what we're going to do to get him situated so he's not homeless anymore. So he's not allowed to go anywhere yet. Hey, of course.
Mr. Harrison, you want us to approach? I talked to him, he's gonna move back to his mother's house in Conroe. So he has a stable place to stay instead of living in motels.
That concerns me.
I know.
Right, because the motel gig, it's just not working out well.
But a night is not what he needs to be spending his money on.
So it's come up.
No. 25 in New York. 25 in a flea bag. No one night stand.
You know, it's probably sucks to live with mom because she probably has rules, right? I know, but it's a small price to pay to have a roof over your head. It really is. Living in a motel at $60 a night in the kind of motels that you're living in for that, it's got to be even worse. You have a lawyer. I've given you a lawyer. All you have to do is stay in contact with Carl. And if he tells me that he's in contact with you, then I won't have a problem. The only thing I'm asking you to do is don't pick up any new cases. Be nice. It's not hard. The terroristic threat, who is it against?
Terroristic threat was against the maintenance man at the apartments where he was sheltering at one time. That's where the
So
that came from.
I don't want you to go back to this place, okay? I don't want you to be in possession of weapons. The only thing I'm telling you, I'm not asking you to split the atom. All I'm asking you to do is stay out of trouble. Don't have any weapons and be nice to your mom. Say that again?
Don't disrespect my mother. We got a good relationship.
It's great because you know what? You need to focus on your future. That way you don't end up with a number on your back for the rest of your life. Mr. Harrison, it only gets harder. It doesn't get easier. You get bigger, fatter, uglier. You lose your hair. I'm telling you, it gets worse. If you don't set yourself up now, you'll have no money for the rest of your life.
Yes, sir.
Did you graduate from high school?
No, sir. I'm trying to go back to school.
No, you will. I am now making it a condition of your bond. I want you to get into school. I want you to get your GED.
Yes, sir.
That's now a condition of his bond. Get into school. I want proof. I'm giving you 2 weeks. I want to see what you've done. I'm telling you, I'm going to keep you so close to me.
He's 23 years old. He's got to get a GED.
Yeah, well, that's what I'm saying. I want you to go get your GED. I'm making that now a condition. I want you back here in 2 weeks to show me what you've done to get it. So go online. You have access to a computer.
Source of something. I can go to the workforce or something. Work source. Use their computer.
I don't know if WorkSource is gonna give you a computer to do some.
Go to the work. Mother has a computer.
Your mom doesn't have a computer?
Lives in Conroe at RV Park.
How can we figure this out? How can we do this?
He didn't have a computer.
Mr. Harrison, take a seat for me for a second. I need time to think.
Because he's got a phone, so he can call and.
Say it again?
He doesn't have a computer, but he has a phone. So he can call to find out where he gets lined up for keys.
What kind of phone is he on? What kind of phone does he have?
Judge, I don't know. He says.
Mr. Harrison, what kind of phone you got? Is it, it's a smartphone, right?
He's got a smartphone that he can access the internet.
Unfortunately, you can't really do a lot of programming.
Right. But you can contact us.
Yeah, that's what
No, but on a smartphone, you should be able to access and,
the library of the town.
hold on, I'm gonna, you know what, I'm gonna get in contact with Natalie Ware and see what I can do.
Okay.
Just give, can you give me?
Sure. I'm gonna go to court and break and I'll be back.
Go for it. For him, can you file no going back to the place, the apartment complex, no contact with the complaining witness, no weapons, and get a GED? Okay, let me deal. Carl's here. Carl.
I'm here. Yes, I'm here.
Okay, come up, Mr. Harrison. You know, in life, there's a reason for almost anything. The last two cases you had problem to the tune where I had to revoke your bond, like I told you earlier, 4 different times, and I had your bond at 5,004 on both. That tells me that I had to revoke it at least 4 total times. And now I think I know why. I sent you for a drug test and you tested positive for cocaine, meth, amphetamine, marijuana, you don't have to apologize, nothing. But we're going to do this either the easy way or the hard way. How that happens depends on you. It stops now. So, because it only stays in your system a couple days, I am now forced to have you come here on a weekly basis to test with me. And I'm going to tell you now, the first time you test positive, because I'm going to have you sign an affidavit with me today, promising me that you're not to use alcohol, marijuana, methamphetamine, or cocaine. And the first time you test positive, I'm going to revoke your bond. I will put you in jail. And then I'm going to put you in an inpatient rehab facility that is at a minimum of 9 months of your life. And that's if you respond well to treatment. It's a minimum of 9 months. It can be for a year and a half if you really battle. So you can either take care of these demons on your own. If you can't, I will do it for you. Promise you that you're not going to like the way that I do it. You understand? You will be back here every Monday and Thursday to take a test.
Yes, sir.
The first positive, I don't care about the weed. As far as from today, today's May 1st. For me, the weed stays in your system 30 days. So I know that you're going to test positive the next couple times for weed. After June 1st, if you still test positive for marijuana, that means that you've continued to smoke and you go to jail. As far as any other drugs concerned, you ever test positive for any of the other, in jail you go. And you know, you have no one that's going to post your bond, so you will be stuck like Chuck. You're here with Carl, so you know that you're not alone. Carl.
Yes, Judge.
I guess we'll just do it this way. You know, I had a feeling, and so we'll see. We'll see if he can stay
Okay.
clean, huh?
I've already submitted to the MAC Social Services a request for assistance on the GED portion. And so, and also possibly for temporary housing, just in case his mother doesn't accept him back.
Sure.
So, Mr. Harrison, you need to keep in touch with me. I sent you my email address. I sent you my cell phone number. I sent you my office phone number, and I sent you my office address. So you know how to get in contact with me almost as good as my significant other. Okay?
Yes, sir.
So just make sure you keep in touch with me. And as soon as I hear something back regarding that GED and you getting enrolled on that, I'll let you know. But in the meantime, we're going to plan on you're planning on moving back to Conroe with your mother. If she won't have you in, then I've already reached out to social service to possibly see about some type of temporary housing for you.
Yes,
so
sir.
you have no excuse. You have no excuses. You got to fly and do right.
Yes, sir.
Okay?
Mind over matter. You can achieve anything if you put your heart to it. There's no excuse. I'm telling you now, you're digging yourself a grave that's going to affect you for the next 40 years of your life. All right. Come on.
See you Monday.
Thanks. Thanks, Carl. Thanks.
Thank you, Judge.
And then I think we'll need pre-trial to amend the conditions for Monday, Thursday testing. So he'll have
So
a
he'll have to stay until we get pre-trial. Okay. Thanks, Carl. Appreciate you coming back.
No problem, Judge.
James Summonek versus Travis Ackerman.
Attorney Tom Ellis appearing on behalf of the plaintiff, Your Honor.
Travis
And
Ackerman.
that's
and Nikki
Ackerman and Meltzer.
Yes, Your Honor, that's correct. You have Travis Ackerman and Nikki Meltzer representing themselves.
Okay, very good. All right. What is the claim in this case? How much is owing, inclusive of cost, Mr. Ellis?
According to our complaint, Your Honor, we asked for $5,743.80, but we are giving him credit for some propane that's in the tank. So he's going to owe approximately $1,150 less. $1,150 is a credit.
Your Honor, may I ask, this is news to me. This would be
Okay,
news to me.
hold on. Folks, hold on a moment. I need, Mr. Ellis, I need to know what's owing or what plaintiffs are claiming are owing on the account as of today, including court cost.
$4,750 approximately.
That approximate figure again. All right.
Your Honor, may I ask a question?
Sure.
We so on the propane tanks, we have evidence and pictures of the readings and the levels of the tanks and can quantify the sum down to the amount owed based on what Mr. Samanak had paid per gallon. The current levels of the propane as of when we left the property on April 30th were there was just under 60% in one tank. There was just under 70% in another. So the full usage of the propane did not take place. And I do have concerns that the amount of money they're sharing does not quantifiably add up to what would be owed in relation to that per gallon rate.
In addition to the rent that they're asking us to pay, we've already paid our rent per an agreement with Mr. Samanak for a prorated rate of rent for February, March, and April, as long as we're out by the end of April.
And this was on the basis of a violation of our lease agreement due to non-repair of, and I have evidence to show pictures of a history.
All right. All right. Hold
Yes,
on
sir.
a moment, folks.
Yes, sir.
This is the first
Yes, sir.
hearing. Okay. All right. Take a breath. All
Yes,
right.
sir.
Because I wasn't there and you're giving me a lot of information. Okay.
Yes, sir.
So
Your Honor, it's a lot.
Counsel, as I'm looking at the complaint, there's $3,023.80 for propane.
That is correct, Your Honor, but we'll give him
So
a
I guess here's what I'm asking. What I'm asking is, what is the rental amount that's due? And then what's due for propane?
$2,420 is owed in rent. And the
Two
propane,
thousand two. 2,240
yes, sir.
for rent. Okay. And then, so if I were to subtract basically the 4750 approximately that you gave me, the rest of that is propane
Yes, in our complaint,
and court costs.
the court costs were not added in there, I don't think.
All right, fine. Then it's just propane. We'll worry about the court costs later. All right. So
$2,182 is owing for propane.
$2,180 for propane.
Yes.
$1,400 has been paid to Mr. Samanak. I can confirm 500 in January, 500 in March.
Sir.
Yes, sir. I apologize. Yes, sir.
Thank you. All right. What payments have you recently received? Has your client recently received, Mr. Ellis?
Originally, approximately 6 weeks ago, my client agreed to reduce the rent if they pay up the back propane bill. And payments were made of about $1,400. But that did not pay up the total back propane bill. And so the defendants are not entitled to any rent reduction because they didn't follow the agreement.
Your Honor, may I make a statement here? At no point in time was this
Have I
agreement.
been able to stop you? But go ahead.
Sorry, I'm so sorry, Your Honor. At no point in time was this agreement ever predicated on the payment of the propane. It literally, in any communications with Mr. Stamanek, that was not conveyed. I have interactions. His son-in-law, Harvey Proctor, actually came to pick up the money for this prorated rent. And I have text messages showcasing the process of, hey, this individual is going to come over to collect this money.
All right. So folks, let me just ask you this. You're currently out of the property.
Yes, Your Honor, we are, as of April 30th.
Okay, so possession isn't an issue. The issue is how much rent owed and how much of that is owed for propane.
Correct.
Right?
Yes,
Can I ask, was there a written lease or written agreement regarding the propane?
Yes.
In the lease, it does say that the tenants would need to pay the full balance of the propane by December 31st of the year. And we talked to Mr. Samanak, since we will be leaving in April and not the end of the year, that we would check the propane levels once we left the property and pay him the balance that we used for the propane from January 1st to April 30th.
We also have witnesses. Mr. Samanek has visits to my.
You know what?
Yes, sir.
You can keep talking, but I don't know why it is. I understand her a whole lot better than I understand you.
That's totally fine. I'll let her do a lot of the talking.
What she said to me makes absolute perfect sense. So, I mean, it makes sense in terms of something that could have happened. I don't know if it did or not, but I get it.
Yes, sir. Yes,
but
sir.
My bigger problem is I don't have, was not filed with this. I don't have the written agreement that is it Meltzer?
Yes.
Meltzer?
Yes.
Meltzer.
I don't have the written agreement that she's referring to.
So it's
That
in
was not filed with the court.
Apologies. It's in their original lease agreement that we signed with Mr. Samanak back in December.
It's okay. It's okay that I'm just letting the parties know I don't have that. I'm taking your word for what it says, but I just don't have it.
Yes, sir.
Yes, Your Honor.
All right.
I am happy to read that to you if you need to.
Okay, all right. So we're not gonna be able to resolve this today. So obviously there's a dispute between the parties as to what this propane bill is. And then let me ask you this, outside of the propane, do you believe that you owe the amount of rent?
No,
No,
sir. Due to the agreement that Mr. Samanak and I and Travis made on the phone in January 19th of 2024, he agreed, since he has violated our lease by allowing multiple people onto our property without our knowledge,
in violation.
and after we have asked not to have that happen in violation to our rental agreement, section 9 of that, I know you don't have it, I apologize,
It's okay.
that technically the only people allowed on our property is the landlord or people doing repairs. It does not state that what we were living on was a working farm and that men will be in and out of our property multiple times a day. That was never disclosed to us. We asked him very kindly multiple times. This has started
Okay.
a month
I'm gonna
after we-
stop you. I'm gonna stop you there because you're
Yes,
probably have to gonna explain that to me again. But here's what I'm gonna do, folks. Possession isn't an issue. It looks, quite frankly, like this is just gonna be math. So in terms of setting it up, I'll hear everybody's story, but what I'm gonna do is I'm gonna set this for a final settlement conference Tuesday. For May 14th, 2024, 9 a.m.
Okay.
That proceeding will be in person at the courthouse.
Okay.
Bring all of your paperwork and everything so that
Are
I
we
can
allowed
look at
to-
it and I can refer to the provisions. You said something, ma'am, I'm sorry.
I'm so sorry. Are we allowed to bring witnesses to this?
Okay, what are they going to be witnesses of?
So his parents are good friends with Mr. Samanak, and he has even stated that we are paid up on our rent. They have text messages between them paying the propane balance of $1,400.
Okay,
all-
look. Here's what I'm gonna do. You can bring whoever you'd like. Whether or not I'll be able to hear from them at that time, I don't know.
Understood.
But as between the parties, I've got to get I've got to get everybody to agree on what issues we would be litigating. So it may be from this final settlement conference, I will set a trial date at a later time where I'll hear the testimony. All right, but you can bring whoever you'd like. I'd suggest that you make sure to bring all of the documentation that the parties have regarding everything.
Yes,
Well, not
sir.
everything, but anything relevant.
We have a
May
full-
14th. Pardon?
We have printed copies for you, and we also have an iCloud link if you would like that at any time.
Okay, all right. You can always send it to the court for filing with the court, and then I'll take a look at it at some. Okay?
Okay.
Thank you, Judge.
Mr. Ellis, anything else?
Nothing further. Thank you.
All right, we'll see everybody on the 14th. Thank you.
Thank you.
James Husa versus Stanley Zarwicki.
J. James Hasanaw, Your Honor.
And I have Christina, but I don't know. I don't have a last name. There are no attorneys. Are they here?
I am.
Plaintiff is here.
J. James Hasanaw is here, Your Honor.
I am here. Stanley
And the
Zarzicki.
property manager is also here.
All right, who is Christina?
She's my girlfriend. She's out of town.
All right. This is a non-payment. They don't even have type of action on this case. Is this a non-payment or a termination case?
Termination, Your Honor. There
Was there a lease?
No, there was
there a
not.
lease?
No, there was not. Mr. Zarlicki was asked to do some work at the 62156 6 Mile. He was given some keys in order to do that work. And he just kept the keys and moved in. So we're looking for a trespassing and termination.
Is that correct, sir?
No.
Well, how did you come into the premises?
The original agreement was that the house didn't have a furnace, hot water tank, and a bunch of other stuff. And the original agreement, which was verbal, was that I install the furnace, all the duct work, the hot water tank, and do some work here as I'm able to live here. And Mr. Hazenaw knew that that was the original agreement. And then he even, about with the gas, electricity, or he had it in his name.
Okay, how long have you been here? How long have you been there?
Since actually physically staying here since middle of November.
Sir, is that correct?
I don't know exactly when he started staying there, but he was supposed to have done the work by the end of last August. And it hasn't.
Okay, well then how long have you known that they've been in the premises?
Since at least the middle of September or beginning in August, actually.
That staying in the premises?
He started moving in a lot of stuff and
Didn't ask that.
How
long have you known that they've been staying in the premises?
Since the middle of September of 2023.
And you gave them keys?
In order to go into the building to do the work, yes, I did give them keys.
Yeah, but then you knew they were staying there.
No.
I didn't realize that he had actually was staying there. He was supposed to have been done like by last August, and he didn't finish the work, so I didn't really monitor what was going on there. But a gentleman named Eric was supposed to be having a room there, and he said that Stan had moved in and had moved his dogs and had moved his girlfriend Christina in as well, and that they were living there. And then Stan finally said that he was living there. He told me he wasn't living there, and then he said he finally said that he moved in.
But you gave him keys.
I gave him the keys in order to go into the building.
He's not a trespasser, sir. He's not a trespasser.
Can I interrupt for a second?
You already have.
I'm sorry.
Here's the problem. Unless you're going to be able to establish to me that he's indeed legally a trespasser on the premises, based upon what you told me, he's not a trespasser, he'd be entitled to notice of some type to the premises. So you got two options here. You can dismiss the action now and then send a notice and refile, or you can go ahead and we can litigate out whether or not he's a trespasser, and I'll make a legal ruling on it. Which would you like to do, sir?
Just a second, Your Honor.
I'm here.
Amanda, did
Yeah.
we give him a 7-day? We never gave him a 7 day, right?
No, we didn't.
Okay. You feel he's not gonna qualify as a trespasser, Your Honor?
I've not made a legal ruling. That's why I was asking the questions that I was asking. Doesn't seem to me that he's a trespasser. It seems to me he came into the property under some color of right.
Also, Your Honor, I'm sorry.
Go ahead. What do you want to say?
Also, if I was an actual trespasser, why would Mr. Hazenaw ask me to put the utilities in my name? The electric is in my name, but the gas, they won't put it in my name without a letter from Mr. Hazanoff. Why, if I'm a trespasser, why would I do that? I'm not a slum person. I'm not a bad person. I got a huge heart.
I don't know that anybody's saying that, sir.
Okay.
Did you, sir, did
It
you
sounds
have
like
them
we're
put
gonna
the-
have to
Sir,
serve
I
him.
can, sir, did you
Yes,
have
sir.
them put the utilities in their name?
I asked him to do that. He wouldn't do it. And so then I turned off the
So
gas
why,
and I
if they
turned
were
off the electric.
trespassing, sir, if they were trespassing, why would you have them put the utilities in their name?
I didn't. I told him I was gonna turn them off. And so then he went and had the electric put in his name and they wouldn't put the gas in his name.
No.
So why, if somebody's trespassing, why would you do that?
Why would I turn the utilities off so that he
Why would
move
you
out?
even have a discussion about the utilities going into their name? These folks aren't
Because
trespassers.
He used to be a resident in one of my other homes. I had to evict him from there. I gave him a second chance on this home. And he hasn't paid. He hasn't
They're not
done the work.
trespassers. Bottom line, they're not
Okay,
trespassers. They're
fine.
going to
We
be
will-
entitled.
We will dismiss this case. We'll send
Case
him a
is
file.
dismissed. Court lacks subject matter jurisdiction. Thank you.
Thank you, Your Honor.
Thank
We'll
you,
be
sir.
back.
How about them apples?
Court calls case of the people versus Jonathan Gibson. He's back again.
Mr. Canata for the people.
Julie Gaines, Senior Assistant Public Defender, with and on behalf of Mr. Gibson.
Again? He's on every docket I have. All right, what are we doing on this one?
Your Honor, we have a new victim in this matter. There's going to be an automatic.
Because he took his other pleas yesterday. All right, I do have before me a plea form. Indicates the defendant will be pleading. So I'm trying to make sure I'm reading this. There are counts 3 and 4, both retail fraud second.
Correct.
All right. Those are offenses punishable by up to 1 year. Upon a successful plea to counts 3 and 4, count 1 and 2 would be dismissed.
Correct.
All right. And then, so he pled to like, I don't know how many yesterday before me. And so then there's an agreement that there's a case out in 1483 or 4 that he'll be pleading to a reduced charge of retail fraud third with restitution in that case of $1,143.82. So that was a retail fraud that was separate and apart from the ones from yesterday. Got it. That's of course full understanding of the area.
That's good.
All right. Okay. Gibson, you know the routine. Raise your right hand.
God, I swear, for testimony about the gives you. Oh, yes, I do. Be Jonathan Gibson.
All right, sir, it is this court's understanding you're going to plead no contest to 2 charges of retail fraud in the second degree. Those are misdemeanors punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that?
Understood.
All right. You understand what a no contest plea is? All right. 2 things I have to explain to you about a no contest plea. First thing is that it means that you're not further desirous or wanting to contest this charge, these charges. You understand that? Second thing is that for purposes of sentencing, the court would treat you the same as though you had pled guilty. You understand that?
Yes, sir.
All right. Understanding and the basis for the no contest plea, Ms. Gaines.
Yeah, Mr. Gibson has indicated lack of recollection.
Okay. So, sir, to the charge of retail fraud, second degree, as contained in count 3, how do you plead? To that same charge as contained in count 4, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind. All right. You had signed an advice of rights form, is that correct? Any question regarding any of those rights?
No.
Look at paragraph 5 if you haven't memorized it already. Those are your rights which are part of a trial. You understand that by pleading no contest, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal, right? Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead to these? Anybody threaten you or coerce you?
No.
Doing this voluntarily?
Yes, sir.
And of your own free will?
Yes, sir.
Court has been provided and has reviewed this is Ann Arbor Police Department. Ann Arbor report. Oh. The right report in this one. No. Right down. Folks. Which report do you have? What's the case? Yeah, this. Okay, I was wondering because I have Ann Arbor report on the drunk driving.
I'm happy to provide my copy.
Okay, if I can just take.
2 pages on one side.
That's.
And
Okay.
I have to take off my glasses.
I didn't think so.
Okay. There you go.
I apologize.
Wrong one. Okay. Did a scheme. This makes a lot more sense. I think actually I saw this one, part of this one yesterday also. All right, got it. All right, court has been provided Pittsfield Township Department of Public Safety report for their case 21, is that 589? Yeah, 589. There being no objection to the court reviewing that, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of these offenses. Counsel, have I complied with the court? Court will accept the defendant's plea of no contest to counts 3 and 4. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing will be.
May 22nd.
That's what its other ones are too, right?
I'm sorry.
That's what its other ones are.
Yes.
Yeah, that we set yesterday, May 22nd, 2024. What time?
9 a.m.
9 a.m. Before me.
Your immediate response, please.
Yeah, go ahead.
Mr. Gibson has indicated that he has a personal repentance in this matter. That for this matter as like.
All right, can I just stop you? Yesterday, Ms. Perny was addressing bond on his other matters. And what I indicated, because she was bringing up this case, and I think there's another case that's out of 1434. What I indicated is, folks, get them all together, give me an order that everybody agrees on that I can sign off on, and I don't have a problem.
Thank you.
So unless you want to talk to me about it, Ms. Perny was supposed to be working on preparing an order regarding all of it.
We will work together. Mr. Mr. Gibson just wanted to make sure that I was getting everything done and all.
He was worried about you getting everything done?
More so, he is anxious that everything is done correctly because he's, yes, and he's not understanding much. So what the judge is saying.
He didn't understand that?
Sign an order changing with regard to.
Remember, we were trying to yesterday, the issue became trying to coordinate all of your cases because you can't do something in one spot. So we were trying to coordinate all of your cases once you had done what you had done. And then they were going to present to me an order that everybody agreed upon with the tether, remember?
Yeah, I'm sorry. I thought this was all that when we agreed. I think it's all.
Well, no, I hear you. It kind of is, but the cases yesterday we took care of. Then you have this one. Then there's one more that's out there because you probably traveled over into SIO. That's not my case. But it is part of the plea agreement.
Yeah, I think just this charge right here is what's having me out of tether before being released.
So now you want to advocate on your own?
I believe this charge is done.
So what the judge is saying is that our office should work with the prosecutor's office and present him with a written order with our prosecutor's agreement that we be allowed to be released and work within 24 hours to have the tether placed on. So that's what we're going to work on. So I will write that out.
Say yesterday.
So because
you don't know what, Miss? Hey, don't. No, no. You know something, Mr. No. Hold on a moment, though. Miss Gaines is very patiently trying to explain what it was. It was the same thing that I was telling Miss Perrine to do, but we had to wait for this case for today. When Miss Gaines was just explaining to you, don't you ever just wave her down like that. Do not ever do that in my presence to Miss Gaines. Am I understood, Mr. Gibson? Bond will continue at this point. Thank you.
Looking at papers, shuffling papers.
This is the time and date for sentencing in the matter of People versus Kyle Thomas Miller. Mr. Miller was charged with larceny over $1,000, but under $20,000, and a misdemeanor larceny of over 200, but less than 1,000. The felony charge was dismissed, and Mr. Miller pled to larceny 200 to 1,000 on Monday morning, March 18th. And I wasn't clear exactly what happened. So I set the matter for sentencing for April 29th and watched the videos and tried to read the police reports. There were multiple videos. There were surveillance videos, police investigation videos, scene videos. And so I had a chance to get a sense of what it was that was at issue and read the report. So at the time of sentencing, then I learned we were talking about more than just scrap metal out of a recycling bin, but an expensive to replace heavy metal dock plate. At the earlier hearing on March 29th, March 18th, Mr. Miller told me that he took the stuff out of a dumpster. He said the stuff was in a dumpster. And I said, well, it wasn't a dumpster and it wasn't your dumpster. But then he acknowledged that he took the plate and loaded up with a winch. So we got over that hurdle, but he contended that he had permission somehow from the owner of Clark Logic, Jamie Clark, to take this, which I frankly didn't believe. He also denied that he told the officers that he had permission from Jamie Clark to take it. So I wanted to hear from Officer Greenhalgh or Holcomb, whoever the officers were, and Jamie Clark. Mr. Clark is the owner and operator of a multi-million-dollar business known as Clark Logic. And I know him, and I'd hope to get some information from him. So I continued the matter until this morning to get that further information, and it doesn't sound like we're going to get it. What I was hopeful for that was Mr. Miller would just acknowledge responsibility. But there's always an excuse. There's always, oh, we didn't understand this. Somebody didn't under this. I was hoping you just look me in the eye and tell me what happened. But when we were here on the 29th, you said, well, I never took anything out of a dumpster. No, yeah, April 29th. So I looked at the earlier hearing where you did tell me you took something out of a dumpster. And your position is still somehow that you didn't tell Officer Greenhalgh you had Jamie Clark's permission. And then you said you did have Jamie Clark's permission. They had seen it on the surveillance video. Your vehicle is distinctive. You run a handyman business, and it's the kind of vehicle that would be for that. It had ladders on the side, and you had a trailer. One of the employees of Clark Logic saw you at Little Caesars and took your picture. And I think you realized at that point that there was something going on. So at some point you called Clark Logic, gave your name and number, and it went on from there. So anyway, I'd hoped to hear from Jamie Clark what happened. Melissa, did anybody talk to Mr. Clark again?
No, Your Honor. I did review the police reports again. I watched the video evidence as well. I think it's clear that Mr. Clark did not give permission to this gentleman to take anything. I think that's been clear from the beginning. I know that maybe this isn't the largest theft that Mr. Clark's dealing with. We've had a string of these issues, which is very concerning, especially with the scrap metal, but this plate was very expensive. The officer that called and spoke with Mr. Clark is a longtime officer that if he states that he spoke with Mr. Clark and Mr. Clark says, I know who this gentleman is and I did not give him permission, I think we have that. It is concerning. The defendant did not accept responsibility at our prior sentencing. The staff indicated in the video that these items weren't just out by where the trash would be. These were, the plate as well as the dumpster were kind of set back and behind a different little building. So, it's not just right out on a curb or something like that. So, I think Your Honor has the right understanding of how this case went. He's not so far accepted any responsibility and is misrepresenting what happened. I think if there was allegedly any type of understanding or miscommunication between the defendant and Mr. Clark, that again, the defense could reach out and, maybe re-question that. But I think it's clear from the report itself. It's not just, I don't think I told him. There was absolutely no permission to take this.
All right, that's the prosecutor's position. Ross, what's your position?
Well, Your Honor's correct that there was a lot of justification and explaining away things at the last sentencing hearing and even at the plea hearing. I believe, though, that this adjourned sentencing with the jail hold that was placed it's kind of given Mr. Miller some time to reflect more effectively on his role and his misconduct. I hate to have to prosecute my own client, but he went there under the dark of night and removed property that was not his. And he's understanding that that is a problem. I don't think there is any more dumpster diving nonsense, any more idea that this was somehow justified. As Your Honor seen in your long career, folks, especially in larceny type situations, will wrangle around and wiggle through to try to justify why it wasn't really thievery. And I think there was some of that going on. But I think once Mr. Miller had a chance to sit alone and understand that this was a theft, this wasn't a misunderstanding. He is now contrite. I don't believe there is any longer a desire to try to explain away. One of his concerns during this period he's been incarcerated is his own shop. And I think that shows, you know, he's got a shop on the south side where his business tools are. And a big fear of his is somebody going in and taking his valuable tools. That kind of shows to me some sort of progress and understanding of property rights, the right to be secure in your possessions, and that it's a two-way street. So I would ask Your Honor to view the jail time that's been imposed pending this second sentencing and the prior memorandum from the prosecution and not order any further jail time.
Mr. Miller, what would you like to say at this point? Anything you want to tell me?
I messed up. I shouldn't have done what I did. I was wrong in what I did. Now I'm just trying to make up for it. I shouldn't have.
And you didn't have Jamie Clark or anybody else's permission to take it?
No, sir. No.
Well, we could have saved a lot of time. Ross is right. He hit the nail right on the head. People often, when they're charged with larceny, they'll admit stealing some of it, but not all of it. It's like they want to retain some dignity, and when they really did all of it. And this had been your pattern, is always to not quite accept responsibility. It's like, I did it, but as you know, I didn't really even want to do this one. I talked to Judge Pattison about it this morning. He said, I told that guy if I saw him again, I was going to give him a bunch of jail. So maybe it's lucky you don't have Judge Pattison. But your friend is here. She's been here at every proceeding, so you got that going for you. But Melissa, is there any restitution?
No, Your Honor,
I
this
didn't
is.
think so. It was recovered.
Yeah.
Other than the headache of it.
Yep.
And we didn't have to drag. In fact, I was going to call him up. If he didn't acknowledge, I was going to call Jamie Clark and ask him what happened, but we didn't have to do that. If that had happened, you would have got a lot of jail time. It isn't that hard to say, I messed up, I did it, and I'd like to go forward from here. And it isn't just you. I do this all the time. I try to get all the way down to the kernel of the truth and acceptance of responsibility. And the irony is, You're afraid that somebody like you is gonna come steal your stuff and sell it to these crooks that are fencing this stolen property. I hope it doesn't happen, but you know who's out there. I canceled your bond on the 29th. Today is the 3rd. What do they show as your jail credit? I think your lawyer's wise too. Your acknowledgement of responsibility is the difference between 10 days in jail, credit 4. You might have another day up front. Credit 5. Leaving 5 days to serve less good time and 90 to 180 days. If you had stuck with that story and I called Mr. Clark and he said no, he would have been mowing lawns at the jail this summer. 5 days credit, 10 days. You got a few more days minus good time. Fine is 0. There's a $75 crime victims' rights fee, a $50 state minimum fee, and a $150 attorney fee, which is $275. Make that due by June 15th. When you get out, I hope you're not like looking for the next scam or something. You got a business going, maybe you could make it as that, but you got to have a good reputation, not a bad one, to grow a business. June 15th. All right, Mr. Miller, you're good to go.
All right, you ready? Let's roll, nerds.
All right, page 6, Grolski. Come on up.
Said Groholski?
Yes, ARO.
Judge, can I bother you? Mr. Casares is here to sign the MOA.
Yeah.
He already signed. If you could just sign
Yeah.
so I can get a right and give him a copy.
Got it.
Thank you.
Yeah, it was that in the bond conditions, right?
Yes, I got that.
Okay, got it. Signing it now. What page did you say?
Page 6. Casares, Raul.
Good morning, Mr. Groholski.
I'm sorry.
Sir, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir.
Yes, sir.
Yeah.
On October 23rd, 2024, the officer made contact with the complainant who stated he had a package delivered through FedEx at the residence at that time and had received an email confirmation with a timestamp and a picture of the package. The complainant stated he observed the defendant via camera footage at the front of the residence pick up the package the same day. The complainant observed the defendant observe the package and then take it inside the residence where both resided. The complainant observed the defendant place the package on the stairwell, pick the package back up, and then go inside the defendant's room. The officer made contact with the defendant. The defendant stated he did not take anything that wasn't his. The defendant stated the package was his toothpaste that he ordered and that he threw the packaging in the trash bin when asked for proof of it was his package. The defendant stated he deletes all his order receipts when he receives them. The total was $189.05.
Okay. They live together?
They live together, Your Honor, and the complainant had ordered a package and the package was sitting outside of the front door and of the residence that they shared.
Okay.
And the defendant grabbed the package that was the complainant and went into his room. That's what's alleged. And then officers asked him if it was proof.
Well, a lot of people, if my wife gets a package, I get it and I bring it inside and I put it in my, in the room. Did he open the package? Do we know, did he misappropriate conversion?
Last night, so he was able to view the surveillance of the defendant taking the package, and he told me that he asked the defendant twice if he had the package and if he did to return it, and the defendant said he did not have the package.
Okay, that's a different story. I mean, if you take it and you say, hey, I'm not going to give it back, then that's one thing. But I grab packages for people all the time and I'll hold it and give it to my next door neighbor. Okay, Mr. Groholski, don't Now's not the time. I've got a bunch of DAs here. Anything you say, they're going to use it against you to prove guilt. It's not the time. We'll have you speak to a lawyer. You can explain your side to the lawyer, and at that point, they can, speak to the DAs, and then, but that way, it's really to protect you. Tell me about yourself. Are you working? What do you?
I had a stroke
Okay.
and
Who do
doesn't
you?
work. I go around to the doctors and Walmart and the
So you don't-
YMCA. That's about it.
You don't have any kind of employment then, I would presume.
No, sir.
Okay.
I'm not allowed to.
Did you want to, I'm assuming you would like a court-appointed lawyer?
Yes, please.
Okay. So, Morgan, what's the status of the relationship? Are they still living together? Does the complainant want to have contact with him?
Yes, they're still living together. I don't think, just speaking with the complainant, I don't think there's an issue like with contact. I don't think he doesn't want to not have contact with the defendant, and he just wants to.
Excuse me. It's a boarding house. There's 8 people living there.
Okay.
I'm just one of them.
Got it. My only concern is I don't want any more bad blood. If you talk to this person and they're angry with you, I don't want anything worse to happen. And so my concern is, what if they get angry? You guys get into a fight and it just erupts into something it shouldn't. So that's my concern, is whether you guys should have contact. So I am going to order you as a condition of your bond not to have any threatening or harassing contact with this person and not to be in possession of weapons. And as long as you can abide by these conditions, you and I will be fine. I'll have you sign a receipt with Victoria. I'll have you take a seat in the jury box. Do not leave until you sign our bond conditions, and I'll have you speak to an attorney here momentarily. All right?
Sure.
There to sign a receipt and then to the jury box. Can you file that, please, Alex? No contact or no threatening or harassing, no new cases, no weapons. Please.
Judge, are you appointing or financial?
Yeah. Just go ahead.
Okay. Go ahead and sign for your reset, please. The next judge is Hernandez on page 7 and 8.
Johnny Joe Hernandez. Mr. Hernandez, you're charged with assault, 2 counts of assault of a family member. You're facing up to a year in jail and or a $4,000 fine. On each of those cases, we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Your Honor. The complainant and the defendant are dating. On October 20th, 2024, the officer was dispatched to a family assault. The first complainant stated she had a verbal argument with the defendant, and the first complainant stated they had a tussle with shoe boxes and were throwing them at each other. The officer observed the first complainant to have a busted lip, bruising, red marks on her face, and scratches on her arms. The first complainant did not want to speak with the officers. The second complainant stated she heard the first complainant and the defendant arguing. The second complainant stated that when she came out of her room, she observed the defendant grab the first complainant from her hair and throw her around. The second complainant stated she approached the defendant and told him to leave. The second complainant stated the defendant used both of his hands and pushed the second complainant from her face. The second complainant stated she fell to the floor, causing pain.
All right. Mr. Hernandez, I'm going to find that there's probable cause to go forward on both of your cases. Let's see, are there protective orders? One is a dating relationship. What is the relationship of the other complaining witness? Because I see there's a protective order on one, but there's not a protective order on the second one, yet it's still alleged as a family member.
It's the stepdaughter, Your Honor.
Okay. Do you guys want a protective order?
It's a DVD case, Your Honor, so we'd have to email Conrad.
Okay, I think that you should, if you don't mind, please file one.
we'll put one on file just in case.
This is what defendant.
Hernandez. Yeah,
Johnny.
Johnny Joe Hernandez. So, Mr. Hernandez, it looks like there's a protective order on the first case, which is identifies as Abby Penablanca as a protected individual. I'm now issuing another protective order on AM. It's just initials because it appears it may be a juvenile.
Yes, Your Honor.
So as a result, this person is now a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is a stalking statute. You cannot stalk, threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where they live or where they work. Do you understand? If you violate this condition, the state can and will file additional cases against you, a violation of a protective order, and it's one of the worst misdemeanor cases you can pick up. Do you understand? No violence anymore. You got out of jail because we gave you a free bond. If you pick up a new case, you violate these conditions, I'm telling you now, I'll make your bond 5,000 to 10,000 on each of those cases. And if you don't have anyone to pony up that money, you'll be stuck like Chuck in custody until these cases are over with. Do you understand?
Sure.
What do you do for a living? We're going to reset your case to give you time to hire a lawyer. So I'm going to have you first. Well, I don't know. Do you have them up yet or no, Steph? I'm going to have you go to Victoria, sign a reset, and then I'm going to have you take a seat in the jury box while we get all your bond conditions. We'll have you sign it, and then you'll be free to go. Be careful while you're out there, because no more chances.
Next is page 18, Treadwell, come on up.
And Your Honor, on Hernandez bond conditions, would it be state's bond conditions?
Yeah, no contact, no weapons.
Yes, Your Honor.
Please, on both.
Yes, Your Honor.
You said Treadwell, right?
Yes, Judge,
Okay.
page 18.
You are on bond for DWI, and now you've picked up another DWI. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, man.
Yes, Judge. On October 23rd, 2024, the officer was dispatched to a major one-car vehicle accident in Harris County, Texas. The officer made contact with a witness who observed the motor vehicle had left the scene, but was still blocking a moving lane of traffic and had struck a school zone signpost. The officer also observed the defendant's motor vehicle had crashed in the direction moving against the flow of traffic, and the witness identified the defendant as the driver. EMS saw the defendant in the driver's seat of the crashed vehicle with her feet sticking out and the engine still running. Upon contact with the defendant, the officer observed bloodshot eyes, slurred speech, and unsteady balance on the defendant's person, along with a strong odor of an alcoholic beverage, and general disorientation and slow responses. When asked about the accident, the defendant stated she may have fallen asleep, but did not remember the crash occurring. The defendant admitted to drinking and consuming Adderall, and she said that she was the sole occupant and operator of the motor vehicle. The officers recovered 2 open alcoholic beverage containers from the passenger side floorboard.
Drinking while driving?
Yes, Your Honor. And 4 unopened containers. Standard field sobriety tests were performed, HGN 4 out of 6, walk and turn 8 out of 8, and one leg stand 3 out of 4. A blood warrant was drafted and executed.
And Judge, on the first DWI, the lab results came back as 0.286.
0.026.
0.206, because there's a big difference. Is it 0.26?
Yes, 0.286. Yes, Judge. Yes.
Yes, Your Honor.
That is a very high blood test. Can you run an NCIC? I'd like to know what other kind of criminal history she has, number one. Number two, did we have her sign a no driving affidavit on the first one? Because if she did, I'm going to have a contempt hearing.
I don't see a no driving affidavit on the file, Your Honor.
Yeah, well, her driver's license wasn't eligible though on the second DWI.
Probably because of the first and the ALR. Mr. Treadwell, I want you to be perfectly clear about something. I'm going to do everything in my power to protect the citizens of Harris County. Every single day, someone dies because of a DWI in Harris County. And I will do everything in my power to protect my city. And if that means putting you in custody because you repeatedly flaunt our bond conditions, so be it. Now, I'm going to revoke your bond and I'm taking you in. And now, if you do get out, you will have a strict curfew of 7 p.m. to 7 a.m. And I'm forbidding you from going within a car at all. You will now be signing an affidavit, and if I find that you drive, and I don't care what your reason is, I don't care if Jesus comes down and tells you he needs to ride to church, you get into a car and drive, I will have a contempt hearing. Every time you get into a car, it's up to 6 months in jail and a $500 fine. On one ankle, you will get a GPS monitor. On your other ankle, you're going to get a scram device, so I know that you're not consuming alcohol. As it stands now, I'm revoking your bonds and I'm putting them both at $25,000. Do you understand? She goes with you.
Judge, for the previous bond conditions set forth by the magistrate, I'll add the GPS and scram. Would you like to keep the rest? One of them is an IID, but since she's doing the no driving.
What is it?
An interlock device?
No. So,
Let's take that away.
no, leave it on. Yeah, leave it on. So any kind of cars that are at wherever she's staying, they're going to have an interlock. Just waive the fees for everything, please.
Perfect. I also have random drug testing remain within Harris County.
Yes. Yeah, and then just a curfew from 7 p.m. or 7 p.m. to 7 a.m.
Judge, you ready for the next one?
So 25,000 more on both.
Yeah. Yeah, he's got an address. What is he going to do in this case? She'll wait for adult.
Yeah, I'm aware of this.
Okay.
Take care of that one. Take care of this.
Oh, I don't know if that'll take care of this.
Okay, Vic.
All right, next judge is page 19. Wakefield, come on up.
Yeah, maybe. I don't know if it was
Let me see. How long have you been in custody for?
This is the best.
So do you have a lawyer today?
Quiet.
Take a seat near the jury box. Can you appoint Mr. Wakefield, someone please? You take care of it today.
Next arraignment is White, page 20.
Good morning, Mr. White. Sir, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. we're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On December 30th, 2023, in Harris County, Texas, the officer was dispatched to an emergency room where the officer met with the complainant. The complainant and the defendant had got into a verbal altercation, and the complainant said she was leaving. The defendant grabbed the complainant by her shoulders, shaking her. The defendant grabbed the complainant's head and hit it against the dresser while she was trying to get her clothes out. The complainant had a large cut on her forehead and needed approximately 10 stitches. The doctor at the emergency room said the complainant sustained a serious bodily injury.
So it's not a felony, serious bodily injury case? Whenever there's serious bodily injury, they can charge you with a felony. You could be looking at up to 2 to 20 in the prison. Are you on probation or parole at this time? Mr. White, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. If I find that you're using any kind of dope, illegal dope, I will put you in jail. You will not get any more PR bonds. I'm also ordering you not to have any contact with this complaining witness. If I find that you do, likewise, I'm going to put you in jail. A protective order has been issued in this case. I would get to know it. If you violate the protective order, and it doesn't matter what your intent is, they will file additional charges against you, and you'll be looking at violation of protective order. If you violate those conditions, I can hold you at no bond. Zero bond until this case is over with, and I will do it in a heartbeat to protect every person. Do you understand? Oh, no contact and no weapons, please. Or you know what? Don't worry about it. I'm gonna have him monitored by pre-trial to make sure he's not using. What do you do for a living, Mr. White?
I work at Tesla in the furnace department. I burn the aluminum to make parts for the Cybertruck for the company.
I'm gonna reset your case to give you time to hire a lawyer. So I'm gonna have you go to Victoria Center, reset. After that, we're gonna have you take your seat in the jury box. You will meet with pre-trial for your bond conditions. They're going to randomly test you. If you fail to go take a test, when they call you to take a test, you're going to go to jail. Do you understand? Because I will revoke the bond. No more PR bonds. All right.
That was our last arrangement for now.
Okay. Tim, you ready? Hey, good morning. How are you, man?
I'm good. Good to see
Been a
you.
while.
I love the suit.
It's new. Well, we're trying to be festive.
I get it. I love it. I have a guy named Mr. Henderson who needs bond conditions.
Did he just get out of custody? Okay, do you mind bringing him up?
Once it's on page 32, Your Honor.
Oh, it's still in the jail then?
They're still showing in jail.
Yep, I see. Okay. Good morning, Mr. Henderson. Sir, you're charged with terroristic threat. This is a Class B misdemeanor. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On August 23rd, 2024, the witness, the defendant's girlfriend, began receiving multiple phone calls from the defendant, who is, I apologize, the witness's ex-husband. The witness stated that the calls came around 21:30 hours on August 23rd, 2024, and observed the phone calls to be coming from both the defendant's phone number and from a no-caller ID number. The complainant answered the phone and advised the defendant to leave them alone. However, the defendant began to argue with the complainant. The witness then grabbed her phone and began recording the conversation as it had become more aggressive. The defendant then began to threaten the complainant by saying, "You don't want none, I'll kill you, your wife and all your kids and your stepkids. Play with me, I'll kill you and your stepkids. Play with me, bitch." Based on the previous incident between the witness and the defendant, the complainant feels these threats to be credible and fears for his life. The officer was able to speak with the defendant regarding the case, who declined to provide any comment.
So who is Simeon Sims? Who is that?
The new boyfriend of ex-wife.
Sir Henderson, I don't want you to have any contact with this person. Do you understand?
Sure.
I'm ordering you not to have any contact and not to be in possession of weapons. As long as you can abide by these conditions, you and I will be fine. If I find that you become a danger to the community, I'm just going to lock you up. You will not get any more car bonds.
Sure.
You understand? Okay. So you have a lawyer. Good job on having a lawyer. Because you have one, I will waive your appearance, but it's your responsibility to stay in touch with Mr. Adams. He will tell you when you have to go back to court. If he tells me he can't get a hold of you because you're playing games, I will issue a warrant for your arrest. I'm not asking much here.
Yes, sir.
Just want to save community. That's all I want.
Yes, sir.
All right. I'll have you sign a receipt with Victoria. After that, I'm going to have you take a seat in the jury box while we get your bond conditions. We'll have you sign it and you'll be free to go. Okay?
Thank you, Your
Thank you,
Honor.
Mr. Adams. You too. No, because it's not a family. You know? I saw it, but it's, that's why I didn't do it, because I don't think it's a family member. Hi.
I just wanted to let you know, we can do Washington chapter 11. All set.
Okay, not a problem. Do we have anyone that's coming in? Do you know?
Not that I know of, but.
Okay, well, hopefully no.
Judge, for Mr. White, you wanted no contact, do you also want to refrain from counsel for reset?
No drugs, no alcohol, random testing, no weapons, no contact. Yeah.
And Your Honor, were there conditions for Henderson?
Yeah, no contact, no weapons.
Yeah.
Please.
Okay, Monday the 9th. I'm sorry. Monday. Yeah. Counsel for reset.
For control Osborne, I only see one on my case tracking system for the 21st. But let me go ahead and reach out to our compliance team further and see.
I think we've tested this one.
I feel as though we have two, because I remember. I'm gonna reach out to our case managers and I'll get back to them.
Yeah, take your time, no rush. Hey, what on earth are you doing talking to the prosecutor? Do you want me to put you in jail?
Sit to the back of the wall.
Steve, what's your last, Henderson?
Out of county.
Hey, I have a couple of BVRs I've got to talk about too. Is this Diaz?
Yes.
So is he gonna go run it now?
I'm gonna talk to him about it.
Okay. Steven.
Hey, Judge, can you sign the four out of county? So I can kind of off for this.
Good morning, Your Honor. I almost screamed Beetlejuice.
The problem is that I really can't wear what I want to wear. I wanted to be with white face, purple eyes with the wig, and I can't do it,
Good job.
Hey, Will. Hey, what's new?
Happy Halloween.
Happy Halloween.
I have two cases on your docket today, both in custody.
Okay, who's number one?
Gonzalez. And they're both
Alejandro? No.
Eric.
Okay.
So Mr. Gonzalez has a pending DWI.
He's got DWIs in 3 counties? Yeah. Where we headed?
His family got contact with me earlier this week. They've retained an attorney on the Fort Bend case.
Great.
Yeah, I get done so on the Nueces County case. I talked to the Fort Bend attorney. He was talking about.
Is it?
Alex who? Is it Alexander Hugh? No, it's I have it. I didn't recognize the name. Let me look. It's like called him.
Okay.
So he was talking about DWI court in Fort Bend that he could get him into probably if we could work out a global thing and have, time for this one, probation, that one, whatever, but then have a new DWI court in Fort Bend. But we don't have a Nueces County attorney. That's a problem.
Why over there as opposed to over here?
Pardon?
Why over there for civil court as opposed to here?
I was going to ask you. So this one, he did a TRAS, right? And he came back. Which we can't do because of the open cases, right? So that's kind of.
I guess, why don't we set up a meeting with,
Let me look up.
Nueces County does stuff so differently too, just because you get a case now, you might not get a court date for like 6 months down the road, so.
That's what he was telling me, but I mean, it's still an open case, and they still can hire a lawyer.
Have you talked to someone for?
Yes, they do.
What you should do is let them know there's not going to be any movement until you do that. I mean, really, it's going to be at a standstill because Nueces County doesn't have the, the speed, I guess, to what we do, and Fort Bend is even slower than we are.
Right.
So.
So I was talking to the Fort Bend attorney. That's what he said. He's like, those things move so slow down there. He's not.
Until you get a lawyer to get it kind of moving on, it'll be in.
Because we can't do anything on these cases, this in Fort Bend, until we can do something with Nueces.
Set it a week and see what happens. 2 weeks. I'm not giving him a PR bond. I'm not letting him, it's. I know, he's stuck like,
Right, understood. Okay, that's fine.
Yeah, just too much baggage. I can't.
Understood. Okay, I'll do that. The other one is Mr. Jaggers. Jaggers, Jagg. Spookily similar case. Get it? Alan, spooky.
You got all the tough ones, huh?
I do get the tough ones. That's okay though. So he also has a pending out of county DWI in Montgomery County.
We have, it seems like we had a problem communicating with him last time.
We did, but we were able to, we worked out a great agreement where it was a time served on a DWI, a deferred on the trespass. TRAS recommended SAT-F, and we're willing to do all that.
I don't know if I'm willing to do that. I think that probably the best course for me, knowing who he is to do SAT-F on the DWI instead of just a time served.
Right.
Either
way, we actually had it drawn up to do SAT-F on the trespass. We approached you and you were like, just realized out of county pending case, can't do it. Same deal.
What does he have out of county?
DWI MoCo. With the resisting, I'm pretty sure.
Does he have a lawyer out there?
So that's on this one. No family, no support. So I got in touch with MoCo Indigent Defense. They sent me an application for appointed attorney, which I filled out and have sent to them.
Great job. Great.
Oh, they haven't responded. So we're also in a holding pattern.
Can you at least try to,
Maybe I could see if I can get appointed to that case. I'm not on their list up there. I don't know what qualifications they require. I can ask. Was that what you
lose?
Yeah.
I mean, I'm sure that you got to be on the list so that they know that you're qualified enough, right? But I mean, at the end of the day, you have nothing to lose by asking. And if not, kind of just put pressure on, do they have a map down there?
They have an Office of Indigent Defense.
Okay, so let's, say, hey, man, he's just languishing when he could be getting treatment. Hurry up, appoint someone so we can, work these things out. And then hopefully if they know on ours that we want to do a sober court kind of deal, they're amenable to that as well, and then just we'll give, if you want to take a copy of the TRAS, give it to them, or not give it to them, but show them, hey, this is our plan on the DWI. He's going into a treatment facility, and then afterwards he's going to be in an aftercare. Hopefully they'll see that and realize that we're not just going to throw them out to the wolves.
That's fair.
I don't know what else, and then.
Yeah, I mean, our hands are tied on both of them.
I guess you want 2 weeks, so it doesn't.
I'll do the same day on both of them, honestly, like I did today, because they're just so similar.
Need any money for investigative fees? If you need any, just whatever you need, I'll give it to you, I don't know if there's.
Dude, I can do.
Yeah, okay. Thanks, man. All right, Mr. Gold, come on up.
Pushing on Cameron Newell. I can give you a cause number. 2535114. He's present as well. He's not going to be driving. We're requesting you remove the interlock and get a portable device instead with an NDA. Also, you require to scram and a GPS with a night exclusion zone, not allowing him to drive at night. He's not going to be driving at all. We're requesting the scram and the GPS removed. I believe those are overburdensome at this point, and the portable with a blow schedule is sufficient at this time.
Do it for, he's got the prior manslaughter where he. Yeah, and
no driving. I don't see how that's going to affect
I'm
us.
okay with giving you the portable device.
But a portable, a scram, and a GPS. I mean, he's turning into a robot, Judge.
Yeah, as a result of a motor vehicle. Now he's picked up another DWI where.
I totally understand the concern of driving, but he will not be driving at all.
How do I know that? How do I know that?
I mean, how's the GPS going to show he'd be driving, or a scram? There's nothing to do
But
with
the
driving.
interlock will.
But he's not. I understand that.
The interlock will show me if he's driving, because if he tries to get in the car and he blows into the thing, it's going to show who's blowing into it and who's operating it. That's why I have it, and I'm paying for everything for him. He's not one dime is coming out of his pocket. I don't want him out in the middle of the night. That's why we did that. Right? I get it if it's overburdensome, but I already have one death on our hands. I don't want another one.
Yes, Judge.
And I'm paying everything for him. In time, if he shows me that we can trust him, then I'm more amenable to things. But now it's been what, a week?
It's very new.
Sorry?
It's very new.
It's been 2 weeks, and my concern is he killed someone last year. And now we have another DWI. In between all that, he has an assault of a family member, and he has another felony assault. Come up, Mr. Newell.
There's another issue as well. He went to get the GPS and the scram, and they said there was an issue and wouldn't put it on. I looked through his condition.
Oh, now we have a problem.
Yeah.
Now we have a problem, because now it's very possible I'm putting you into custody if you're not getting your stuff within the time you're supposed to get it.
Still have one more day today, sir. But I did go and they emailed that I did show up. I did show up to get my scram yesterday, and I was not in the system.
Order in the court,
They said that they
please.
emailed the court, and said that I showed up to do it.
Hey, Felicia, can you check out Mr. Newell and see what the issue is, please? You're asking me to take stuff up. He don't even have anything on.
He was trying, Judge. He went there.
I got my
They
GPS on.
denied him.
That's the only thing they put on.
So he went there. I mean, he got the GPS. He's doing everything he's supposed to, Your Honor.
I don't own a vehicle.
My concern is public safety. You have a manslaughter from last year, a felony assault, and another assault. And now you have a DWI. You're crashing and burning before our eyes. And what I don't want you to do is leave a wake of destruction in your path. That's what's happening. And I'm going to do everything in my power to stop it. If it's an inconvenience to you to have this, every day there's a death in Harris County because of alcohol-related collisions. It's not going to happen on my watch. Do you understand, Mr. Newell? And if it's an inconvenience to you, the other thing is a lot of the other judges here would make you pay for it. And for this, you'd probably be in the hole around $1,200 a month. I'm paying for you so that there's no excuse. And you still have yet to have the device on.
As of now, he's currently in compliance. He does have one more day to obtain that device.
Why? He's saying they kicked him out.
Okay. Yes, I see the email right here. That's not stated on here. It was stated that.
So let-
But he has conditions of bond and told to apply with the IID condition. He stated to our officer that he lost his job, but we did not have a card up to the DWI. Does not have money to hire an attorney. He got his GPS and said that he will pick up his scram device, or he said that yesterday. And then I don't have any reports following that.
So he's here now. Let's send him down to pretrial to get everything right now.
Eric, I'll send him a report.
Okay, we're sending you right now to get everything right now.
Yes, we just.
The only thing, Mr. Newell, the only thing I'm asking you to do is don't kill someone, man. That's all I'm asking you to do, you know? God forbid you dig yourself into a 50-year hole because of some catastrophic event. I'm trying everything in my power to prevent that from happening. Do you understand? That's all I want. In time, if you show me that we can trust you, and it's not just, okay, I'm all better, I'm gonna be little bunnies jumping in the woods. No, I need proactivity. To show me that you appreciate everything, then we can talk. But at this time, with the kind of criminal history you have and the fact that we have a death in 23, no, I don't think that this is unreasonable. You understand? All right, just go ahead, take a seat. We're gonna send you down now to get your stuff. You gotta have it on by at the latest tomorrow. If not, it's not gonna go well. Do you understand?
And just to be clear, you're allowing the changing from the interlock to the portable since he doesn't have a vehicle?
No.
He doesn't have a vehicle to put it in, Your Honor.
So whose vehicle was this that he was driving?
That's.
Are you Dad? Come on up, Dad. Thank you so much for coming. We have quite a bit of issues with Mr. Newell. And it seems that most of them are related to drug and alcohol issues. And I want to prevent anything further from happening that endangers the public. And my fear is that, does he live with you now?
Yes.
If there's a car at the house, he has access to it. And the problem is that when the cat's away, the mice will play. So if he has access to it, I'm scared that he's going to use it in a way that, and so that's why I ordered him to put the interlock for any vehicle that's at the house that he's staying. I'm paying for it, so it's not going to be anything coming out of your pockets. But my fear is that he just takes the car and something happens that's catastrophic. And I'm trying to prevent that from happening. So that's why I've ordered it. Like I said, nothing's coming out of your pocket. You guys don't have to pay for anything. I just want to make sure that if he gets into a car, we know about it. And that's the only way that I know. Okay?
Interlocks.
And my concern, Your Honor, he doesn't have any bond conditions and the car won't start if it's not blown into. So you're saying he's going to have to start blowing into it as well and he's not allowed to, so he can't drink any alcohol as well. So the father has bond conditions? He's legally allowed to have a beer and go driving if he's under the limit. He doesn't, he has a normal use of the mental and physical faculties.
Get it? But
now he's going to have restrictions on him and he doesn't have.
I want to make sure that Mr. Newell's not driving, you know? I mean, have you seen the record? We have a death last year. Two assaults, and now we have a DWI second. I told him that if he's proactive with showing me that he's tackling everything in a mature and adult way, then we can talk about bond conditions in the future. But it seems that with the wake of destruction that he's left with the last 2 years, 2 to 3 years, it's really concerning, you know, and I feel that he's deteriorating before our eyes, and I don't want it to happen anymore. And, you know, my fear is that something happens catastrophic. He gets into a car and just takes off and does something that's just, you can't dig yourself out of. That's all, that's my fear. And I don't want it to happen, you know? Okay. I'm sorry, but Mr. Gold, we'll talk in a couple months. If he's doing well, proactive, come back and we can talk.
So the conditions are staying.
Yeah.
I mean, you see my concern that it's now impacting his father since it's not his cars. I understand your concern, obviously, Judge. I just have to advocate for my client, and his father doesn't even have conditions.
I'm not begrudging you for it, Mr. Gold. I never will.
Question, Your Honor, though, is does he need a second interlock now? Okay.
Yeah, and I'm going to pay for everything for you, okay? So that it's nothing out of your guys' pocket, okay? Just make sure he's not driving. He signed an affidavit not to drive. If he drives, I can have a contempt hearing and he's facing 6 months every time he drives. So please, okay?
Okay.
Good luck to you. If you ever need anything, come back to us, talk to us. We're happy to help you in any way and anything you need, okay?
Okay, thank you.
All right, happy Halloween.
Thank you. Are you excused?
Okay.
Unfortunately, we're skipping you real quick. Go ahead, no problem. Come step all the way up. This is Mr. Goodman for a waiver, Your Honor.
Good morning, Mr. Goodman.
How you doing, sir?
If you could sign.
Okay.
On your arms this way.
Yeah.
Yes, that's not that.
All right, Mr. Goodman, it looks like you were wanted out of the state of North Carolina for a violation of probation. Are you waiving formal extradition, sir? Okay, unfortunately, it looks like you've not paid bond on the felony case, so it's kind of told until that case works out. At that point, that's when the clock starts ticking. And then North Carolina has 14 days to come get you.
That's when it starts.
You can't bond out. Okay. If you make bond on the felony case, then the 14 days starts running. Correct. Yes. Okay. All right. Good luck. Thanks.
Just now, approach again.
Yes, sir.
This is on call Bell, WI. Maybe I'm overdoing it, but the state has offered me time served or probation. I'm trying to get a PTI, and I need to get Nathan Beadle a package.
Yeah, but we've been working on it for quite a while. Is Mr. Bell here?
Yes, he's present.
Has he completed the package yet?
No.
Come up, Mr. Bell. I got to imagine that you've asked him several times to complete it.
Yeah, it's on me. This time. He was waiting on my call, and I just got extremely busy. The state deal offered me probation on time served.
Okay. We'll give you another 2 weeks, but at that point, if it's not done, I'm going to hold him day for day until it gets done. Mr. Bell, good morning, sir.
Yes, sir. Good morning.
Shh. They have a program called pretrial intervention, where if you are granted entry into and you complete it successfully, the DWI gets dismissed.
Yes, sir.
However, one of the main factors is your prior criminal history. Your history is thick, it's significant. So I will tell you, it's never a no, but the more history you have, the harder it is. But like anything in life, if you put your heart and soul into it, you're going to get the moon, sun, stars. So the better your packet, the more likelihood you have of getting into the program. If you bring stuff on a bar napkin with your criminal history, it's gonna be a no. So do a kick-ass package, and then you have a better chance of getting in.
Yes, sir.
Give me questions. Your case is old, so we will give you 2 weeks. If you have it done, if you have it turned in by the next 2 weeks, we'll set you for an evaluation. If you don't have it done, you're out of time.
Make it happen, Your Honor.
Okay? Okay, sir.
Thank you, thank you.
Got an approach?
Yes.
Judge, I'm approaching on Tony Kelly, and the case is getting a little old. We're still waiting on a rip on this one.
Custody or bond?
Bond, Judge.
Okay. We have tried to rip this thing since July, and you still don't have it? You gotta give it up. You might as well wish for a unicorn. Alex?
That's correct, Your Honor. We still don't have the rip.
It's not gonna happen. They don't want to be found. So.
Just have a seat.
I love it.
I should sit him in the jury box.
You might offend a couple here and there, but I don't think he really is concerned about that. Okay, Alex,
Yes, Judge. So
where are we at?
we can try to task the investigator again to get a look.
Have you done it first to an investigator?
I can see that we have not yet gotten the investigator involved yet. We've been trying the number we have. And I can get the investigator involved to see if you can find it and we can.
Hey, I'll give you 2 final weeks. If you don't have it, then it's over.
Yes, Judge. And
That's it.
we'll make sure that we get the investigator.
I'm gonna give you a 10-day trial setting if you don't have it.
Yes, Judge.
Thank you, Judge.
Okay, hey,
We got Mr. Rubin on the docket. We've got something worked out for a dismissal. He just needs to take a class.
is this the gentleman from yesterday?
Yes, sir.
Okay, is it the gun class?
Gun class.
Okay, is he here?
He's here, contract signed.
Mr. Rubin, come up. It's 220. I'll give you a couple weeks, but if you don't have it done. You have a great deal that he's worked out for you, that if you take a gun class, they will dismiss your case. Your case is extremely old, so I will give you 2 weeks. But after that, I'm not giving you any more time. If you don't have it done, that tells me that you don't care. Do you understand? I mean, really, they will dismiss this case. All you got to do is a 2 to 3 hour class. If you don't have it done, you're out of time. You understand? Okay.
Thank you, Judge. Like your costume. I mean, jacket.
What? Costume?
All right, go out there. Sit down.
Hey, Hugh. Happy Halloween.
Yes, happy Halloween. I liked it. It looks good. I have Javier Galindo on docket. And if you remember the last time you took him in custody and wanted me to check with his sister, and I just had a lengthy conversation with his sister. Everything's good. He can go live with her. She's a teacher, and then she's also getting her master's to become a principal now, and she's pretty
great.
Yeah. So he's in custody. I was going to see if we can get him on a PR bond.
I don't know, man. I don't.
I think last time you indicated that you would let him out. That's why you wanted me to contact his sister and see if he had a place to go.
She will take him?
Yes.
How do we get him to stop using?
She told me that he's not, she has keeps pretty good tabs on
She
him.
can hold him.
Well,
if he's, can you bring out Mr. Gallendo?
and he really has, he's like a different person now from that.
He's clean?
Yes. And so,
Don must have been.
yeah, I don't think so. Yeah, that was probably no fun.
Phil.
Yes, sir.
Talk to me while we're waiting.
Eric Gonzalez, his mom, dad, and sister are all here in person today.
I'm happy to talk to him.
Yeah, I was gonna ask, we were talking about the bond. I know the court will do a PR bond, but I was gonna ask for a reduction.
Are you mom and dad and everyone? Is that you? Okay, let me talk to this gentleman and then we'll talk to you. Morning, Mr. Galindo. How are you? You look great. You know, you sound good. You're coherent. You're not jittery like you were when you came here last time.
Oh, I know.
So Hugh wants me to let you out. Looks like you've got a place to stay with. Shh. Looks like you've got a place to stay with your sister. My only worry is that if we let you out, you're going to go back to doing right what you're doing, using. And I don't want that to happen. I know you're going to tell me no.
Oh, yes.
Right. You've told me that before, right? Fool me once, shame on you. Fool me twice, shame on me. How do we get it to stop? Therein lies the rub. I don't want to keep you, but I know if I release you, you're going to go back to using, and you're going to use grandma as the excuse.
That was just.
Perhaps it's another excuse. Perhaps it's saw Bambi and you're upset at the movie. Did we have him T-Rast? What did it recommend?
SATF followed by anger management and the CE ratings.
That's what needs to happen. I think that with what you're using, the frequency of what you're using, the best course of action is a treatment facility. Because we let you out, you're going to end up killing yourself. And believe it or not, I really like you. I want you to persevere, and I want you to become the great person that you can be, Javier. I think that that's probably the wisest choice, to get him into a treatment facility. I know that you want to get him out.
Yes, I'm just wondering.
Done this before.
Yes, but yeah, it's all pre-trial, so I don't know. I mean, is that something he can do pre-trial, or, I mean, can he do outpatient, or?
I can't pay for anything. The only way I can pay for everything is if he's in there. If I let him out, he doesn't have a job, doesn't have anything. He's going to be unable to pay for anything. So therein lies the excuse. Well, I can't get it done. I ain't got no money. I ain't got no job. And then it spirals into the same thing. I don't know, Hugh. I don't. I think that the best course of action is to get you into a treatment facility, Mr. Gaye.
I'll stay with my sister. I don't drink over there. I don't do nothing. I'm staying with my sister. She's a teacher. She don't let me drink. She don't let me do nothing.
She.
As if you're going to listen to her.
Yes, of course I listen to her. She's all I have. I listen to whatever she says. I babysit her son.
It seems.
Living before.
I wasn't with her. I wasn't staying with her.
Living.
Just being bad. And friends, wherever. With friends.
Street.
Yeah. But I'm with my sister now.
She seems like she has a pretty tight grip on him.
She does.
Speaking with her.
You could get her number.
Discovery's outstanding.
Your Honor, it looks like everything's uploaded and shared with the defense.
And we can set the case for trial. There's a felony that's attached to this, but I'm okay with setting it for a trial date.
Okay, I am too.
Okay.
That way, if it goes well for him, he's out. If it doesn't, I know what I'm going to do, which is what I think needs to happen regardless. Because if we let him loose on the street, he's just going to use. And we've done this game before. I've let him out before, and he goes right back to using.
He's only bond forfeited once in your court. I know one time's too many, but I know that it's not like he's been a recurring issue. This is the only time that he's had an issue with this, with the drug testing.
Let me think about it.
All right, Mr. Goodman, like this one.
You ready?
Yes, sir.
Okay. You know what? Hold on, because it's going to take a little bit of time. Let me see. What do you got?
So if you got a client tomorrow,
Okay.
I think we are due for a trial setting, Judge.
Want to set up a trial?
Yes, sir. Yes, sir.
Yeah, just pick a date with Ramona and back and whatever. I'm happy with whatever you want.
Yes, sir.
For sure, of course. Talk to me.
Judge, how are you? Happy
Hey,
Halloween.
Happy Halloween.
Judge, Ms. Lorenzo Castillo is on docket today. It is an assault, just a good old fashioned bar fight.
Okay.
Says he didn't do it. Says it was him that got assaulted.
Okay.
We are asking for a trial date.
Okay,
Can
not
we
a
have-
problem.
Can we have one in January?
Okay.
Oh, you're the man. You're the best judge. Thank you. I set for this trial in December twice today, and I'm like, man.
Sorry. We have a bunch of trial settings in December as it is, so just don't stress. Life's too short.
So, Judge, the trial setting in January would be January 20. Oh no, the 28th. January 28th.
Are you gonna do a go-go dance?
Yeah.
Okay.
That startled me. The speaker started talking.
Have fun. Okay, Will.
Okay.
Okay. You speak English?
Yes, yes.
Come up. They can all come up.
Yeah, all y'all.
They can all come up. The more the merrier. Thank you for coming. Thank you for coming. I wish it were under better circumstances. And I'm sorry that you guys are having to come here and deal with this, but better now than 6 feet under in a pine box, right? We've had a lot of issues with him. And I think that, I don't know, I mean, I guess you realize and the spiel that I give to everybody is that watch the news, which I hope you do. Every day, someone dies in Harris County from a DWI. Every single day. We in Harris County lead the nation. Shh. We
Hold
lead,
all conversations.
we lead the nation in DWI fatalities because it happens so much. Is it because we have 4 million people here? I don't know. Is it because Harris County is 3 hours from one side to the other? I don't know. But that's what it is. And it's disgusting. And what scares me with him is he has 3 open DWIs in 3 different counties. That is extremely scary. And we're lucky that no one has been injured. A life has not been taken because it could have gone so much worse. The reason that it's taking as long as it is because he does not have, I'm presuming he doesn't have a lawyer in Nueces, right?
This time, that's correct, Your Honor.
If you guys are able to get a lawyer for him down there, hopefully that can speed up the process to get everything working. Because here in Harris County, we have so many cases, we have so many people in custody that we move it like crazy. We're very, very fast. We're a fast-moving criminal justice system here. Fort Bend is building their way up to being as big as we are. So they're a little bit slower, but in the other counties, in like Brazos and Nueces, Corsicana, and they do things a lot slower. So if you pick up a case, you may not go to court for 6 to 8 months, and then you start dealing with it. It looks like that's what's happening over there.
Did let the family know that even though they don't have a court date yet in Nueces, getting a lawyer down there, they can talk to the DA and they can start working on the case and talking to myself and the Fort Bend lawyer, trying to get a global deal done prior to any court date even being scheduled. Because I mean, the case is open and pending. I mean, it's there. So that's where we are for now. But I think the bond in Harris County is the only thing keeping him from going home to his family. And so we're trying to figure out a way to see if the court would allow him to post maybe a lower amount for bond.
It scares me to let him out. It scares me to let him out. He's repeatedly shown us that he refuses to comply with bond conditions. If I let him out, what's going to happen? Is he going to pick up a 4th? Well, I know you're going to say no, but history tells us otherwise.
Sam, but I see where you're going with that. But my son is a 21-year-old kid. He's still a kid to me. And he messed up 3 times. Yes, he did. But he's ready to come out and do right with society and do the way he's supposed to. He's going to come out. He's going to live with me. He was out there living in Corpus because he turned into a welder. And I never agreed with that, with him. I told him, I said, I don't like that for you. I'm a roofing contractor. He's gonna be living under my home. He's gonna be staying with me. And I will be giving him a ride to wherever I need to take him to get his stuff straight. That's what I have, and that's what I want from him, and I know that's what he wants too. He's not a bad kid like that. He's not like what we're writing him off to be. And I see your position, and because you're telling me about, all these fatalities and stuff, but that's not my son. Twice he was caught. He was parked. 150 times I tell you at AA that you're gonna have probably gonna kill somebody. Of those 150 chances, he's got two. He decided to stop and pull over and he didn't crash with anybody. Yes, he got caught 3 times, but he's ready to not ever drink again.
How many times has he not been caught?
He's young. He hadn't been drinking. He hadn't been drinking until 21. Because he left and he was living on his own. He was living in my house. He didn't want to be here at my house anymore because he went out there to work. But him being a young kid, he lost his girlfriend. We had a cousin of his committed suicide. So he had a lot of stuff going on in his head. But now this is real to him. And he's learned his lesson. He's ready to be out here, and he needs to come out here and start working. He's gonna work for me. And he's gonna make money to pay for all this mess that he got himself into. Right now, we're paying the price. He's in there.
Why are you paying the price?
Well, we're paying the price for him because he's my son. And I'll give whatever I have to get him out of there.
Sorry, I really am.
He is not like I don't want to, he's not like all these other people, man. I'm sorry, my kid's not like that. He's not a drug addict. He doesn't abuse anything else. He messed up with the alcohol, being too young and not knowing what to do.
How do you know? How do you know?
I just know it. Know my son.
Hey,
he was living with me for a long time. That's how I know him.
And I understand and I respect it. Looking through the eyes of a father, I get this a lot. But when you have 3 DWIs in 3 different counties, judges have told you repeatedly what you can and what you can't do. And you repeatedly flaunt that and just don't. And you have shown us repeatedly you're going to do whatever you want to do, regardless of what a judge tells you. And I know that that's not what you want to hear, and I'm sorry, because I don't like to keep people in jail, but my only concern is public safety, And I know that you don't like to hear it, and it pains me to do it as a father myself as well. But I don't know how else to get him to realize that when you don't abide by court orders, this is what happens. And
Judge, you read people, you see people, you've seen my son. See him, and I'm telling you, he's not going to do this again. We want him out here so he can start working. He can work for me, and he start paying for his stuff. He does no good to anyone in there. He does no good to anyone in there.
But it does, though. Protects the public. What I'd like to do is, we've had him TRAS, right? Okay. So what we do is I have clinicians on staff who evaluate him and tell us what the proper course of action is. We've had our clinicians evaluate him, and what that is that it's a treatment facility that's kind of like a long-term rehab type facility where it teaches him how to deal with the issues, cope, and not use alcohol as a way to cope, as a coping mechanism. After he does that rehab, we have him going into sober court, which is a long-term, an 18-month program that supervises him by one of the actual judges here that keeps him under their wing and meets with them on 2 times a month, where he would come to court, meet with them to ensure that he's on the straight and narrow. While he's with me now, I can pay for it. If he's on the outside, I can't pay for anything.
that program with other.
Right, and unfortunately, we want to do that, but I can't do anything until those other two cases are resolved. The idea what Will had was you've got a lawyer in Fort Bend. You have to get a lawyer in Nueces. Once you do that, we can work together all as one unit to resolve all the cases at once. And then we get them into this program. And hopefully the other counties will see it, that this is what we want to do. We've got a long-term solution to help him keep sobriety. And it's okay.
Does that mean that he has to be incarcerated during the entire?
It's an inpatient treatment facility, correct?
He would go from custody and jail here straight to the treatment facility. So he wouldn't be incarcerated, but he would not be released in between. He would go straight to the.
It's not too terribly long. It's around a 6-month program, 6 to 8, 6 if you respond well. And after that, we let them out, and it's an aftercare program where he meets with us. He literally meets with the judge 2 times a month to ensure that he's on the, he's doing well. And if he does well, he gets rewarded throughout the program. They help him get his license back, help him job searches. So it's a really rewarding program. And the idea is to get him to recognize this at a young, early age now, before it spirals out of control at a later date, or either that, or before you do some catastrophic damage where you're now ending up with a 40 or 50-year sentence. That's the goal.
The treatment facility is called SATF, SATF. It's an acronym.
Yeah, it's Substance Abuse Treatment Facility, SATF.
But
we can't until Nueces is on board as well.
I'll talk with the family more, Judge.
You want to use all this money to get him out of jail. He needs a lawyer over there. The money, instead of getting him out, probably be better spent with the lawyer in Nueces, so that we can work all together to find a great resolution. Not just getting him out and hope he does well. We have the tools, and I can pay for everything for you. It's a $30,000 program that I'm willing to pay for you. Not to mention aftercare, which is probably another $15,000. So we are footing the bill for everything. But I can't do that if he's on the outside.
Okay.
I know that it's not the answer that you want to hear, but it may be a blessing in disguise. Work with me. I want what's best for your son. We're not here just to throw away the key. We don't want to do that. We want to help him. Sometimes it's better in the long term to sit in there, get him in the facility, than to just put him out and throw him out there in the wolves and hopes that he does well. Okay.
I'll talk to him further. Thank you, Judge.
Okay. Anna. Yeah.
I'm approaching on Wakefield.
This is the case that's nearly 250 days and just taken off repeatedly?
Yes.
Okay.
I think he only took off once, but he did take off. I just got appointed this morning. I have a drug discovery order in your queue to get more information from the lab about the test. So if you'll sign that, I'll send it off today.
Putting an ankle monitor on him though, because he's been gone and I have no idea where he is. So I'm putting a monitor on him and he's not allowed to use. And I'm going to send him for a drug test now.
Okay.
So, and then I'll set you off, I guess, a couple weeks, but it's not going to be a long time.
Okay.
I'm not going to sit here for another 6 months waiting,
Well, and I don't know how long it's going to take the lab to get that information, but
I understand, but I'm sending him for a test now. And then when he comes back, I'm going to put an ankle monitor on him as well. And if he tests positive today, then he's going to get repeatedly tested. And if he doesn't, admonish him. Okay?
thank you, Judge.
Yes, ma'am.
And don't forget.
Oh.
Don't forget to sign the order.
Get your boy. Antonio.
Judge, this is approach on Eric Helms. He's in custody.
Okay.
Judge, he was out on bond for theft, and then he picked up another theft and also a felony. But he's made bond, he's showing that he's made bond on both theft
Give
cases.
him another 2 PR bonds? Yeah.
One is the GOB, and yeah, and a personal.
God, it's set for February,
That's the next felony, sorry?
February 5th. That's so far away. It's like 4 months away, man. That's. What do you want to do? Do you really want to set it out 4 months? You know?
Well, Judge, I really have no control over, the felony court settings up there.
I don't know, Antonio.
Um,
Like if they're out of the same transaction, you
Can
set
we-
up a trial. What would you like?
Judge, can we just have, since I'm just now coming on today, I don't know any of the facts of what happened. I just need a regular reset, and then we'll come back and see how it's progressed.
Just let me know what you want.
All right, thank you. Your Honor.
2 pleas back to back, both of them are Spanish speakers.
All right, let's do it.
Come over this way.
Aaron.
Yes, sir. How you doing, Aaron?
Mero, mero. El mero, mero. Aaron, who's your guy, man?
Federico Romero, Your Honor.
Okay, so we've got Rico Romero.
Okay, yo lo voy a traducir con español, todo en español, ¿ok? Todo en español, ¿ok? Entonces, todo en español.
And then Idelce.
Sí. Stay. Yes.
Yes. Sí, señor.
Order in the court for the pleas.
Both of you gentlemen are charged with driving while intoxicated cases. Both of you guys have worked out agreements where cases will now reflect as convictions on your record. Mr. Idelce, you need to understand that this is a DWI second offense. If you ever get pulled over and you have the faintest smell of alcohol or dope on your breath, what is going to happen to you?
I want to be deported because I don't have papers.
That's one of the things, perhaps, yes. But first, you're looking at a prison sentence of a minimum of 2 years, a maximum of 10 years. From now on, if you pick up another DWI, you will not be with me. You will end up in felony court. A very lengthy.
Sorry, I want to tell you I'm sorry that I am sorry.
Sorries don't matter to me.
Okay.
What matters is that it doesn't happen again. And I'm just warning you that if it does, you will now be in felony court. So if I were you, even if you have a sip of alcohol, I wouldn't get into a car because you're taking a humongous risk. The same applies to you, Mr. Rico Romero. You now have this DWI going on your record as well. If you ever get into a car and smell like alcohol or dope, likewise, you will end up going back to jail. He has 2 FSRAs upstairs. What's going on with that? 5 years? 2 years? Are they second degrees?
No, the charges like the hybrids 2 to 5. It wasn't
Oh,
serious.
it's a hybrid one.
That's why I feel comfortable doing this. I mean, it's the minimum.
If you're going to get into a car and maim and destroy other people, please don't. You have a DWI. You've got 2 failure to stop and render aids where you've created a ton of damage. Don't. How is that fair? All we want are our streets to be safe. Your sentence is 3 days in jail with credit for the 4 days that you've done. You're giving up, both of you guys are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You could be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you accept this agreement, you can never change this or undo this. Now, you, Mr. Rico Romero, It looks like after these cases, you still have to deal with the felony cases. And then after that, it looks like you also have an immigration detainer as well.
Llama por papeles porque va a ir a la corte mayor. Y después de eso va a
How do
enfrentarse
you
a la
plead to
corte
the
de
offense of
inmigración.
driving while intoxicated guilty?
¿Cómo se declara borracho? ¿Culpable o no culpable? ¿Culpable o no culpable? Guilty.
Find you guilty. I'm going to suspend your driving privilege for 1 year.
Por un año.
Do not drive. And please, don't kill anyone. Mr. Idelce, you've worked out an agreement. They're offering you 365 days in jail
35 días en la cárcel.
to be probated for 18 months.
18 meses.
As part of the probation, you will do a repeat offender DWI education class. You will do 2 victim impact panels. No drugs, no alcohol, no breath test refusal. So if you are pulled over in a car, you must, and an officer asks you to submit to a breath test, you must submit to a breath test. If you don't, you are in violation of this probation. You must also do 5 days in jail as a condition of this probation. This is to begin tomorrow.
Yes. Mañana va a empezar a presentarse usted.
Do you want him to hear or report?
¿Dónde se va a reportar?
Okay. By 6 p.m. You must report by 6 p.m. to the 701 San Jacinto. If you fail to report,
Okay.
if you fail, sorry,
I will show it to him what to report.
we give him paperwork too, Mr. No, don't have to. But I want you to understand that if you are someone who is repeatedly late, they're not going to take you. And if they don't take you, the full range of punishment is available to you.
Si no lo toman ahí de nuevo o algo, va a tener más problemas.
Pero yo voy a estar a las 6 ahí.
I'm gonna be there at 6 p.m.
I would be there before.
Yo diría que estuviera.
Before.
A las 4, sí, ok.
4 o'clock. I'll be there.
Ok.
Okay. How do you plead to the offense of driving?
Te declara la ofensa de manera
Offense,
totalmente
guilty
intoxicado,
or
culpable
not
o no
guilty?
culpable. Guilty.
Okay. He also has a felony case, Mr. Nunez.
Y este le hizo una felonía,
Sí, sí.
pero la felonía se lo quitaron.
Let me make one thing clear to you.
Eso es algo claro.
How old are you?
¿Qué edad tiene usted, señor?
45 años.
45.
You're not a spring chicken.
Es un niño, porque ya no es un niño.
You don't look like you're in the best of shape. If you're doing that kind of dope, it's going to ravage your body and you'll likely end up dead. So 45-year-olds can't be using the dope that 18-year-olds do. Get my drift? We don't want to see you in a pine box. What about the DPS fines and fees and surcharges, Mr. Nguyen? Mr. Idelce, what do you do for a living?
Trabajo medio tiempo a veces de construcción. De construcción y a veces tengo mi esposa que tengo que mantener.
And then I have to take care of my wife.
Ya.
Okay.
Okay.
All right.
De construcción, pero no trabajo mucho, medio tiempo.
Just give him a long hand.
$300 por semana.
The six.
Solamente no me preguntan, nada más conteste.
Just have them do that. All right. We wish you the best of luck, gentlemen. I am suspending your license for a year. Do not drive until you get a license, Mr. Idelce. And good luck to you, gentlemen. Oh, enhancements. I'm sorry. No more. Sorry. Mr. Idelce, is it true that you had a prior DWI in 22 in our court?
El 22 es cierto que usted tuvo otro DWI aquí en esta corte.
Sí.
Yes.
Is it true that you also had a 0.15 or above in this case?
5 tenía con de alcohol.
Imagino que sí.
Yes, I
Is
imagine.
it also true that you had an open container in this case as well?
Se llama un contenedor abierto con el carro cuando lo pararon.
Contenedor como
cerveza o algo
Had
abierto.
an-
Oh, sí.
Yes. Yes.
Tell you now, Mr. Idelce, that you will be required to pay the DPS fines and fees and surcharges that are now $6,000 to pay. I will give you time to pay it, but if you don't pay it, a warrant will issue. And for every $100 you owe, you will sit 1 day in jail. Do you understand?
Pero no tengo.
We will put you on a payment plan for 2 years and you will be required to pay it. I will waive the court costs, but with the DPS fines, you're gonna have to pay that.
Se llaman los costos de la corte, pero eso es una multa del estado, de DPS. Ahí le van a dar ¿cómo se llama? Tiempo para pagar.
Hey, guys, good luck.
Suerte.
CC.
Judge, may we get an order to get the device?
Well,
But he'll have to put on another one whenever he's ready.
well, no. I mean, he needs a device, though. He can't go without a device. Does he have a Guardian Interlock now or a portable device?
He has the portable one. He came to.
Let me make sure that he has it.
He has it.
And that it's operational, Mr. Newey, and then if so, yeah.
He showed it to me now. What is the machine? The portable one.
máquina que tiene.
That's and it's operational?
Yeah.
Está trabajando.
Sí, está trabajando. Ya.
Okay. Yeah. All right. Yeah, because he's paying for the 6,000. Yeah. Okay, all right.
Thank you,
We're
Judge.
gonna waive the probation fees because he's doing that other one, which is probably like a. Okay,
This is back from my client Navarro Alejandro.
yes.
This is a harassment case. I wanted to see if you could consider removing his ankle monitor. It's a current bond condition. This is a case, Judge, where right now there is a protective order, a 5-year protective order out of one of the family law courts whenever they got child support and custody handled. And this is also one, Judge, where I think the state is having trouble getting a hold of their complaining witness.
Michael,
Yes, Judge.
Navarro, they're asking that the device be removed.
This is a GPS, Judge. Or what kind of device? Okay.
Come on, Rita.
Judge, based off of the fact that there's 2 harassments with the same complainant, we would oppose removing the GPS device at this time.
There's 2 different harassments,
That's true, Judge.
one after the other,
Right.
you know. When are we
We got
set for
called
trial?
in February, so we'll see what,
Why so long? Why not January?
I think the,
Because
yes,
on the
ma'am.
trial date that is available, he has a CLE. The weeks before is a short week, and the week before that, it's.
All of
the-
January, we have only one date available?
Yes,
How is that possible?
Judge, I'm out of the country on the 7th. That's baby DA school on the 14th. The 21st is a short week, and the 28th is available. He's going to be in a CLE.
Okay, no, I mean, I'm not gonna, he's got 2 different harassment
I
cases.
understand, Judge.
I mean, if-
I would ask, just
Yeah.
based on circumstances, so.
Okay,
Thank you, sir.
thanks, guys. All right. Hi, thank you for being patient.
I have Mr. Rivera here. He's doing 2 time serves today.
Last name?
Rivera.
Good morning, Mr. Rivera.
Good morning to you too.
Okay, so you're charged with theft, you're charged with evading arrest, correct?
Yes, sir.
You want to do, let me see. Okay, you worked out an agreement, they're offering you 30 days in jail on both cases, and it looks like you've got 3 days credit on both cases. Is this how you understand it?
Yeah.
You need to understand something very important now. You are pleading guilty to this evading arrest. This is an enhanceable offense, so if you pick up another evading arrest,
It will be a felony charge.
Right.
I'm fully aware of it, sir.
years instead of days. Do you understand? You also need to understand that that also applies with theft cases as well. If you pick up multiple theft cases, they can also hit you with a felony charge on that one as well. Do you understand?
Yes, sir.
You give up a lot of rights by entering this agreement. You give up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, you can never change this or undo this. It will stay on your record forever and a day. This is what you want to do.
Yes, sir.
How do you plead to the offense? Are guilty or not guilty?
Guilty.
I will find you guilty, sentence you to it. Good luck. Thank you.
Thank you.
And thank you for being patient.
Thank you, appreciate you.
This way.
You can go, Tim, I'll come back there. Are you Beetlejuice today, Judge? Beetlejuice? I like that.
You know, I want to wear the hair and the makeup, but you know, my wife was like, you can't do that because you're doing a serious thing and, you know.
I mean.
She's right.
It's one day.
She's right.
Would you think it would have gone bad to do that? Yeah, but let's have fun.
This is not about fun.
No, that's true. I guess that's a matter of perspective, right? Hugh. Okay, sure.
It's a time served on a trespass.
I don't know if I'm ready to just let him out. I don't, because I truly think that if I let him out, he's just gonna start using again. And that's what I don't want to
This is
happen.
his only time. This is his only mess up while he's out on bond now.
The only way that I would have is to have him come twice a week to test, so I know that he's not using, right? And I'm gonna tell you now, it's how long do you think it's gonna take?
Yeah.
I mean,
yeah.
The only way that I can really know that if he's not using is to constantly test him.
Yeah. Even still back
He's
there.
gonna do that? You think he's gonna want to do that, come up here twice a week to try to test?
I don't think he wants to, but I think he will. But I haven't had never had any issues with him showing up. But I mean, so should I just get a trial setting or should we?
Yeah, of course. I mean, yeah, and because it's a jail case, we'll do it as soon as you want.
Okay.
You know, I got to give them at least 30 days so they can get all their motions and subpoenas out. But, you know, we can get you already have a case December 3rd that we set, didn't we?
Yeah.
Yeah.
Set on the 3rd? Yeah. Set up a trial on the 3rd, you said?
Sure.
Yes. I have a trial set that day as well, but.
It does.
I did.
Set you a jail case that day.
Yes.
So I'm saying we could do the same thing.
Okay. Let's do that. Minutes.
What, Mr. Smart? Ay. What's going on with you, man?
I'm just tired. I'm supposed to be on medication.
Did they just pick you up?
Yes, sir.
You still coming down or what?
No, I've been here for a couple of months.
Here for a couple of weeks.
When did he get a? When did he get?
It's been since 9/16.
You've been in custody here since 9/16?
Yes.
Continuously?
No, I think.
I know, but it keeps happening, Mr. Smart, and you keep picking up trespasses and you keep coming back here and you don't come back here. This is now our 4th trespass case and you never come back. The days of catch and release are over. Do you understand? And I am now, any more cases that you pick up with me, we will now be working on getting you treatment so that it stops happening. Where are you living?
With friends.
Who's in your life right now?
My sister, my mom.
I've been speaking with his father, but they live up in Fort Worth.
Why aren't you living with them?
Me and my dad don't see eye to eye sometimes.
Can I take a guess why?
I mean, I'm not trying to lie. Easy.
Mr. Smart, you have now, for the past 3 years, have been in and out of custody. And before you know it, 15 years are going to pass, and you're going to look like that little Quasimodo dude on the side of the road begging for money because they've got no job, no prospects, but only addiction issues, never willing to take care of it. Toothless. Is that what you want? How long has he been in custody?
Since September 13th.
I'm not going to do it. I'm not. I think that we need to have Mr. Smart TRAS to see what the problem is, why it continues to happen, and so it stops. We're working on since 22, early 22, burglary of a building, trespass, assault, trespass. And now I'm not doing this anymore with you, Mr. Smart. I'm not going to do this. So we will have you evaluated. I want you to talk to my clinicians to find out what's going on with your life, to see what we can do to help you out, to get you out of this rut before you kill yourself or worse. No more. Do you understand? We will do it expedited, so it's not going to sit here and languish. So today's Thursday? Hopefully we can get the TRAS done tomorrow.
Okay.
We can come back maybe Tuesday, Wednesday, and figure out what they say, where the proper course of action is.
Sure.
Mr. Smart,
Okay.
please be honest to the people that we have you talk to. If I get a report back and it tells me that you're all rainbows and gumdrops and there's no issues, I'm going to send you right back to do it again. Do you understand? Be honest, because we want to help you. That's the only way that we can. Okay? See you on Tuesday or Wednesday. Thanks you. Ricardo.
Judge, you can't be real mad about this one, but I'm approaching.
Mad?
Yeah.
I'm not going to be mad.
Oh, thank you. I'm gonna hold you to that, Judge.
Am I going to be mad at them?
Well,
Okay, well,
I don't
you
know.
know.
I feel like some of it's gonna come to me, so we'll see.
Okay, Morgan, the problem is that it's usually not your guys' fault, but you got to hear the brunt of it regardless, and that kind of sucks.
It's part of it.
So I'm sorry.
It's okay.
This is gonna be a doozy also. This is gonna be a doozy, so. All right, Rafael Lobet, L-O-B.
Can we just talk about a little bit?
We did. We have like 3 weeks in a row. We have. And so I got my disclosure. I'm good on that end. And then looking at everything, making sure my ducks were in a row, all of a sudden I see, hey, we don't have the breath test slip.
Okay.
Can't clean without a breath test slip, Judge.
You have one?
So,
I mean, maybe it was
when-
misplaced. I don't know. That's usually.
And whoever was in this court screened this case, they did not put a to-do in to request the test strip. Sometimes it's at the bottom of the DICs. It was not in this case. I know Ricardo reached out to us yesterday, and we reached out to our admin to see if we had it like in our system somewhere. She could not find it, so she emailed to get it. But as of right now, we do not have the breath test strip.
How old is the case? God, it's 230 days. Do you want to set up for early next week to see if you can get your hands on it?
I was gonna say, Judge, if we could just have a week and
Done.
see if we
It's
can
not
get it.
there, you know.
I would ask, can we go ahead and exclude it for not having it today?
Council for reset.
I'll give you a week.
Thank you, Judge.
I mean, if it's not in a week,
Okay, because that changes things for me. That's the biggest red flag. on me. All right, so let's see. So 1 week?
Yeah.
Okay, sounds good.
and I'll keep it, I'll waive his appearance. Is he here now?
He's here now. We'll waive his appearance. Perfect.
I'll waive it for the next one just because it's not his fault.
Perfect. Thank you, Judge. I'll explain that to him. I appreciate it. Thank you. Thank you, Morgan.
Judge.
Hey, can I have, Morgan, can I have you take a look at this? It's an order for discovery for breath test, and we usually have you guys sign it. I accidentally signed in your place. Would you mind just taking a look, see if you guys are okay with it? I think it's a standard. Why are you here? You ready? Let's do it. Bond or jail?
Oh, no, I didn't get some candy.
Thanks.
To the front.
We got now. I can take another half hour. To do the final. Right?
Good morning, Miss Murphy.
Good morning, how you doing?
Miss Murphy, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. You've worked out an agreement that they're offering you 3 days in jail, credit for the 24 that you've done. You need to understand that there's an affirmative finding of family violence. What that means is that if you pick up another one of these cases, you will be charged with a third-degree felony. You will be looking at 2 to 10 in the penitentiary. Do you understand?
Yes, sir.
You also cannot own a gun or ammunition as a result of this plea bargain as well. If you have a gun, ammunition, that in and of itself is a Class A misdemeanor. Okay, you give up a lot of rights. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, you can never change this again. Is this what you want to do?
Yes, sir.
How do you plead to the offense, man?
Guilty.
I will find you guilty and I will follow it and I will sentence you to it. Good luck to you, man. Okay.
Want to make sure I get. Got Mr. Gilbert, Your Honor, for a plea?
Yes, sir. Man, I'm digging y'all, bro. Beetlejuice, Beetlejuice, Beetlejuice.
I have John D on it. Did you sub in?
I was originally appointed on it. I was in trial one day when he was on the docket and they brought John in just for one day.
Got it.
To reset him until today.
Mr. Gilbert, you're charged with 2 cases. You're charged with assault, bodily injury. You're charged with theft. You've worked out an agreement. They're offering you 3 days in jail, credit for the 27 days that you've done on the assault, and they're going to dismiss the theft case. Is this how you understand the agreement? You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, you can never change this or undo this. You need to understand that from now on, you're facing a minimum of 90 days in jail for anything that you pick up. Do you understand?
Sure.
How do you plead to the offense of assault? Guilty or not guilty?
Guilty.
I'm gonna find you guilty. I will send you to the above agreement. You know, there's some people that when they drink, they turn into great people. There's some that turn into, if you're like that, you know what I mean? Be a happy person. It's not hard. Good luck.
All right.
Thank you, Your Honor.
And God bless you.
Yeah, Miss Treadwell popped up on the docket today and she had that prior DWI and she picked up a new one.
Yeah, she's with us now.
Okay, did you revoke her old bond and raised it?
Yeah.
Okay.
You also have Flores.
Yes, I've got Flores. I got a time served from Michael. He's got a felony pending that's reset till January the 7th.
The felonies are set for tomorrow.
Oh, really? Okay.
Michael, did it change on Flores?
Did what change, Judge?
Manuel Flores, it looks like the felony cases are set for tomorrow, not January.
For some reason, when I checked, I thought it said January the 7th. But in any case, Judge, while Michael's checking that, it looked like he got a lower bond up in felony, like I want to say like $5,000-$6,000, and ours is at 10. I was just going to see if maybe you can at least lower it and at the very worst match the felony.
Do you want to know why, Judge? Because he picked up a new felony yesterday. He picked up a third-degree possession on the third.
Hold on, John. Let me do this plea real quick so they can get out of here.
No problem.
I didn't think it was gonna take that long. All right.
Stand down for a second.
Give me a second. Ms. Almanza, good morning.
Hi.
Ma'am, you're charged with assault, bodily injury. You're facing a year in jail and or a $4,000 fine. You guys have worked out an agreement that they're offering you, is it a year in Harris County Jail?
Yes.
How much credit does she have? It's 365 days in jail, credit for the, what did you say? 29 days that you've already done. Is this how you understand it, ma'am? You're giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accuser. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this, you can never change this or undo this. You understand? Is the felony going away?
They still have to do the RIP, but the felony chief told me that it's definitely going to help.
So, ma'am, you're charged with a very serious case upstairs, and it looks like it's going to help. So,
Don't get scared. Sure, it's going to be okay.
Give me tissues by chance. It was mom, wasn't it? The cases? Was it mom?
Boyfriend, mom.
Okay. Do you still want to do this, ma'am? How do you plead to the offense of assault? Guilty or not guilty? All right, ma'am, I'll find you guilty. I'll send you to the agreement. I'll roll your court costs or anything. It looks like your felony cases are set for in about a month, so hopefully they'll be able to get everything squared away from you. Just, ma'am, be careful, Just, all right, good luck. Thanks for that. Okay, John.
I'm here, Judge.
So here's the deal. With this gentleman, since February, he picked up a PCS. July 16th, he picks up a theft. We get him out of jail. 3 days later, he picks up another theft. I guess he gets out of jail. And now he picks up another felony PCS, this time a third degree. He just picked up a new case. They filed it yesterday. Or is it an old case?
Yesterday, Judge. No, it was case from the 29th. They followed on the 30th.
Really?
Yes,
so
Judge.
he's out on the lam. He must have been on the lam because I've got it at 6,002. It's got to be that he must have been out and it was in warrant status and then he just picked up. The only way we got him is,
Yeah, he's out because it says that this occurred on October 29th and that he was in a Target. And they're taking him in because he previously trespassed there. I'm sorry, they haven't screened it yet because it's so new. So I'm trying to see what's going on here.
He trespassed him at the Target and popped him with stuff.
Yeah. They popped him with meth.
Did you hear that, John?
Grams, 2.9.
Yeah, I did. So I guess he must have made all the bonds. He made our bonds.
No. What I did was he failed to appear at our last setting. We revoked his bond on 8/15 because I did a bail order.
Right.
And the newest thing we have is the capias that was returned yesterday, 10:30, because he got popped at the Target and he had meth allegedly. So that's where we're at. He's being held at no bond on both felony cases regardless.
Okay. Well, let me ask you this. I think Michael put a time served on it, Judge. If you want to just bring him back tomorrow, I'll talk to him now. Maybe he can.
No, there's no rush, John. Really.
Yeah,
We can
that's
set it
fine.
for later next week if you want, when you're back. It's up to you. You tell me. What do you want to do?
That's fine, Judge. If you want to put it on on Tuesday the 5th, I'll be back by then. I come back on Monday night.
Okay, done.
Sounds good, Judge. Thank you.
Okay, we got you.
I'll see
Have
you
a safe trip.
Yeah, thank you, Judge. Talk to you later.
Okay.
Take
See ya.
care.
Hey, guys. Of course. I feel naked without the donkey.
Something?
Okay. Tell
Well,
me.
we're approaching on a case that's off docket, so
Okay.
problem solved.
There you go.
It's Christopher Anderson, and I have a cause number if you need it. 250-1154. He's set for trial on the 19th. The state has made me a new offer. I relayed it to my client, but I want to take the court's temperature to see if the court would be amenable.
The time served?
No.
Okay, good.
He's got a.
And I'm usually okay with,
Okay.
I don't think I've ever had a problem other than time served on the second.
Okay, so he's got a DWI second and then a UCW, and the offer is to reduce to a first and do 12 months probation.
Yeah, I'm okay with that.
Okay,
Absolutely.
and then dismiss the UCW. Okay,
Totally.
thank you. I will let my client know that and we'll go from
And come up. Oh. You now will be tested like crazy. And the next time you test positive for cocaine, for alcohol, or for marijuana, obviously 30 days, but if you test positive again, I'm going to keep you and I will put you in a rehab facility. If you can't stop using on your own, we're going to do it my way. You understand? I'm also now, because your case is so old, going to put a monitor on your ankle so I know where you are at all times. Do you understand? Okay. That's it. Take a seat. Okay.
when do you want to see him back?
Come back weekly to test,
Judge, how long was your record, or how many days for the device?
Since he's here, we'll send him now. Can you do randoms once a week?
Yes, sir.
Do that.
Okay, so he does not need to physically come.
No, we're gonna do randoms once a week. Okay, all right. Yes, ma'am.
Judge, my approach.
Mr. Slider.
Judge, how are you? Here for Mr. Brown, the test came back.
Come up, Mr. Brown.
Had some alcohol in his system, but in Mr. Brown's defense, his bond conditions, when the magistrate did not say no alcohol, it just said no drugs. We've since amended that as of yesterday, but it did say no drugs. It didn't say anything about alcohol.
He's not on that.
He's a gentleman that has 4 hours of community service left, set for dismissal on Monday.
I remember. The case is as old as Hashem himself, and yet has failed to complete the 4 hours of community service.
He's already registered at the food bank for Saturday and Sunday.
Hey, got until Monday. You don't have it done by Monday, I'm sending your case for trial. Do you understand?
Yes, sir.
If I find that you consume alcohol again, into jail you will go. Do you understand?
Yes, sir.
You will get tested again if you don't have it done.
I understand.
See you Monday.
Thank you, Judge.
Thank you.
Yes. We'll do the plea and then we'll have him sign later. Come up, Mr. Wakefield.
When is he going in? Today. He's right now? Yeah.
I guess we'll send him to 49. Or,
Do you want him to determine right now or at 6?
no, right now.
He's prepared to go right now if you want to
Okay,
give him
no,
till
we'll do,
6.
no, we'll do it now.
Okay.
I don't want him to not turn in. Because then it'll go sideways real quick. Mr. Wakefield, you're charged with possession of marijuana. You're facing up to a year, up to a year in jail and or a $4,000 fine due to the amount. You've worked out an agreement. They're offering you 30 days in jail credit for the
4 days?
4 days credit that you've already done. Understand that this charge will go on your record. It'll be there for the rest of your life. From now on, you're facing a minimum of 90 days in jail. Do you understand? Not only, do you have a job? What do you do in life? Dude, it's not funny. You're using all kinds of dope. You've got no job. What the hell are you going to be doing in 30 years from today, man? You know, you're going to end up on the street, jobless, prospectless, ain't got no money. Where are you going in life, man? It's not a good way to be in life. I know that you like to have fun. I know that you like to party, but you got to think about your future, because if not, and your mom and dad are not going to be here forever. Your auntie, your uncle, they're not going to be here forever. And if you don't have them in your life and you got no job, you got no money, you're on the street begging, either that or you're going to be slinging. You get caught up in that. You're either dead or with a 40-year sentence. How old are you? Have you ever had a full-time job? Doing what?
At Chevron in Lake Charles. I was a pipe fitter.
You were a pipe fitter. For real? So why stop? And?
So you can work this comp.
So it's easier to just get workers' comp and do nothing, I guess, right?
No, I just never went back, like reapply after.
Okay. You have to do something in your life, Mr. Wakefield, because if you don't, you're going to end up in jail with a lengthy sentence or on the street. That's not a good way. You work hard now, so you set yourself up for the future, so you can have vacations. You can buy nice cars the legitimate way. What you're doing now, it sucks. Just bottom line, it's not a good way to go through life, man.
Judge, while he's in custody, I can have a MAC social worker talk to him about options.
That'd be great. Dude, pipe fitting, if you get a trade like that, you can kill it, man. Making 20 to 30 bucks an hour. Holy you can buy a Benz, man. You can, with that kind of money, you can kill it. What you're doing now, it sucks. And I don't even know how you're getting your money to do the dope. Anyways, you got to be getting it from somehow. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen or a possible immigration consequence, you can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, you can never change this or undo this. It will go on your record. It'll be there for the rest of your life. The reason I'm telling you this, Mr. Wakefield, is because your demeanor and the way you act when you come in here, you think it's a joke. Well, what I'm trying to tell you is that your future should mean something. We have enough brown and black people in custody as it is. Your life is hard enough as it is, being a black and brown person in society. It doesn't get easier the older you get. It gets harder. You get fatter. You get uglier. You lose hair. The older you get, the more unemployable you get. So if you don't set yourself up now, you're going to be nothing in 20 years. Do something, Mr. Wakefield. Don't become a statistic. How do you plead? Guilty or not guilty? I will find you guilty, sentence you to the agreement. I will roll your court costs. One more thing. I'm done with catch and release. So if you continue to come back with criminal cases, what we're doing today, the plead on the spot, be done. It's not going to work. Do you understand? If you come back, it's not going to go well. Good luck, Mr. Wakefield.
And Judge, if I could just get you to make a note on the docket sheet that he pled on the same day I was appointed.
Yeah, I'll do
Okay.
it. Sure.
Thank you, Judge.
Okay.
Okay.
Guys, I had tended to, where is the other thing? Let's see, where's Lena's? Yeah, Lena's, I was gonna put on the makeup and get everything done. I had tea.
Okay, yeah. Yeah.
It's showtime.
Oh, he's showing his whole.
Yeah.
You put it on?
Yeah, I did, but you know, it's just, it's too serious of a gig here, and I don't think that people would have appreciated it with, so that's why we didn't put it on. You know, but anyway, all right, guys, happy Halloween, and we'll see you bright and early tomorrow. I'm gonna go get my daughter. You wanna say hi to everybody?
I did.
Oh, and that's Tina, by the
Hi,
way.
everybody, it's Tina.
Okay, all right.
Before the court, because you failed to appear. I remember meeting you on maybe not my docket or somebody else's docket that I was covering. And I said, "Are you promised to come to court?" And you said, "Yeah, sure."
Yes, and I certainly tried, Your Honor. I mixed up, like, there was a lot, like, A, there was a lot going on. B, I
Yes.
called the public defender's office.
No, don't say anything yet, because you have the right to remain silent. Anything you can say can be used against you, so we're not going to do that. So you're remanded for now, but we'll have you back on the 16th, which is on Monday.
Okay, I'm sorry,
Thank you.
I'm confused.
Again, Ms. Martinez, you're remanded. Do not have a bond.
So I'm leaving today, leaving jail.
You're not leaving today.
But Monday?
You're remanded to the Washtenaw County Jail, no bond. We'll see you on Monday.
What does that mean, no bond?
That means you're not able to post. You're staying in. Your bond is revoked at this time for multiple failures to appear.
Until Monday?
And I'll revisit it then. You're done.
Okay.
Ms. Martinez, come back.
Yeah.
How much time do you want?
Judge, I'm going to need 2 to 3 weeks. I anticipate a social work referral. I need to confer with our juvenile attorneys to get some background information, as well as to talk to Mr. Chavalowski about how to proceed. And then I'm going to need some meetings with Ms. Martinez.
Ms. Martinez, I'm going to schedule your pretrial for November 6th at 1:30 p.m. You're going to stay remanded. You have too many failures to appear.
No,
Last
Your
time
Honor,
that-
Your Honor.
No, last time that you were in front of me, I'm like, I talked to you about coming in and you're like, yeah, no problem. And it was really
No, it
dismissive
wasn't
about
a
it.
problem
And
then.
then you didn't, you didn't show up at all. And
It certainly
I'm
wasn't.
not confident that you're gonna come back. You have a multitude between this court and district court of failures to appear. You don't come when you're ordered to come. So why would I think this would change now?
Your Honor, because there
So
are a number
on
of.
11/6 of 2023 at 1:30 p.m., you'll be back for your court date. Thank you.
Really, there's nothing I can say?
Seriously, there's nothing I can say on account of I have a job to get back to. I have bills to pay. I also have a car to unimpound, and there's nobody else who can do it except for me. And
Ms. Martinez, you would have had that opportunity had you had just come to court.
Yes, Your Honor, I understand.
Any of the number of times, the handful, the dozens of times that you were supposed to come and you didn't come before. And if it had just been one failure to appear, I would not have thought it was much to worry about. But there's more than one. You're done. We're done today. Thank you.
Number 17 and 18 people versus Devin Martinez, 23-626 FH, 23-635 FH.
Alex Chabalowski for the people.
Sent Overwater, Assistant Public Defender, on behalf of Ms. Martinez.
Camille, can you hear me? There we go.
Yes, hi.
Okay.
Yes. Hello.
All right.
Good morning.
Morning. Did we get through the plea last time or no? I don't remember. I
We
have it
did
all
not.
written out. Okay. So how are we proceeding today?
Well, Your Honor, it's still my client's intent to plead no contest to the R&O larceny under 200 and retail fraud third pursuant to the offer. We had discussed that the restitution on the misdemeanors that would be dismissed as part of that plea offer were $24 and $27.97 respectively. The issue was where Ms. Martinez was going to go upon her release. The court did not want her to go to her home with her current romantic partner because of allegations of drug use. So Ms. Martinez suggested that she might be able to go reside with her grandmother. I did have the opportunity to speak to her grandmother a couple of times, but she has refused to let Ms. Martinez stay there. So what I'm asking the court for is that Ms. Martinez could be released to treatment because she does have some mental health and some substance abuse issues that she could certainly stand to benefit from treatment and from living in a sober environment, and that would provide her hopefully with not just a place to stay, but also transition into more stable housing. So I'd be asking the court for precisely that.
I would also, may I say something as well?
It would be against my advice, Ms. Martinez.
I'm just curious, like if I were to have another option before a treatment bed opened up, would that be possible? Also?
What's the other option?
There are a couple other people that I'm trying to get in touch with. It's just very difficult within the confines of the budget that I have to be able to speak with people through these confines. So it's just a matter of getting in touch with somebody, but whatever happens first, I'm thinking like would that be all right? Like whether it's treatment.
I don't know who those people are, and so there's no way of vetting to make sure that you're going to a proper place. The first place you suggested to me, we've already had that conversation.
Okay,
it's maybe not the best environment for you to go through, but if that was your first choice, where there's active drug use, that's not. I'm worried about who else you would pick. So in that case, for the safety of the community, I pick, and so it's Home and New Vision or Home and New Vision.
Would Sparrow be all right? I was thinking, because I've already been.
I need you in a longer program, not 5 days or 8 days.
No, 90 days is their residential usual program, and I've spoken to Sparrow already, and someone was coming to reach out to me at the jail actually. Would that be possible? I'm familiar with it. It's really nice actually. 90 days would be appropriate.
No, it's right now it's Home and New Vision unless I have additional information, but the information that I have now it's Home and New Vision.
Sparrow is not available?
Camille, I'm not gonna repeat myself again.
Okay. Do you know if there are beds open?
I don't. So the offer on the table. Making sure that I have all this right. In 23,635 FH, you would plead no contest to an amended count 1 that has both officers' names. The maximum penalty is 2 years and or $2,000. In file 23,626 FH, you would plead guilty to count 2 or plead no contest to count 2 and then added count 3, which is larceny under 200, which carries a maximum penalty of 93 days and or $500 or 3 times the value of the amount stolen. Count 2 is a retail fraud in the 3rd degree. It has the same penalty, 93 days, $500 or 3 times the value stolen. In addition to that, the people would dismiss case number 23-3028, which is a retail fraud 3rd degree, a 93-day misdemeanor. They would dismiss 23-905, which is a 1-year misdemeanor, which is attempted R&O. And case number 23-1056, which is also an attempt R&O and a second count of lying to a police officer, which is a 93-day. And you would be responsible for restitution in 23-3028 of $24. And in 23-626 FH, the restitution amount is $27.97. You'd be waiving your right to a restitution hearing in those $2 amounts. Did I correctly summarize the agreement?
There was one correction, Judge. The case that we identified as 23-3028, rather than being dismissed, that case will not be recharged upon payment of the $24 restitution, as it has already been dismissed. And then also we agreed not to charge a case that we're identifying as CTN 23-5195.
And what's the?
That was a potential possession of cocaine charge.
23-5195,
5195.
which is a potential 4-year.
Yes.
Very alleged. Oh my God.
Do you understand the plea agreement right now?
Yes. Yes.
Okay, we've covered the maximum penalties. Is this how you want to proceed today?
Yes.
Okay.
Yes, yeah.
Let's be sworn in.
Can you raise your right hand, please?
Good.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Right, have you had enough time to speak to the public defender's office about how you want to proceed and what the consequences are of pleading no contest today?
May I lower my hand too? Sorry.
Yes, you can. I'm sorry, I can't see that it's
Okay.
up.
Sorry.
Have you had enough time to speak to Mr. Overwater about your plea?
Have I had an opportunity to?
Yes, enough time?
I mean, I've already attested, haven't I? No? I don't know. Like, I think so.
Do you want to talk to him again?
Yes, please. Well, I mean, not if it adjourns this again, I guess.
Mr. Overwater, sending you in a breakout room and a treasure hunt, and we'll recall the case in a few minutes.
Thank you.
Thank you, Your Honor.
Thank you.
Recall number 17 and 18, People versus Devin Martinez, 23-626 FH, 23-635 FH.
Al Chabalowski for the people.
Kenneth Overwater, Assistant Public Defender, on behalf of Ms. Martinez, who is present from custody from the Washtenaw County Jail. Thank you for passing the matter. I did have an opportunity to speak to Ms. Martinez and answer her questions, and I believe we are prepared to proceed.
Okay, you're still under oath, so I have some questions I need to ask you now. Do you have an understanding of the plea agreement now?
Yes. Yeah.
Okay. All right. Are you currently on probation or parole?
No.
And we just covered all of the maximum penalties for the offenses that you'd be pleading no contest to and for the ones that will be dismissed. Do you have any questions about the maximum penalties?
No, yeah.
Okay. Has anyone promised you anything other than what's been stated on the record to get you to plead no contest today?
No.
Has anyone threatened you to get you to plead no contest?
No, yeah.
Okay. Do you understand that if you plead today, you're giving up the rights you would have had if you went to trial? That includes the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond a reasonable doubt that you were guilty, to have the witnesses against you in each of these cases appear and have your attorney examine and cross-examine them, or to order witnesses that you need for court to come by court order or subpoena, to remain silent because you don't have to testify. I won't use that silence against you, or to testify if you wanted to at your hearing. Do you understand you're giving up all of those rights?
Yes, Your Honor.
Do you understand that if I accept your plea today, you cannot come back later and tell me the plea was a result of something that you're not telling me about?
I fully am aware and understand, yes.
Do you understand that if I accept your plea today, you don't have an automatic right to an appeal? You have to ask a higher court for permission. They may say yes, they may say no. In other words, it's not automatic that you can undo your plea. Do you understand that?
Yes, Your Honor.
Okay. Do you understand that if you're not a citizen of the United States, the federal government can take action against you that includes deportation?
Yes, Your Honor.
Okay. And lastly, counselors, would you confirm no other threats or promises?
No other threats or promises, Judge.
None that I'm aware of, Your Honor.
All right. In file 23-635, as to count 1 that's amended to have both officers' name, how do you plead?
No contest.
Okay. And in file 23-626 FH, to count 2, which is retail fraud in the 3rd degree, how do you plead?
No contest.
Okay. Factual basis.
Judge, Mr. Overwater asked me to provide the copy of the police reports. The first one is for the RNO.
What is that? Sorry. What?
Oh, okay. Yes, thank you. And there's an added count 3, Andrea, on 23-626, which is larceny under 200. How do you plead to that?
No contest. This is all part of what I've already agreed to, right? Like with my lawyer?
Yes, this is.
Oh, okay.
Mr. Overwater, this is all.
This is all part of what was agreed to. Camille, the judge needs to establish a factual basis for the plea, so she's looking at the police report.
All right.
Counselors, are you satisfied to comply with the court rule under 6302 in that case?
Yes.
Yes, Your Honor.
I find the defendant's plea knowingly, understandingly, voluntarily, and accurately made. We'll set this matter for sentencing on January 22nd. Overwater, do you want to be present for the pre?
I do indeed, Judge.
Okay. And Camille, the probation department, if you are out, you need to reach out to them and talk to Mr. Overwater, but they're going to do a pre-sentence interview with you to make a recommendation for sentencing. Do you understand that?
Yes, Your Honor.
Okay, you need to make and keep that appointment.
Okay.
Your Honor,
Okay.
she's being released to residential treatment today,
It'll be when a bed is available.
but it's not, we're not waiting for sentencing.
No. I'm just gonna think about this phone. Okay, I'm gonna amend your bond that you can be released to treatment to home and set for sentencing 122 at 1:30. Any questions?
No, just thank you very, very much, Yana.
Thank you.
Yes, you're welcome. We will see you then, okay?
Look forward. Thank you so much. Have a good day.
You
Bye.
too.
Thank you, Mr. Everybody. Cheers.
You're welcome.
Peace, everybody. Love, rock. Sorry.
Supplemental number 1, people versus Devin Martinez.
Your Honor, Jonathan Emmons on behalf of the people.
Good afternoon, Your Honor. Assistant Public Defender Chinabri Carey on behalf of Mr. Martinez. Devin, can you state your name for the record, please? It's beautiful.
Yes, Devin Julia Martinez.
Ms. Martinez, you're gonna need to speak up a little bit. It's a little bit garbled, so I heard it, but it's a little just.
Did you see the recommendation? Devin Julia Martinez. Revoke.
So today's the date and
Revoke
time
in 1
set
year.
for
She's
arraignment.
going to
Ms. Martinez, do you want me to appoint the public defender to represent you on this matter?
Yes, Your
I will appoint the public defender, represent you in this matter until further order of the court. Ms. Carey, I believe you had a chance to go over the allegations.
I have, Your Honor. We were able to discuss the allegations. We reached out to probation. There is a recommendation from probation as well. So in regards to the arraignment, she does stand mute. Well, does she stand mute? No, she's going to be entering a guilty plea. Yes.
Okay, so just let me remind you, ma'am, that this is not necessarily going to happen. You have the right to be reminded of the underlying maximum on the charge that you were convicted of, you pled to. And that was assaulting, resisting, or obstructing a police officer, maximum of 2 years incarceration and/or a $2,000 fine. I'm not saying that's what will happen today, but that is what's on the table as far as what the maximum.
Is it? Okay, it's not
Agent
300.
Seibert, do you want to tell me the recommendation?
Yes, Your Honor, the recommendation is to revoke the probation, 1 year jail, credit for 301 days served.
Yeah, I guess it's every 5 days. Have you raise your right hand to be sworn in?
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Oh, God. Yes.
Okay, you've had a chance to go over all of this with your attorney, and you understand everything that's going on, and you want to proceed, ma'am?
Yes.
Okay, you heard what the recommendation of probation is, correct? That your probation would be revoked if you serve a year in the Washington County Jail with credit right now for 301 days served, correct? You have to say yes, you can't just not. Okay, other than what's been stated on the record, has anyone promised you or threatened you with anything to get you to plead guilty to this violation?
I plead guilty. There's no
And
contact.
did anyone, are you doing this of your own free will, man?
Yes.
Okay. You would have the right to have a hearing in this case. And at the hearing, you would have rights, and they're important rights. And so let me go over some of that with you. At the hearing, the prosecutor will be required to prove by preponderance of the evidence that you violated your probation as alleged in the petition. At that hearing, you'd have the right to have you or your attorney question through examination or cross-examination any witnesses who testify. If you wanted to testify at the hearing, you could testify at the hearing, but you would not be required to. And then finally, if you needed witnesses for your defense, I would order them to appear at the hearing. You understand all those rights, and that by pleading guilty today, you'll give them up?
Yeah.
Okay.
I plead no contest.
And so if you didn't like what happened at the hearing, you could automatically go to the Court of Appeals. You file the papers and you go. But because you're not having the hearing, you give up the automatic appeal. You can still try to appeal what happened, but you have to ask the Court of Appeals for permission to take the case. That court decides whether it's going to hear it, not me. So you give up that automatic appeal. You understand that?
Yes.
Okay. The warrant that was issued alleging your violations was dated October 9th, 2024, and it says that you violated your probation with 4 different counts. There's some detail on that warrant and you were arraigned on it. How do you plead to these probation violations?
No contest.
I'm sorry, go ahead and speak up.
No contest.
I think she said no contest, Your Honor. You can plead guilty, Ms. Martinez.
It's not going to affect the outcome.
Are you guilty?
How do you plead to the allegations?
Guilty.
Okay. And so I'm just going to ask counsel if I can provide them here 6.445 and take you a minute.
Defense is satisfied, Your Honor.
Okay, I believe I'm complying with the court rule as well. I find the defendant's plea of guilty is knowingly, understandingly, voluntarily, and accurately made, satisfied that there is a factual basis in the warrant to support the finding of the defendant that she is guilty of counts 1, 2, 3, and 4 in the warrant that is dated October 4, and I will accept your plea. Ms. Rodriguez, do you object? Ms. Martinez, do you object to me moving to immediate sentence on this matter?
We do not object, Your Honor.
Are you okay with me sentencing you right now? You have to say yes.
Yes, Your Honor.
Okay. All right. Agent Seibert, Mr. Evans, anything you want to add besides what the recommendation is?
No, Your Honor.
Anything you want to add?
Nothing, Your Honor.
Ms. Martinez, is there anything you want to say before I sentence you?
No, Your Honor. Thank you.
Okay. It is a sentence of the court that your probation is revoked and you were discharged without improvement. It is a sentence of the court further that you served 1 year in the Washington County Jail with credit for 301 days served. So that is a sentence of the court. You'll be dismissed when your total sentence is over. No more probation. This Securiac ruling is going to get you what's called an appeals rights form or appellate rights form. That has all the information that you need to try to file an appeal in this case if you wanted to do so. The one thing we need to take away from today is if you needed me to appoint counsel for you to do that, you have to make that request in writing within 42 days. Does that make sense to you?
Can you repeat that one more time? There's a lot of noise out there. There's a lot of noise out there.
If you want to appeal what happened, you can do so. If you needed a lawyer to help you with that appeal, I will appoint that lawyer. But you have to ask me in writing for that within 42 days of today. Okay?
Okay.
Other than that, your lawyer is going to get you the other information you want to appeal. Okay?
Okay.
Any questions?
So am I sentenced to what now?
365 days in the Washington County Jail with credit for 301 days. So about 4 months-ish, give or take. Okay?
How many?
About 2 more months.
Thank you.
Bill Cat, yeah. Okay.
All right, you're all set. That concludes the hearing.
Thank you, Your Honor.
Thank you.
You're all set. Thank you.
Thank you very much.
Get your popcorn, ladies and gentlemen. Make you some coffee. Get you something that'll make you happy for the next hour, because we're going into Simpson's courtroom and we're going to get frustrated right alongside with him. This is going to be a ride, ladies and gentlemen. Let's get it started.
Case of Alec Jerome versus Eric Cassidy. To be Eric Cassidy and Paula Cassidy. Go ahead.
Donna Tope, appearing on behalf of Caroline Jerome, who is watching by Zoom. I recognize Caroline.
Okay.
And Alec Jerome. They are the landlords in this.
Got it. All right.
Your Honor, Francine over appearing with Eric Cassidy. Ms. Cassidy, Paula is not well. She's been undergoing chemotherapy, and so she won't be present.
All right. Very good. All right. So where are we now in this case?
So appeared before you, and I have on the results of that hearing. I got their counter complaint, etc., and I have filed a complaint bringing the non-payment amount that we are requesting for judgment up to date. And it was.
Hold on a second.
I filed a complaint on Tuesday, and we've been given a case number, but I would.
Hold on a second.
Okay.
You filed a new complaint.
Yes, you advised me that the complaint that I had made it.
Okay, go ahead.
So that it would be heard. I gave them more than 30 days to get out. I had that complaint to be heard on the same date that they were supposed to either pay or evacuate. And you said, no, I needed to, because my 30-day notice was still good. I refiled on Tuesday, and I received a new case number, and on that summons and complaint, I noted that there is this pending case because they had filed a counterclaim. And you set this hearing for the counterclaim because Mr. Cassidy's attorney.
No.
Okay.
The last time we were here, I was indicating to you what were, as I'm recalling, were distinctions between the notice and the complaint. And basically gave an option that if I dismissed your complaint, what would end up happening is their counter complaint would survive.
Mm-hmm.
And so therefore I'd have a case that would just have a counter complaint. So you filed a new complaint.
And I would guess that I would like.
That's fine.
I'm asking for, I asked for the file.
Thank you. You read my
I
mind.
did.
Did they open it?
It is open.
Okay. They're bringing it.
Except for next Friday.
Got it. Okay. Go ahead.
Okay, so I guess an order of administrative business, would I request now a motion to join that complaint, or do I need to file a motion to join that complaint with the counter complaint?
Well, here's what's going to happen. I'm going to hear them all at the same time, whether they have two files or one file.
Got it.
So you can file a motion rejoinder if that's what you wish, but.
Okay.
I don't know that necessarily matters. How much are you claiming
Okay.
is owing in rent?
I would like to, I just make a statement. This case is a simple non-payment of rent case based on the agreement to pay rent and utilities for 102 weeks and follow the simple rules stated clearly in the lease and accepted by the defendants. We want $25,891.07 in unpaid rent. Defendants have been in arrears since September 1st of 2023. That's 9 months. And they have paid nothing since December 2023.
Counsel, please.
Okay.
So the first thing, I'm just trying to answer some of the things that are raised that are jurisdictional issues that are raised by the defendants to try to clear the way for that.
Okay.
All right. And so because I don't have the new complaint, I wanted to know what your claim was.
Okay.
And so the dollar amount of it.
The dollar amount for the rent owing through May 6th is $25,891.07.
Okay, so let me stop you there.
Okay.
You can either elect to proceed to collect 25,000, or you're going to have, this case is going to have to go elsewhere, which I say won't necessarily make me unhappy. I don't know, I shouldn't have said that.
Does that terminate the lease or does that get the lease paid up to now? Because the lease goes for 102
No.
weeks.
I have jurisdiction to 25,000 on most civil matters. There is some case law that indicates that I can exceed the 25,000 because it's a landlord tenant matter. But I have to have argument on that in any event. Or what you can do is you can elect to limit your claim to 25,000 and it would stay here. Otherwise, this matter has to be transferred to circuit court.
Okay, so to keep it here before you, that's the first thing, right? To accept
that I couldn't, you need to understand, I could not issue a judgment or would not issue a judgment.
Okay.
For an excess of 25,000.
Okay, so we can
Plus
claim
cost.
that, but in order to have it heard by you,
Or
you
in
would
this-
only, yeah. So you're telling us that that's all we're going to get if we
If
continue.
it stays here, that's all that I can do
Okay,
or will do.
okay. Well. glad you're consistent.
Pardon?
It's not printed or like the paper. JS copy.
There isn't one, but that's all right. I'll be all right. And
so,
Ms. Novart, hold on a second. Ms. Novart, is there anything you wanted to say on that $25,000 issue?
Yes, Your Honor. Is it okay if I?
Yeah, you can say that. That's fine.
Your Honor, my clients are asking for a $2,000 a month abatement of the rent because of numerous things that were never repaired, that were promised to be repaired. So that almost gets us right there to the $25,000, maybe a little short of that, but our counterclaims will far exceed that. My clients have been retaliated against, they've been falsely accused of harboring illegals. They've been spied on, their property was wrongfully entered by Ms. Toe by numerous occasions. She's called the police on them. She falsely accused my client, partner in a law firm in Houston, of assaulting her. So our counterclaims will far exceed the $25,000 jurisdictional limit.
Okay, so if you attach an affidavit to I mean, actually, you don't have in here, I was trying to make sure I go through everything, but you don't have you didn't file a motion to remove the circuit, did you?
Not yet, we were going to do a more, a motion on the record today, Your Honor, if we need to file.
I think there would need to be a written motion with that, with the accompanying affidavits that would be necessary for the court to, because of the way that your counterclaims are stated. There would have to be an affidavit indicating that. Okay, so now here, given that that's going to be their position on the counterclaim, that means well, you just can't make this easy. So that means the entirety of it would go. All right.
I did have a suggestion.
Well, before you do that, I'm
Okay.
just trying to procedurally think this through. So I'm gonna have to take back what I said, because if it had remained here, I'd just operate with two files and wouldn't care. You would have to file a motion to consolidate this new case with this case. You'll file your motion to remove it so that everything goes. Because otherwise what will happen is, I would imagine that once they file theirs, it will go to circuit. Your case will be remaining here, which I don't know. Doesn't make, that wouldn't make much sense to me, quite frankly.
Right.
All right. I would indicate to the parties this, because I don't know why I'm doing this, but what the heck. The other way to go around this would be if the parties were in agreement and wanted sort of a quicker process, is that, and I've done it before in the past, I don't know that I really want to do it here, but I will. And that is that if both parties would agree, I would then talk to the chief judge of the circuit court, have myself appointed as circuit court judge for the purposes of this case, and have it resolved here, and I could hear all claims. But both parties would have to agree to that before I would do that. It'd be the same process. It's just that, quite frankly, with landlord tenant cases, I have no offense to my circuit court colleagues, it's what we do here. So.
Yeah.
Your Honor, would the circuit court rules apply in a case like that if you were to hear it? So all the rules of discovery and evidence and the timeline.
The discovery, everything happens as though it's circuit court. So in district court, there would not normally be discovery until the court says there's discovery. In a case like this one, I would have ordered discovery in any event. But what will happen is that you will have those you'd have the discovery and the like.
So if I had gone through this, one of the things that I was going to posit is that if they pay the rent that is owing to date, the lease will stand as it is for 102 days and mediate the remaining issues, which are what she is propositioning, that, there's been wrongdoing on the landlord's side to the tune of $2,000 a month, and then adjust everything once mediation and case evaluation and all that takes place.
Well, I'm certainly not going to speak for Ms. Novar. I'm sure she could speak for herself, but it seems to me that their idea is that they don't know anything. Ultimately. Right? Or something, but much like.
Depending upon the time frame, there were certain times, at some point, it became owing nothing because of their blatant refusal to do anything. Originally, we were going to ask for an abatement because of major things like air conditioning, central air, which was promised was never fixed, the oven stove isn't working properly. So it may end up to several months, we will ask for no rent at all, but for several of the months an abatement.
Gotcha.
The home has been not without air conditioning and not without heat.
Well, hold on, because
Well,
I can't.
okay, but you're taking into consideration abatement for things
I'm
that
not taking I haven't taken into consideration anything. I just sat here, hold on. I just sat here and said that I'm just trying to figure out procedurally how you guys are going to hear the case.
I would like to do what you're suggesting. I would like to keep it before you. You know, landlord tenant, you have such experience with it, and that's what this is. This is simply a landlord tenant case.
All right. And Ms. Novak, do you have a position on that? And if you don't, if you want it to go up to circuit, I am not, but by no means will I take any offense whatsoever. I will be more than happy. I will carry the file there myself.
That's where I usually work, so I'm very comfortable in circuit court. However, my client and I would like to discuss it. I think what we'd like to do is wait for the written motion to consolidate the cases, and then we'll have an answer for you then at that point. And we would do, you know, at that point, we will probably do a motion to remove, but we would let you know if we agreed to have you hear that versus.
Okay, and so that you also know, just because this is the other kicker to it, it could get sent up and then come right back.
Yeah.
Because
they know,
just so that you know that that has also happened, where I get the call from the circuit court saying,
I see.
This is
hear this.
I understand that, but a number of our counterclaims are really much more better situated in circuit court, where the judges have had experience with the numerous counterclaims that we have. So,
Well,
I don't know.
I think you should understand that I've heard circuit court cases for 25 years. So I'm just saying, it's more the landlord tenant aspect that isn't there.
Right.
But I mean, I am more than happy to send this case out and then let it fall where it may. It's not like I don't have stuff to do.
Your Honor, may I say something else just in general? We've tried on numerous occasions, including 2 days ago or yesterday, to ask, I asked Ms. Tobin an email, would you like to allow the parties to mediate? Can you order the parties to mediate pending the motions that you're about to hear that will be filed in this case regarding the consolidation and the removal? Because the lease requires it. So I'm hoping the district court, with their somewhat equitable power, little equitable power.
Well, no, we have equitable over landlord tenant. I have full equitable power.
So the lease requires it. We've tried repeatedly to ask for mediation, and we keep hearing no, but the lease requires it, number one, and that could possibly resolve everything.
I would like to speak to that point.
Sure.
Thank you. Our lease does require it through the University of Michigan Mediation Center for Students. Paula Cassidy was a student at the time we signed the lease. They did not go and utilize that term that we welcome in our lease. They went instead to Student Legal Services and had Mr. Lewis represent Paula and appear as her attorney. They absolutely closed the door on mediation.
Can I ask this? Because history is fine, but I don't know that I need it right now. I think what I'm hearing from the defendant side is they would wish for this to be mediated.
Yes, and I am telling you why I have told them no, because they closed the door on that. If we can hear the unpaid rent and
Okay,
utilities,
okay.
then mediate
Ma'am,
the
ma'am,
rest.
Ma'am, I don't know. I don't know what happened before,
Right.
right? All I have is what's in front of me, which is quite frankly a lot. What I'm hearing from Ms. Novar is they would wish the case to be sent to mediation so that the parties mediate. Okay? Regardless of what's happened before, the question then becomes, are you amenable to mediation? I will say also that I can order it to mediation. So, I mean, I typically don't, because I can kind of waddle through what needs to get through, and sometimes I can handle it faster than getting mediators set up. But are you willing to mediate it or no?
We are willing to mediate, but only on the things that they claim should result in abatement. We have rent that has been unpaid. It's caused a hardship for the owners and the landlord.
Okay, so here's the thing. And I guess maybe you should look at it this way. What you have are what are really going to be sort of these firm contractual numbers.
Yes.
Okay. There's, I don't really want to call them soft because I think that's not the way to really look at it. They're going to have numbers when they're talking about abatements and other things, which are the sort of softer side of, and sort of dig into those hard numbers.
Right.
So you can't, it's impossible to separate it out. So there, for example, there would be no way I would take your claims of those hard numbers of, just adding up each month, let that sit there and then send everything else to mediation, because I don't know what then they're mediating against or mediating with. Does that make sense to you?
It makes perfect sense to me, but meanwhile, the owners, landlords have been with the utilities not being paid. We pay the utilities. They have not reimbursed us under the terms of, so, I mean, can we get partial payment and have the abatement amount that they're saying withheld from the payment partial?
How would you, okay,
I'm just trying to get something.
How would you expect me to do that?
I don't know.
Because here's the only thing that I could do. But I could do this, but it doesn't help you. I could order escrow. They could pay into escrow, but it's going to sit here until such time as whatever is resolved and the court orders the escrow split. Now,
our greatest fear.
But hold it. The only exception to that I've made over the years is when something's not paid that jeopardizes the property itself. Then I will order paid out of escrow those funds to preserve
the
property.
Perfect condition.
But other than that, I mean, so the bottom line to it is, if the parties want mediation, it all goes, or none of it's going to go. Because it doesn't make any sense to do it any other way.
Your Honor, one of the reasons we want mediation, honestly, is because I feel that, in all due respect to Ms. Toth, that she's been an impediment to settlement. And so I feel if we can get the landlord at the table with the tenants, we have a much better opportunity to settle the case. Not to mention the fact that it is required into the contract that both parties sign. And Ms. Cassidy is still to make you about.
You know, we wrote a really great lease. We had mediation in it. They withheld rent for no given reason. I would, and either party can, under our lease, either party can request mediation at the University of Michigan. If we go to mediation, I will utilize that part of our lease.
If you what?
If we decide, if we agree to go to mediation, I will go to the University of Michigan's mediation that is part of our lease instead of, you know, looking for someone outside to mediate.
Just to clarify, Your Honor, the lease calls for Michigan on-campus housing program to do the mediation.
Is that who you guys want to do the mediation?
I mean, I know a number of good mediators.
I'm not paying a mediator.
If they're limited to, then that's fine. We would agree to do that. We're required, in fact, to do that.
What do you want to do?
Oh, sorry, what was the question?
Well, I'm asking what she wants to do.
I think I just said what we would do. I would agree to mediation. I will go to the University of Michigan. I'm not paying a mediator.
And you're agreeable to that or believe that you may be bound to that?
Yes.
So, if that's the case, do we think that the parties can stipulate to an order sending it to mediation?
Yes.
And then in that order, and so you would send both these cases to mediation. The case at this point, and I like Snovar's idea, the case would stay here. Okay. And I just think in the stipulation to send it to mediation that neither party is waiving any right to remove the case. That issue is not being addressed, but it's being sent to mediation. So then you guys can have that fight later down the road.
Could this be folded into a stipulation to consolidate the cases and agree to mediation under the terms that you just said, so we don't have to have separate motions?
Ms. Newmeyer, it really, if she moves to consolidate, are you going to have an objection to the consolidation?
No, we're not gonna.
Okay, so just, why don't you stipulate to,
We did that step first before we did our motion to remove. I was under the impression of.
pardon?
We needed that step before.
No, you're right. But I think if it's gonna go this route, if you can make part of the stipulation that you're consolidating these two cases, send it to mediation, doesn't waive your right regarding the to claim removal, and then we move from there.
But we would like a 30-day limitation if possible, that we need in good faith within 30 days. If it provided.
What?
To you, Michigan Housing.
What?
I mean, we're gonna limit cases of
Yes.
language.
Hold on. Okay, what's your objection to what council's proposing?
They haven't paid any rent or utilities, and now we're pushing it on down the road, and we're just.
I think, hold on.
I'm just expressing my frustration. That's.
Well, yeah, and then when I start expressing mine, that's when things get bad.
I know.
So listen, here's
you're
going to be the
patient.
problem. Here's what I heard them say. Okay, so that you understand. What I heard is almost put it on an expedited track.
Yeah, within 30 days, yeah.
Right, I
get it.
I mean, I was surprised actually when it was said, because normally for me, if I send it to mediation, I'm not seeing it for a while. And 30 days is maybe too soon, but anyway.
I think
do you have a problem with that?
No, I don't. No, I don't.
And
thank you for asking.
And here is so could do that. And then here is the other part of it. And I don't really like to interfere with anybody's particular position on their cases. I just, let people argue their cases. But man, I'm going to be frank with you, because, and then if it stayed here, there's a jury demand, so I think I can say it anyway. The negotiation in good faith is really going to be clear.
Yeah.
Okay. It needs to be done. Now, I'm going to let you know that when you came in here the very first time, and I get parties start yelling at each other about whatever. But you immediately were trying to sort of convince me what bad people the Cassidys are. Yeah, you were.
I only told you that he physically assaulted me.
Ma'am,
said nothing about personal.
Ma'am, I'm going to tell you how the court was taking it then. Maybe I'm all wrong. And what I'd suggest to you is that as you go to this mediation, that you just take that part out. And that you try to negotiate the case for what the case is.
Yep.
For all I know, all of you are bad people. I have no idea. All of you are good people, but I assume that everybody is a good person until they show me otherwise. But you also have to listen to what their claims are. You don't have to agree, but you have to listen to it. Now, I'm going to tell you this, man, because when Ms. Novard talks about maybe being an impediment toward trying to resolve it, typically with most cases, where that happens is only where you're looking at your side. It doesn't mean that you don't want to win. It doesn't mean that you don't want to come out. It doesn't mean any of that. But you've got to give some credence to what one side is saying or the other.
That's why we have it in our lease.
Yes, but the parties have to do that, ma'am. And I'm talking specifically to you.
Yep.
Because every time you come in and whatever, when the Cassidys appeared here on their own the first time, whatever he was trying to raise, you didn't even hear it. I didn't ask you to agree. You just didn't even hear it. You didn't even hear what he was saying. And if you don't do that, I mean, there's skilled mediators. I get it, but it's going to be a failure. So, I'm going to hope and I'm going to pray that each side is going to do that as you go into mediation, but I don't know. I mean,
It's part of our lease, and in good faith, I follow the lease, and I will participate in mediation with everything that is expected of me as a representative of my clients. I know they want that, and I will do it.
Can we also remove the May 31st, the second case, the one that was just filed, except for May 31st, remove that from the docket?
Yeah, I'm taking it all off. Once I get that order, everything's coming off my docket. Okay, but I will have to give a control date. And so how And that always can be moved, but how long from the time are you looking to have mediation continue? Or what window do you want to kind of give?
I have no idea of what.
Their availability is.
Yeah.
You're right.
But we may pull in another attorney for Paula. We may actually pull in a U of M attorney.
Got it.
That way that may help us.
May help get it there. Okay,
So I'm hoping we can get in within 30 days.
all right, so let's do this. Why don't the parties find out? Let me adjourn this out to the 31st.
Either of us are available.
On the 31st, okay. If people could think they can get everything done in a week, I'm here on the 24th. I'm here every Friday.
We can contact U of M Housing just in general to see if they can mediate, but.
Why don't-
Take a couple weeks to bring U of M attorney on, please.
Right. Well, why don't I do this? Why don't I set it for next week? Okay. And then you can come back with, and maybe the parties can exchange the stipulation regarding mediation. See where we are. If we run into a hiccup, then I can try to deal with that. And then at least if the call is made, then at least maybe you can have a framework as to, and then we can sort of guide ourselves that way. I think that might be it.
That sounds good. Would you be able to do that appearance by Zoom?
I don't see, if we have the paperwork here, I don't see why not. Okay, if you send it to me before then, everybody can appear via Zoom. What time would that be?
3 o'clock.
All right, so we'll set you for the 24th at 3 o'clock. Okay,
Yes, thank you.
thank you. I wrote nothing. And yes, come on. Fortune stands in recess.
So yes, they actually adjourned until yesterday. Anybody interested in seeing what happened yesterday? I am. Now comes yesterday.
Case people versus Alec Jerome. Eric Cassidy. State your appearances, please.
Donna Tope on behalf of Caroline Jerome, who's via Zoom,
Yes.
and Alec Jerome, the plaintiffs in our case.
We have your Francina Park, with defendant Eric Cassidy. Paul Cassidy's not today.
Okay, I thought that the parties were going to come back today with an indication of a framework for mediation through the University of Michigan Housing, or whoever it was. And there was going to be timeframes and the like. Not what I got.
No. So,
And we've already done some work to find out if we would accommodate our needs.
so you're hearing both our complaint, which is case number 241C1772, and also their counter complaint that is an earlier case. And the thing that I want to know, would like to know first is, you mentioned consolidation. Would that happen?
No. Hold on. What I said is, both of these files are gonna come out to me. Whether it be a formal consolidation or not, as long as it remains in this court, I'm it. So, I mean, whether I work out of two files or one, hey.
Okay. Well, so I guess my question is one of procedure. Do you hear their complaint first, their counter complaint, or do you hear our complaint second or first?
Why does that matter for you?
Because I filed a motion for my case.
Let me just shortcut this. I'm gonna hear, if I have both files before me, I'm gonna hear whatever needs to be heard in an order that makes sense to me.
Okay.
That's how that's gonna work.
Okay, so I also filed a statement on mediation.
Oh, I got it.
Okay, so I also contacted the University of Michigan Mediation Services, and I had a very good, long talk with my clients who attended the last hearing. And that statement on mediation is what we have come up with. We would like our complaint to be heard as a landlord-tenant complaint for non-payment of rent and termination of tenancy because they have not paid any rent and they have not paid any.
Okay, I get each party has their claims.
Okay.
But are you agreeing, the contract indicates that it will be mediated?
The contract indicates that either party can request mediation, but they did not do that before they withheld rent.
Does it say that they have to do it before they withhold rent? That's not what I read.
You gave me a really wonderful, precise, and pointed statement on good faith. We are convinced that any mediation would not be met with good faith based on all of the interactions that have occurred during the entire time that this situation has existed.
Let me stop you. They request mediation, which I think they have. And as I read the contract, when either party requested, it should happen. What would you, after you get finished saying everything that you're going to say, what do you want me to do?
I would like you to hear my motion.
So what you want me to do is ignore the contractual language of the lease and just do it your way?
I think they ignored the contractual language of the lease. They contacted an attorney and the attorney represented them, Paula, and them at our hearings.
Are you talking about Mr. Navarre?
No, Mr.
Doug,
Lewis.
okay. And
that, to me, was that they were not following the language of the
okay,
lease.
so hold on a second. I don't even know why I'm going through this, because do you want me just to order mediation? Because I'll just order it. And then we don't have to go through all of it. I mean, I thought the parties, when we got here the last time, I thought the parties were going to look into the process of mediation because we were looking at, you wanted something quick. And I think Ms. Navarre said that she would contact and they were gonna figure out how fast they could get it. And that's what we were gonna come back for. I set this basically as a check to make sure it just didn't linger out there and try to develop a time frame for how this would occur. That's why I thought, that's where I thought we were. And then I get this statement basically saying you don't want to go to mediation. And that doesn't make any sense to me because the contract says that. I think both parties agreed that.
Well, I think they voided that part of the contract when they went to an attorney.
My goodness. How, when they went to an attorney?
They got an attorney. They did not go to mediation. They did not request mediation. I did not request mediation. Either party could request mediation. They did not request it. They hired an attorney and bypassed it. So, yeah, if you order mediation, we will definitely comply.
Well,
We
here's
will
what's gonna
comply
really
and
happen.
pay.
Here's what's really gonna happen. If I order mediation, I'll order mediation. Otherwise, what's gonna ultimately end up happening, once everything's in place, you're gonna be in mediation with me, which is just mediation with a hammer. So it's gonna happen one way or another, but I guess my issue was, I thought that's where we were. And that's now not where you guys are.
Well, we haven't really consulted.
No, I know, when I said you guys, I was not including you. I was not including that side of the room. I'm sorry. Why don't you want to go to mediation?
We have serious reservations about all of the things that have been said to you during the beginning of this.
Okay, everybody has said all kinds of things.
That we're going to be met with good faith. We have serious doubts about that.
Okay. You have serious doubts about that? They, I'm sure Harris will have serious doubts about that. I gave my admonishment, thinking to both parties, but also based upon what I had already seen here. I gave my admonishment that all the parties should be acting in good faith. Plain and simple.
And I did tell you that that clause is written in our lease because before anybody goes to an attorney, if there are issues, both parties.
Does it say that?
It does say that in the lease. Before
what?
Before the issues are under litigation. It says.
Okay, the fact that somebody goes to an attorney doesn't mean it's in litigation.
Oh yeah, because he appeared at the hearing on my summons and complaint. So that, and we were then sent to you. The lease says, and it's 37 or 34, no. It says, a mediator can't, if communication between tenants and landlord breaks down. There was no communication. He told me the night before rent was due, he was withholding rent, and he withheld rent since then. And before, if communication between tenants and landlord break down, a mediator can assist the parties in voluntarily reaching a mutually acceptable settlement of the issues in dispute. There were no issues in dispute. We had no knowledge of why he was withholding rent. He just said, we're withholding rent. And he said his wife had retained an attorney.
What is your reluctance to go to mediation?
Oh my gosh, because they have withheld all of the rent. In landlord-tenant cases, only the most catastrophic situation allows for that.
That's not true.
Well, that's
just not true. Oh my gosh. I mean, no, don't say, oh my gosh. You say, oh my gosh, one more time, I'm gonna find you in contempt, and then we're gonna really have a problem. Because that's disrespect.
I mean no disrespect. I'm really saying, oh my gosh, to myself. I'm sorry. I did not intend it for you.
So Look, I don't, here's what I don't get. Okay, just from a practical sense. If you go to mediation and the parties with a mediator try to work out whatever the issues are, right? If it doesn't work, you're here. But the issues typically, when cases are sent to mediation, the issues that are involved get narrowed and they get clarified. And that's where then, when it comes back to the court kind of enters into it, and it's much clearer of what you're dealing with. So there's some benefit to it, or can be some benefit. If you're looking for some expedited process, I don't think that's going to happen. I'm looking at this file. It's not going to move. The period of mediation is not going to make this file move any faster here. If that's what you're looking for.
No, we're not. What we're looking for is some kind of financial certainty that you had mentioned escrow, and my motion is to escrow the amount in arrearage. I know you said that you are capped for $25,000 in landlord-tenant cases, but I'm wondering if the arrearage is more than $25,000.
Well,
are you able to?
If you're talking
that amount?
I'm not going to even answer that question. I mean, I'm not capped at the $25,000 limitation is really on the money judgment. On the possessory judgment, it could be whatever number. But in terms of a money judgment, that's where the limitation goes in.
Okay, well, I don't know the fine points, and so I was asking if we, in our motion, we ask that the arrearages be escrowed, and if that happens, we would
Okay, so first of all,
participate in mediation.
no. I don't know how you think. I don't know what you're negotiating against. I mean, I just don't. You're negotiating saying, well, they got to do X before we're going to do Y.
Well, if it's held in escrow pending the pendency of the case, and we go through mediation and we come to some kind of an agreement, then what was escrowed would pay whatever we come up with in mediation, which could be something less, and they would get the rest. But how do we just keep adding the arrearages on? This was, close to over $32,000 of unpaid utilities. How can unpaid utilities be mediated? They use them. They lived in the house. They've enjoyed the heat. They've enjoyed the electricity.
You're asking me a hypothetical. I can't answer that.
Well, I get, yeah.
There's no way for me to answer that. Certain things can be mediated. Certain things I think that maybe shouldn't or can't be mediated. They happen to be mediated and have success. I mean, I don't know.
And so we go into June 1st is coming up.
How much is monthly
They
rent?
pay nothing.
A month.
Yeah.
Well, ma'am, first of all, and so when you say they pay nothing,
no,
it's not entirely true. If you are requesting an escrow order, I will consider that.
Okay,
but not with an escrow order that's in compliance absent certain circumstances, because you're asking me to go back and tell them to put money into escrow. Usually escrow orders, except under the most extreme circumstances, are prospective.
Which they probably should have done instead of withholding all the rent. If they had problems, they should have done that. But
I should have stayed in bed today. I can tell you, they can say you should have done anything. I don't know what you want me to do with that, about what they should have done.
I don't, I'm, Your Honor, I'm thinking out loud, and you have been very good. You have been very patient and with your comments that all contain a nugget of information for me when you are telling me that I'm not making any sense and that this isn't, I thought we had it all set.
So that's getting across?
Some things are, yes, it
Okay,
definitely
okay.
is, but so that's what I'm thinking out loud about is the small little crumbs that you have put out that I am trying to follow.
Okay, so let me
to
ask
the
you this.
cottage.
Yeah. If I order escrow beginning June 1st, will you go to mediation?
Oh, yes, absolutely. We are
Okay.
so worried about the finances.
All right, everybody's worried about their finances. But she has her hand up. Your client wants to say something. I don't know.
Your Honor, just to say, the reason after speaking to my brother, we resisted mediation is because we had this house, we're very new. This is our first house we've ever rented. And Donna is very by the books, and she insisted that we do everything, and we worked and we got it ready, and we had it inspected. We had it inspected twice and it passed. So when the tenants suddenly started withholding rent and very unclear as to why, then it was a lot of money and it didn't really build the trust between us for mediation. So I think I don't need you to do anything. I just wanted to state that. I don't need to interrupt the court. You guys know what you're doing. But I just wanted to say that breach in trust has really affected this investment that
No, I got you, but
okay,
ma'am, I'll just tell you, part of the reason I have to do this every day is because there's a break in trust between people. So I get it.
Yes.
Okay. So I mean, I get it for various reasons.
All right. I just wanted to say that. Thank you for hearing me.
Thank you for listening.
All right. Ms. Novar, what would you like to tell?
I don't even know where to begin, Your Honor. In addressing the mediation issue, you have been fully informed, but I hear the court going in the direction of ordering mediation, which is what we want. In August 31st of 2021, my client emailed and told the landlord they were withholding rent due to no effects. That's in writing. And they told the landlord that they were hiring up notice. They've got things not looking from day one of etc. Air conditioning is not working.
Your Honor.
So why are you interrupting?
Because you did not allow me to address those same things
but
the last
hold
time
it,
you brought them up.
But hang on. You expect me to have Ms. Novar, she sat there patiently saying nothing while you went on about mediation. Particularly, it seems to me that what she's addressing right now is I'll call it an accusation, that they didn't tell you anything and that's why mediation shouldn't happen. I think that's the issue she's addressing. She's saying, look, they told them, and this is what they were talking about the defects.
His email to me said, we are withholding rent, period.
Your Honor, it's our exhibit 4. It doesn't.
I know.
It doesn't say that. Your Honor.
Yes.
This is the strangest case I think I've ever been part of.
Well, you should come to my world sometime. But go ahead.
The is that our clients withheld rent. They told them why they were withholding rent. Those still issued, and then they paid it in December. They had a family a very tragic event occurring with his wife, one of the tenants. So they had to go to Houston for treatment and surgery. And so they just said, we're gonna pay it. Let's hope when we get back, these things are taken care of. When they got back, not only were the things not taken care of, but now we have a mice infestation. They refused to do anything about the mice infestation. They called Terminex themselves. So they've been good faith. They paid their rent, hoping that they would see change, and they have not seen change. We're still dealing with the same issues they've been dealing since June of 2023. I think it's not number one, and number two, I think it's unreasonable to ask for back rent for the reasons the court, not only that, the court rule doesn't allow it. 4.201 I2 says it should be escrow, future escrow.
And just so that we don't have to worry about that, the only time that I ordered that, that's why I said it to extreme circumstances, I use what equitable powers this court does have over these cases to order that held. I don't see that here at this point.
So then at this point, I guess we're asking the court, and we have an order proposed pursuant to the lease. We're asking the court to order that the parties mediate. We have found out from University of Michigan, they can call their program down to now. They're happy to mediate, and they can do so. Very quick order, within a week or two, I think we could probably get into them.
Within a week, really?
And we asked for mediation way back in September, and then Mr. Cassidy again in writing asked for mediation on January 27th, I believe it was. So we've numerous times have asked. I think their position is once they hired an attorney, it means they don't want to. Which is ridiculous, and the lease doesn't say that.
Yes.
So I would ask the court to enter our order for mediation. Did the court want to address the other issues as far as consolidating the case and then the jurisdictional $25,000 issue?
I think my thought, quite frankly, was we were going to get it to mediation. Those issues were going to kind of be held off, seeing if it could be resolved at this level in mediation. That is how I envisioned when I left last week that this was going to proceed in that fashion. I thought everybody was on board with that. Okay. Is there anything else you wanted to say?
Just that if you allow escrow, prospective escrow, can we at least get an order for the payment for the unpaid utilities, electricity and gas that now are $3,418.78.
Look, folks. All right. I realize that there may be some financial pinches and strains. I get that. But every time I ask a question, I'm not going back to that issue. Just not.
So mediation is going to include the rent, the utilities.
It's going to include all issues.
And the court costs.
It's going to include all issues.
Okay, will you formally, do I prepare an order for you to sign about prospective escrowing?
Oh, it's just called escrowing, but can I see, have you seen the order prepared by Ms. Novak?
No.
My client sent it to me right before court. So.
Pardon?
This is just the order for mediation.
Yes.
This is just the order granting mediation. So, I mean, we will sign this. We also.
No, okay, you need to understand something.
Okay.
Well, I don't, I don't know what other courts do entirely, but if I'm gonna order something, I'm gonna order something and I'm gonna order something else, but I'm not doing this. We will agree to this if.
We just need a little certainty
Certainty of what?
somewhere down the road. These people who have been underwriting their residence for.
Look, I have no reason, and that's what I'm talking about. I have no reason to believe that one party isn't gonna do what they're supposed to do or that another party isn't gonna. I don't have any basis for that. And I think I was indicating that to the parties the last time. I'm going to assume that people will act in good faith. It's really as simple as that. And so here's the other thing that I'm going to order. So hopefully we can make us more problem. I'm inclined to sign this order for mediation. All right. Do either of the parties have a time frame they believe for the length of mediation and timing? And what I mean by that is usually when we're sending, this isn't going to be unusual, certainly. When we send cases off of the summary proceedings docket, I indicate that mediation should conclude in 45 days. The parties can then, of course, come to me and say, well, we're close to doing whatever. And so can we continue? And then I will make a decision as to whether or not it moves. So that's typically how it works. And so I guess, do either party have a suggestion as to how long the mediation process should last?
I also talked with them, the University of Michigan. It's not on, what is it called? On site, on campus?
Off-campus housing program, which is what's contained in the lease, which is here. It may have some new name,
Right.
as long as it's whatever.
And I was told that, yes, we would be able to be heard within a week or 10 days. I would guess that if we set 3 weeks from today, and then if mediation is going well and we need more time, we can come back and ask for that. Or come in and present the result of mediation.
All right, here's what I'm going to do. Parties, I'm going to sign this. We're going to do two things. I'm going to sign the order for mediation. The parties are to cooperate in mediation. I'm going to add one thing to this order, and that is that mediation to conclude by, and I'm going to put June 21st, 2024, unless otherwise ordered by the court. So that's the first thing that I'm going to do, and I'm going to sign this order. So now this case is headed to mediation. I'm also going to enter an escrow order. In fairness to the parties, here's what I'm going to do. People can be upset with me if they want. I'm going to order that escrow will start May 15th. Okay. No, May 15th. No, it's okay. If you want to get up here and order here, you want to. I'm just saying, if you want to do this.
It looks better on you.
So we're
You
gonna
look good in
start
black.
escrow May 15th, which is going to then require that plaintiff post 2,000, if monthly rent is 4,000, you need to post 2,000 in the court escrow for the month of May. 4,000 would need to be posted for the month of June and each month thereafter that the matter is proceeding. Make sense? All right.
My question is,
Yes, ma'am.
utilities go month to month. I have given them the utility bills. Will we be able to escrow the utility bills? If they're going to be under mediation? Going forward, not going back.
Let me just ask this. Average utility bills per month, what utilities are?
I included the most recent invoice, and.
Well, I don't. Okay, first question.
$340 was due on,
Can you let me
May
get
1st.
my question now? What utilities are we talking about? first of all?
Electricity and gas.
Is that all through DTE?
Your Honor, as I understand it, this is very odd again, the utility, my client's never seen the utility bills.
Oh, I've sent them all. I've sent them all.
He tells me they've requested them and they haven't even seen them.
They were sent with every invoice.
Yeah, I requested them in January, February. It's the first time I've seen them. Yes, we've seen the bills.
Okay.
I've seen cars.
So,
We need to see all the bills.
well, but hold on, folks. Yeah, I mean, and that will at some point happen. But it's just gas and electric.
Yes.
It's all DTE.
Yeah.
Right?
Yes. DTE. There's no water, no sewer.
Okay. So then, are they, who's paying the water?
We, in the lease,
That the landlord's paying the water?
we keep them in our names so there's no transfer fee and to ensure that there's no shut-offs for whatever reason. And then I bill with the rent on a monthly basis.
Bill what?
The amount of the utilities from the past month.
Okay, and so what I'm asking is what utilities are you billing for?
Just DTE and
Okay, listen, just listen to my question.
I
Water, no, just listen. Water is basically paid for by the landlord.
there is no water bill. We're on a well.
That's all you needed to tell me. You're on a
Okay.
well and septic,
Yeah,
right? So there is no water.
that's what I said. I did say that at the beginning. There's no water and no sewer.
Okay. And apparently I misunderstood. All right. So the only utilities, let's just boil this down, folks. The only
Yes.
utilities are DTE. Every utility that would need to be paid for by the tenants is DTE. Okay, so. And I don't have a problem escrowing part of, or the utilities. However, what's the average utility?
The average utility bill when they are in residence is about $340. 320, 363. That's the last 3 months. That was ending 4/9 and due 5.
Okay, all right, but here's the thing.
Okay.
And this is gonna be part of what the problem is. I'm assuming these bills go up in the winter.
Yes, we do not pay a budget. We pay as they occur. but it's AC. So, the heat in the winter offsets the AC in the summer.
Do you have the utility bill amounts for the last 12 months?
Yes.
Okay. So with those bills, what's the average?
I don't have.
You don't know.
Well,
All
no,
right,
no, no.
so
I know I got the total and I can divide by 1, 2.
what's the total? What's the total over the last 12 months?
11 into 2,571. $230, $240 a month, average.
What'd you just do?
I just divided the total.
Give me the total amount that you have right there of what you're saying the bills
The
are.
bills that have been unpaid are $2,571.64.
Okay, great. And that is over how many months?
11.
Give me.
$233.79.
$233.79. Okay.
We dispute that. They paid some of them. I don't dispute that number. I would also remind the court, the landlord has $7,000 in security deposit.
No, I know, but I'm not even to that. They're not out, so I can't deal with that at this point. Well, hold on. I'll get to that in a minute. Jeez. Okay, I'm not gonna do it this way. I'm not gonna do another divide. I'm just not. So if somebody wants to appeal me on that, they appeal me on it. I'm gonna order that you are going to pay that $233.79 into court escrow for each month. You're gonna pay that full amount for May. Okay, I'm not gonna half that. I just okay. So it'd be for May, it'd be $2,233.70. You said 79 and
Yes.
79 cents. And then for May, it'd be $4,233.79.
I think you mean $233, not 2,000.
No, 2,000 is
No.
the rent for half of
Yeah.
it.
Oh, sorry.
Right, got it.
Okay.
That's what I did.
Yep.
Okay. So that's what we need to be deposited. The rent or the escrow for May, you'll need to do that within 7 days of today. And then for June, it's 7 days from when it's ordinarily due, but it will be due by the 7th of each month. Okay? All right. Yeah.
Can I ask that you add that this continue monthly until order of the court? So that if we have to go mediation
Okay, the
longer?
way the escrow order works, it continues
Okay.
till this matter concludes
you.
or until I say
Just-
whatever.
Just,
That's the way it works. You understand that, sir?
Yes, I do.
You'd have to continue to pay. If we're here in 2027,
No.
you still gotta pay it. Okay. Then I'm gonna give a control date on this for the parties to come back. If there's no further requests from mediation, so mediation basically would have to conclude without anything else by June 21st. I'll set this for a hearing June 28th, 2024 at
3 p.m.
3 p.m. Yes.
I can't make that. I'm celebrating my 80th birthday up north with my family. And we start on the 27th. So if you make it earlier, that would be all right, because I
Well, I
think,
don't want it earlier because I do it on Fridays.
oh, okay.
And so the 21st, I'm here July 5th. Will July 5th work?
That's the Friday after the 4th. Yeah, I'll be here.
That's why it's the 5th. Yes.
I'll be here.
All right. What time?
I don't have a time yet. Well, it's the week after, so 12.
12. July 5th at 12 noon.
Thank you, Your Honor.
Okay, now let me try to address one other thing, and I really want to make more issues than we have. There's a $7,000 security deposit. Why is it 7?
Because they have permission for 2 dogs, and our policy is that we collect a dog security deposit of $500 for each dog. And so the security deposit for the rent is $6,000.
Okay. It might be an issue. All right. Pardon?
They're very nice dogs. I've met them.
Your Honor, we have one other issue that.
Oh,
Can we raise it?
no, you go right ahead. That's fine.
And what really brought it to our attention was a statement on mediation that Ms. Tope filed. She has really made herself a party to this and a witness to all of these. We are suing her individually for defamation per se. We're suing Ms. Tope. She's made police reports, false police reports against my client. And I'm seeing a possible conflict of interest pursuant to attorney ethics that will require her to not represent the Jeromes moving forward because she is a witness and also be personally sued. And so I don't know if the court wants that issue before us at this time, but it's an issue that I was alerted to this morning as I was reviewing for pleadings.
So I wear 2 hats in this situation. I am the landlord's agent in managing the lease. And that situation that I described occurred while I was performing my responsibilities in managing the lease. Once we had to file for, once the plaintiffs decided that they would file for withholding rent, they asked me to represent them as an attorney. So I think in all of the proceedings that are requiring the landlords to be represented by an attorney, the situation that occurred against me personally should have no bearing on my representation of them. That's denying them.
Okay. So the short answer, Ms. November, to your question is, I would like that. I won't address that today, but that would have to be raised by a written motion before the court, giving ample opportunity for Ms. Tote to respond. Counsel, I would, and why I think it would be best that it is in writing. And I'll just say this, and I don't have the answer to it, but I think what Ms. Novar in part is indicating, you both may be talking about the same thing in a lot of ways, because if you're acting in one capacity at one point and something occurs, and then litigation ensues, it may very well be that you were outside of any claim that might be made by the defendants in this case, that you may be a witness to the proceedings, and so may be in a position where you could not proceed forth.
And that, I
So,
understand.
yeah, and I don't, like I said, I don't want an answer to it.
No, I know.
Because I'm just saying, that's the first thing that, outside of what Barbara was saying, that's the first thing that came to my mind after you finished saying what you were saying. So it may be right, but I think it's probably better if that be the case, that be put in writing right before the court. And then after you see what their issues may be, ethically, you may think, yeah, they may be right. Let me do X. Or you may say, nope, I don't think they're right. Let the court decide whether or not it can be here or not. That's probably a much better way for us to proceed on that. All right, is there anything else? Seriously? Nothing? Okay. All right. Then-
Wonderful vacation. You said you were gonna have a blast.
Oh, I am.
Does it begin now?
The moment I walk out to my truck. All right. So, all right, folks, you guys have a great holiday and be safe, please. Ms. Novara, could you prepare an escrow order for the court signature? To the court, thank you.
How would I submit that? Should I email it?
Yeah, you can actually email that right to Ms. Wiley. All right. And it will get to me. Thank you. What is she doing? What is she doing? Just walking across my well. Alan, take her down. Alec Jerome versus Eric Cassidy. We set the motion
Yeah, so that it's,
today.
yes.
Okay, that's what I thought. All right. Council, state your appearances.
Donna Tope, I'm here on behalf of the plaintiffs, Alec Jerome and Caroline Jerome. They are here by Zoom.
Yes, I do see that.
Good afternoon, Your Honor. Francine Novar appearing on behalf of Eric Cassidy. Gail Rosen from University of Michigan Student Legal Services has filed an appearance on behalf of Paula Cassidy. However, Ms. Rosen is at a conference this week, and so we are proceeding without her presence.
All right. I think the first order of business that we have to take up is before it goes any further, is the motion, I think, filed by Ms. Rosen. So I don't know, counsel, if you were going to, well, who was going to argue that motion? She's not here.
I'm fine arguing the motion, Your Honor.
All right. And counsel, you received a copy of the motion? Okay. I did not get a response to the motion, but
I haven't had a chance to respond, but I will today.
okay.
Your Honor, I did also mail the motion on Monday and email it as well.
All right. Well, without here, I've reviewed the motion and I don't need much argument unless somebody wants to argue. And I guess, Mr. Tope, I would ask why wouldn't you be disqualified as counsel? I guess I'm going to start there.
That's fine, Your Honor.
First, because, sorry about that.
What would
Why wouldn't you be disqualified as counsel in this case?
Your Honor, their counter complaint is this, their complaint or their motion to disqualify me is premature. It's not right. There's no certainty that the cases will go to trial. The plaintiff's right to the legal representation of their choice would be irreparably damaged if their attorney, me, were not there to represent them during the preliminary steps before trial. If the case does go to trial, defendants can make the motion then. The defendants claim in their brief that there is a conflict of interest. A conflict of interest does not exist. I, Donna K. Tope, MSJD, has no legal or personal relationship with the defendants in this case. Donna K. Tope, as plaintiff's property managed agent, has no legal or personal duty or legal relationship with the defendants of any kind. The legal brief is an error. Donna K. Tope, MSJD, me, the plaintiff's attorney, is not a party in any of the Cassidy's legal filings. Their counter complaint is against Alec Jerome, Caroline Jerome, Cambridge Family Holdings Property Management Company, and Donna K. Tope, the Jerome's property management agent. The complaint is a documents case. It is a landlord-tenant case for non-payment of rent and termination of the lease. And that the Cassidys violated several terms of the lease between landlord owners Jerome's and the Cassidys.
Okay, Mr. Let me stop you for a moment.
Mhm.
On some of that, you may be correct. But I think the biggest problem that I see, and there are a number of them, but the biggest problem I see is you representing in a case in which you may be a witness.
And my next point is directly on that point, and that is that the case is based on the Cassidys withholding all rent and utility payments, beginning with those due September 1st. The defendant's defense is limited to the legal basis for the claim that those repairs were so egregious and made the home so unlivable so as to rise to remedy of withholding all rent beginning December 1st. There are 4 different witnesses. They have filed the case against Alec Jerome, Caroline Jerome, Cambridge Family Holdings, and Donna K. Tope. All 4 of those people could be witnesses for any of the evidence.
But counsel, that doesn't negate the fact that you could be a witness.
I'm not an essential witness. There are 3 other people.
But hold on, I think that you are, if what's contained in here is correct. And that is that you're having these conversations with the other parties.
I'm having these conversations. Could you be a little more specific?
Well, but you're arranging certain things. You're the one talking to them. You're the one dealing
As
with
the
them.
agent is okay.
Right. I get it. I get why you're doing it in that capacity. I don't have any issue with that.
I'm just trying to understand.
Right. What I
we're
have an issue with are the rules of professional conduct, particularly, and then you representing a party where of rights, because of a conversation that might have ensued, you would be called as the witness. That's a problem.
Okay, the rules of professional conduct, and that is where that is behind what I say, that the brief of a conflict of interest does not exist, is because that an attorney in a party to a suit cannot be a witness. I, Donna K. Tope, MSJD, am not a party to any lawsuit that they have filed.
No. But the rule also indicates you can't be the attorney and witness.
The other 3 parties are the best really the best
Coun-
witnesses
counsel-
because they're the landlords.
But counsel, just by being here the number of times that we've been here, what's clear to me is that you're, just by way of example, you've got conversations or have conversations that you've had with the Cassidys directly, with Eric and Paula Cassidy.
Not as an attorney, only as the property management. And they are all related. to
Right. But it almost would be better if you had it as the attorney, because that puts you in a different boat. It's precisely what you just said that causes the problem. You are having these conversations, negotiating with them, imploring them, taking their complete, hey, hold on.
I'm not negotiating. I'm just managing the property.
Right. But in that management of the property, you're having the conversations with the tenants.
Through their attorneys, always. Now, once these cases began, I do everything through the attorneys as well.
They didn't always have attorneys,
No,
right? You dealt with them directly.
neither did the Jeromes.
Miss Tote. I think, let me just be clear about this. I am loath when an attorney comes before the court to disqualify an attorney ever. I just am. I think attorneys, we're in a profession that is in a lot of ways self-governing. So if there is a conflict, I mean, if you just take the basic structure and you say that if I am an attorney in a case and I could be a witness to something in the case, then you almost have to rely upon the attorney not to enter into representation. Now, having said that, and so typically attorneys won't, right? And so I don't like, because I think attorneys have to make that decision a lot of times on their own, right? And so I don't like to get involved in that. But when it's brought before me that an attorney is going to be a witness in the case, and the other reason I don't like it is because sometimes that can be used from a tactical perspective from one side or the other. And so I went through this in great detail. And quite frankly, trying to find a way that would preserve your ability to represent these individuals. That's really how I approach it when I'm reading it, right? Because what I say to myself is, if an attorney isn't supposed to be in a case, the attorney's going to get out of the case. This other side's filing this to get this other attorney out of the case. So I'm going to operate on the presumption that the attorney should be there. When I finish reading this, and then also knowing and having been here and heard the case, I'll be absolutely honest with you. I don't think you can represent the parties in this case, because you are clearly, in my mind, going to be a witness. Now, I'll stop you, hold it before you say anything.
That's if we go to trial.
But here's what I don't want to end up in. But there can be certain points before trial in the way I operate my cases, where I set them for a final settlement conference.
Right.
And the thing in certain
Yeah, no, I would be acting as their attorney in those pretrial.
Well, the problem is I may ask for certain representations from the parties. Right. I don't want to.
I understand. I get exactly that. There is a problem there because you would be talking with them from, I get that.
And I don't want to be, so the interesting thing about all lawyers are bound by this, that if I see a violation of the ethical rule,
Yeah,
I'm then.
that would be.
Hold on. I'm then required to report.
Okay.
So I do not want to be in a position where I have to report you. I don't do that unless I absolutely have to. And
thank you very
I
much.
don't want to do that. I wouldn't want to do it to anyone.
So can I just want to suggest that your kinds of reservations, your kinds of concerns would not apply if the Jeromes were representing themselves. And yet they still are going to be witnesses in their counter complaint.
That is absolutely correct.
Okay.
It wouldn't apply to them.
No.
It doesn't.
No, because they're not attorneys under the attorney. Well, I still say that I would like you to wait until we actually come to that Waterloo. But I know that because we may not. I mean, we were hoping that we could get some kind of meeting of the minds at this discussion that occurred without attorneys at the University of Michigan legal department's dispute resolution meeting that took place. And we did not. But if a settlement does occur before I have to come in a legal court proceeding representing the Jeromes, then I wouldn't have to disqualify myself from advising them.
Tobe, I'm gonna have, I've been doing this a minute.
Yeah.
And I'm just gonna tell you, I'm gonna see it on motions. I'm gonna see that.
Got it.
This issue get raised.
Got it.
The moment an affidavit's filed.
Yeah.
We're gonna have a problem.
Yeah.
Right.
I totally am understanding your issue.
And so I don't want, everybody has a right to have their cases heard expeditiously to get through them. And I just don't think that can happen in this case.
Given what's going on.
Representing them. Because and here's the other part. The other part is this is a summary proceeding and maybe one of the thickest or second thickest I've had this year filed. But summary proceedings operate at a different pace. We operate rather quickly. The moment they file a motion, file an affidavit alleging that you said we got a problem.
Yeah.
And then I have to put it on hold, which is not, quite frankly, in your client's interest. I have to put it on hold, waiting for an attorney to come in to just answer the motion, let alone argue.
Okay.
Because you would place yourself in a quandary by even trying to answer. You follow me?
No, absolutely.
Okay.
Absolutely. I mean, like an arrow to the heart.
Okay. Well, don't put it that way.
No, I just gotta say.
Yeah.
That's what it feels like, but
okay.
I totally understand.
All right. So I guess my question is, if you, rather than me even ruling on this motion at this time, but if how long would it take for you to find counsel to substitute in?
I will talk with my clients and we will have a speedy discussion because they are on it. And I can get back to you within several days.
Okay. I won't ask this side to the Jeromes. Do you, based upon the discussion, I realize you guys aren't lawyers, so did you have any questions with anything that the court was saying or anything that was going on there?
Alec, did you want to? I think it's clear. I think I understand what you've said. Thank you, Judge Simpson. And yeah, we can confer and we'll figure it out. You know, there is always a lawyer present just because of the nature of the tenants, but we'll find another lawyer that will work and won't cause a conflict. I understand that's super important.
Yes. Okay. So, yes, ma'am.
You did understand what she said, that in every situation involving the tenants, there is a lawyer present on their side because Eric is a lawyer and he has sort of, yeah.
Right. And if
he's inserted lawyerly things into the discussion.
I get it. But
okay.
But if he were representing, quite frankly, he might have a problem if he were to step in and represent even his wife in this. He could certainly represent himself. I mean, he could do that, but that's not what this is.
Yeah.
Right. And I get there's always a lawyer involved. Sometimes you throw a stone, there's a lawyer involved. So
Mr. Cassidy is licensed in the state of Texas, not in the state of Michigan.
State of Texas? My condolences. All right. So, that's it. So I guess, my thought process is to adjourn this out a couple weeks, allow them to substitute an attorney in even before I rule, so that way we're not even trying to do things right now that may cause problems later. But I don't know how you feel about that. We like having you here every couple weeks or so, but
Your Honor, I mean, we really are asking the court to make the decision today, and I think an email that we received last night from Ms. Tope at like 11:30 p.m., coupled with the motion that she filed a few days ago to allow the landlords to repair the property without the tenants present, show how integral she is and what a fact witness she is. She's, in our opinion, the only fact witness. We don't need anybody else. Not to mention the fact that most of our counterclaims are against her individually.
Oh, I know.
Because emotional distress and whatnot that we're going to file is against her.
I know.
Individually. And she has a clear conflict of interest because I presume the Jeromes are going to distance themselves from her and say they haven't authorized the behavior that she's been doing on entering onto their property.
And those are all allegations.
I know. And look, folks. All right. Maybe my problem with being a judge is I'm a lawyer's judge.
Is what?
I'm a lawyer's judge. I love the practice of law and I like watching lawyers practice. And where I don't have to enter into having lawyers do the right thing or whatever, and I don't. I think you had Ms. Tope a certain position that she had. We had that brief interaction we just had now. My understanding is that there will be an attorney substituting in. So what I'm going to do is, this is how I'm going to leave it, because I do understand your point, but you have 7 days to file a substitution of attorney. If not, the court will enter an order granting the disqualification of this. Just do it that way. All right. You're welcome. And I'm not going to proceed on anything else until I have different counsel on this side.
Okay, so they would have to refile my motion that to have the tenants vacate while the landlords do.
No, I mean, I'm not, because, no, I'm not going to require them necessarily to refile. They're going to have to sign something.
Okay.
For that motion under the court rules, because it has to be their motion.
Okay.
They don't have to absolutely refile it. I'm not,
Excellent.
I mean, there are ways around that notion without causing undue delay.
Yeah.
All right.
Thank you.
So what I will do, and if council, if you would prepare the order that there will be a substitution, right?
Yep.
Or that the court will be granting that. So that order needs to be prepared, submitted to the court. I will adjourn this out 2 weeks. And we will come back. And I'm sorry. Yes, ma'am.
I'm being a little sister. My brother has had his hand raised because he did want to also.
Oh, I'm sorry.
That's okay.
I'm sorry. I wasn't looking at that screen. And I
That's totally
apologize.
cool. Totally cool. Okay.
All right.
Alex,
so you said you were being a little sister when you did that?
speaking up for my
I wasn't speaking up. I did have my hand raised.
No, it's okay. I have one of those, and you're right. I get him. He's big brothers were just quiet until our little sister says, "Got to say something."
Okay, I'm back.
Go ahead, sir.
Your Honor, the only point of question that I had was related to, we actually came today prepared to make an offer for settlement of the situation related to the payment of all of the back rent, penalties and fees, but absolving the Cassidys of any of the penalty related to the forfeiture or breaking of the lease, which was in the neighborhood of, I believe, $26,000. Does that make a difference in terms of having a discussion or not?
Yeah, no,
Ask that the record be stricken on this in terms of any proposed settlement that we have.
Yeah, in the court, its head is not, I'm not even dealing with that. The short part of that is you came to try to look to negotiate it. What I'm going to suggest to you is just hold it for a minute in terms of what position you may want to put forward. Let's get other counsel in to do that who can also look at it. And then if that's still your proposal, certainly there'll be time to submit that to the other side.
Yes.
All right, thank you.
We're heard. Alec, you were heard.
All right? Yes. All right, folks. Thank you.
Thank you, Your Honor.
Thank you. All right.
4 to 6 weeks later.
Let's call the case. Alec Jerome versus Alec Jerome et al. Versus Eric Cassidy. Two cases. Got counsel, and then they've got. Are they both? Okay, I do have Mr. Okay, because Mr. Cassidy's usually here, but he's not here. He's there in there. He's just trying to mess me up. All right, and they do have both the Jeromes. Got it. Okay.
Good afternoon, Your Honor. How are you?
I'm about to find out.
Gail Rosen appearing at Francie Nova appearing on behalf of the defendants.
Okay.
I'm Donna Toe. I was the attorney for the Jeromes. I am now a plaintiff. The Jeromes are here by Zoom and we are in pro per.
Well, hold it. You're a plaintiff yourself?
Yes, they counterclaimed and.
Oh, okay. Gotcha.
It's complicated.
Well, not really. So
If I could, Your Honor, just what we're,
I just want to know who has been representing the Jeromes.
They are representing themselves.
Is that correct?
That's correct.
Yes, Your Honor.
You're going to represent yourselves?
That was the idea.
I'm not sure whose idea.
With that was the idea with Donna as our agent, because she managed everything for us. So yes, that's where we are.
Okay, but okay, I just want to make sure you're going to represent yourselves in the legal proceeding.
We're representing ourselves today. I don't know. I mean, what I'm hearing from you is that perhaps that's ill-advisable. But yes, today we are here just representing ourselves.
Okay, no, I didn't mean to say either way, except that I just want to make sure I'm clear that from a legal standpoint, you guys are representing yourselves.
That's correct.
But you're doing it for today for sure, but it may change.
Yeah, yes, sir. Yeah.
Got it. I got it. Okay, now.
so we're here on two motions, I believe, but before I get to those motions, if I can provide a brief update to the court.
Sure.
So I just wanted to let you know that, or the court know that in July, the tenants advised, as did I, advised the landlords that they would be vacating the property prior to September 1st, 2024. Provided notification 2 months ago to give the plaintiffs an opportunity and significant time to find new tenants before the start of the academic year. So the tenants have found alternate housing and they will vacate on August 31st and return possession of the property to the landlord. I'll need to know where to leave the keys, and they'll continue to comply with the court's order to pay rent into escrow until the case is decided.
Okay.
So just as a, go ahead.
No, I was going to say.
Just by way of the reasoning is that they contend that they've been constructively evicted, not only as a result of significant delay or failure to address a plethora of necessary repairs, but also due to substantial privacy violations and a violation and interference with their right to quiet enjoyment. Ms. Tope has routinely noted that she frequently conducts what she calls security checks at the property, as well as what she refers to as due diligence surveillance, watching the property from the road. So I'm not aware of anything that allows that to occur. Additionally, she's falsely filed a police report accusing the tenants of assault, filed a PPO making the same false allegations, and now filed a case in circuit court, similarly falsely accusing the tenants of assault and battery. So that's
excuse me. There's a new filing, or is that
circuit court? Yes.
Okay, so when did that happen?
I'm not sure when that was filed.
It's a civil case.
Okay, I understand
And
that.
it has nothing to do with the landlord-tenant issues that are before this court.
We'll come back to that.
So the good news is that
There's going to be some. Go ahead.
Since the tenants are vacating the property in about a week or 8 days, plaintiff's motion to enter the property unimpeded by the tenants and their dogs is moot. So they can enter the property after August 31st without any fear of interference from the tenants.
Okay.
So we just have our motion then to strike the plaintiff's report to the court on mediation. I believe.
Before we get into that.
Sure.
This is where this gets a little bit weird. Did either of the other parties have anything to say about the vacating the premises and the like? I guess the only people that wouldn't. Well, I'll hear from anybody. Ms. Tope.
I'm the agent who has managed the entire lease from the beginning to the end and had all interaction on the lease and its terms and meeting the responsibilities of the landlord as their agent. I did that. And as far as the request or the assertion that the plaintiffs were leaving the property September 1st, they have not requested nor gotten written permission to terminate the lease. And they have not,
See, this is where this gets weird. Okay?
Okay.
Because as you stand here before me today.
Yeah.
How are you asserting that on behalf of the Jeromes?
As the agent who has been completely involved in the entire performance of the lease from the standpoint of the tenants.
Okay, that's why, as I said before at the last hearing, that we actually were all here.
Yes.
This gets messy. Because that notion, certainly you can say up to a certain point that's occurred. However, it's really up to Jerome's to say that.
Okay.
Well,
no, I mean, it is murky because, of course, as our agent, all these, from our perspective, all of these things are allegations. We're not there on the ground to see.
Yeah, okay. And that's, let me just stop you there because I think
it seems to me that these issues for trial as opposed to being.
What issues for trial? Well, here's what the issue for trial would be. Whether or not they were constructively evicted. They're leaving. If you listen to what Ms. Wilson said, they're not seeking your acquiescence to leave. Their belief is that they've been constructively evicted from the premises.
Your Honor, if I may, my intention was to notify the court and provide an update on what's happening to date. They're leaving. The motion is therefore moot. And whether or not they've been constructively evicted will be determined by this court. We're not asking the plaintiff's permission. They're leaving.
That's why I consider that to be an issue that needs to be decided down the road, as opposed to how did the Jeromes feel about it? I think that they will assert themselves at that time.
Counsel, this is where our problem is. You're holding way too many different roles. I don't know when you're talking to me, whether you're talking to me as an attorney in the case or as a party in the case. But it worries me because of this court's order.
Yes.
When you're talking about something, making a representation as to almost representing the Jeromes, because that's going to be a problem.
Okay, they have counterclaimed against the Jeromes and me. And these are issues in their counter complaint that all of the things that I
didn't want to say this, but here's what I'm just going to say. Here's what the problem is, counsel, and why I did what I did. The problem is that, as Mr. Jerome was saying, they weren't there. So let's assume, for the sake of argument, I'm not saying that it's the case, that you did something that was where all of a sudden they're liable for it and they didn't give you authorization to do it. And if that happens, you guys are on way opposite ends of that legal perspective and argument.
Wouldn't that be part of their counter complaint, which is a.
I'm not even getting to the counter complaint. I'm just getting, you're standing here making representations on behalf of the Jeromes, under the guise of being their agent.
Right, because I was.
However,
If I could just add to, Your Honor, the mediation, the report to the court, the mediation summary was also drafted and filed by Ms. Tope. The motion was, the response to the motion was drafted and filed by Ms. Tope. So,
what was the song?
Yeah. I hope it's inspirational.
so it's even murkier.
I'm going to put on a flannel shirt and go outside. Put on a hat. No, anyway, I'm sorry.
It's even murkier, Your Honor, in terms of where the representation begins and ends, and that's why we filed the motion to disqualify Ms. Tope as their attorneys, and you granted the motion to disqualify Ms. Tope.
Your Honor, may I say on behalf of Mr. Eric Cassidy that we believe that Ms. Tope has completely violated your order. She continues to represent the Jeromes. By saying she's an agent does not mean that she's not doing legal work on behalf of the Jeromes. They admitted it themselves today. This needs to stop. She should be sanctioned, and we need to move forward with the trial in this matter.
The motion that is before you was a motion that I filed when I was the attorney. I no longer the attorney, but in your order, you said that we could pursue that motion, and you set it for a hearing today because you did not want to jeopardize the Jerome's rights. That is the motion that I put into notice for this hearing. And these other things sort of fall behind that. So I sort of am, I have been put into that position, this position, by filing that motion. And so I'm responding as the person who filed that motion that you allowed us to continue to present before the court on this date.
Your Honor, that motion is moot. And
it's not moot because they haven't left. And
next week. And additionally, after the disqualification order was signed, Ms. Tope filed an amendment to that.
No, I know.
To that motion, and then a response to our motion to strike. So it continues, and there's quite a lack of clarity onto as to what Ms. Tope's role is in this matter.
And Your Honor, I think it's willful at this point. She knows. She's been in this court and in front of you long enough to know that you told her not to do that. There's a clear conflict of interest between her and the Jeromes that will be apparent at trial. So she's not only having the conflict of interest, but she's a witness, and she's participating as an attorney for herself, an attorney for the Jeromes still to this day by her last two pleadings.
The response to the letter was because I, as their agent, set up that dispute resolution settlement meeting. And so I feel I set it up with the University of Michigan because it's a term in the lease. And so I felt like.
But Your Honor, it was filed on their behalf after she was disqualified.
Oh, I know.
And it was also a completely improper filing. There's no, I don't know why a report was just submitted to the court on facts that the court wasn't seeking information about. It doesn't ask the court.
That's in our answer, my answer, because I'm the one that had it set up, and I'm the one that got affirmation from the director who set up the meeting that it was not mediation, it was not legal mediation, and the assertions that were put into their motion to strike were not accurate.
Your Honor, Ms. Tope wasn't at the mediation. That was the point. It was the plaintiff without Ms. Tope. She prepared their affidavit. She filed their affidavit. It is mediation. The court ordered mediation. This is all a type of mediation that was provided. The parties agreed to it. The parties signed a confidentiality agreement that applies to the entire process of the mediation.
And our answer answers that, because he directly said, and
let's not.
That it was not mediation and did not have any legal import, and that they would not file a report with the court.
They would not file a report with the court because it's confidential. They signed an agreement that said it's confidential. The court rules provide that it's confidential. The rules of evidence provide that it's confidential. And now you're trying to get that information in yet another time when the information is confidential and shouldn't be. And we requested that it be withdrawn.
Can I remind the court that Ms. Tope tried to get this information in last time at the hearing, and I objected, as this was information to settlement discussions, and Your Honor said, yes, I'm not hearing any of this. So she turned around and put it in a writing and submitted it. And MRE 408 does not say mediation, it just says settlement discussions cannot be before the court.
And the settlement discussion, nothing about this, Your Honor, nothing about the settlement discussions was disclosed by the Jeromes. What was in their letter, they described to you that they did discuss the issues of the landlord-tenant case that was presented to the dispute resolution people. Assistant. And it was Mr. Cassidy who went off the rails and talked about things that had nothing to do. No, they drafted that letter. It's their words in that letter.
So if I can renew my.
Can I just hold on a second?
Certainly.
Ms. Tope.
Yes.
I don't like finding that attorneys are violating not only the written orders of the court, but certainly the spirit of the court's orders, and are trying to go around that. And when this whole thing about the disqualification started, what I honestly thought was that, and I ultimately ordered and was waiting for, was a substitution of attorney, because I didn't want the Jeromes being without counsel.
And I have searched far and wide among all the landlord-tenant attorneys who have appeared before you, and nobody wants to take this skillet of snakes. I have an attorney who is not part of the landlord-tenant attorney group, but she has not been able to file an appearance for me because she was in court today.
But is that for you?
Yeah, she will represent the Jeromes as well, but she's not able to.
Whoa. Okay. Stay with me here. Stay with me here. Stay with me here. I don't care who the attorney is.
Okay.
That attorney
cannot represent
both. There is, even from what minimally I know about this case, just from the plea, that can't happen.
Okay.
And I'm not going to allow that to happen.
Okay.
Because I think, quite honestly, and I didn't want to say it out loud, but I'll just say it out loud now. I think the interest of the Jeromes are going to, at some point, be absolutely in direct conflict to your own interest.
Understood.
Okay. No, I value your advice, every word that you
I don't
told
give
me.
advice. I give opinions and orders, but go ahead.
Okay.
Ms. Tope.
Yes.
You need to just stop.
Okay.
No, you need to stop doing what you're doing in this case. You can certainly defend yourself. I'm not entirely clear of the relationship that you have with the Jeromes, but I will just say that what is happening and what you're doing is potentially jeopardizing their positions in this case, as well as your own.
I hear what you're saying. I intellectually do not understand because.
Just
I
basic,
handled the
basic,
whole-
just basic.
Okay,
If you did something
yes,
that they did not implicitly or explicitly give you permission to do,
right,
that then would, because you're acting as their agent and it causes liability to the Cassidys. You with me so far?
so far.
They come after you because they didn't give you authority to act.
They meaning?
The Jerome.
Oh, because they're going to go after.
Because now all of a sudden they're
something
like.
I did in performing the lease. Because they are going after me for something I did in executing the terms of the lease that I signed.
But they're going after not only you, they're going after the Jeromes. And the Jeromes may have said, oh, she was supposed to do that.
Yeah.
Right? And that the Jeromes, I'm going to presume, are going to say, we don't want liability for that. She didn't have authority to do that.
Right.
And
so it's on me.
Yes. Yes. Let's presume it comes out that way.
Yeah.
The problem is when you're representing them, that will never happen.
As the agent
No.
who signed the lease.
As you're representing them and making the statement as though you are one in this court, that will never happen. The fact that that can't happen or won't happen is where there is jeopardy and prejudice to the Jeromes in terms of what their position might ultimately be.
Okay. The attorney that I have retained, if she represents the Jeromes and I represent myself.
It's so weird.
No. I think, can I just interject?
That you're retaining the attorney. That's just so strange to me. I'm sorry.
No, we're
yes, go ahead.
Okay. You've made it abundantly clear that we will retain our own attorney. And
wow, somebody actually is listening to me.
And I really don't know what. Well, I finally got it. And we'll have to proceed from there. As far as the things that are on the agenda today, I know that our contract does, I guess this is an anticipatory breach of the contract if they move out. But again, I would want to have a lawyer here to talk about that. And, I am understanding some of the language that's going back and forth between you and the attorneys for the Cassidys. But we're going to have to prepare ourselves to distance ourselves from Ms. Topin. So I'm comfortable with that. And I'm sorry it's taken us so long to get there. Alec, do you have anything to add to that?
No.
Okay.
He's a good husband.
Yes. No, he's a brother. He's a brother.
Your brother?
Yeah.
Yeah. Okay. Then he's very good.
Yeah.
Like,
yeah. Good brother.
Sister asked, do you have anything to add after I talked? No. All right.
He is. They are. They're great people. Okay.
Okay. So when speaking to the Jeromes, how long will it take you to get attorneys? Because it's going to be very difficult for me to move forward unless I'm sure you've got attorneys that are.
They will have an attorney within.
Why are you answering for them?
Yeah, no, I got this one. I got this.
Your Honor, we have talked about this. We have talked
about. What did I just say to you?
In the past.
Oh my gosh. Look.
Yeah, no, I just to interject again. Alec, it's the 23rd of August. I would say after the 11-year-old, she's beginning school. Could we put it into the beginning of September? I would think that we should be able to find some.
Okay, let me ask you this. Could you guys have an attorney in, say, 2 to 3 weeks?
Yes.
She just
3
said
weeks, please. Yes.
3 weeks? Is that going to be tight for you? I don't want it to be tight for you. I'm just.
Alec, what did you say?
I said 3 weeks. I would like the latter of that range if possible.
Okay, so at least 3 weeks to get you, okay, very good. See, I knew he'd say something eventually. So, okay, all right. So, all right.
So I do think, Your Honor, our motion to strike is pretty straightforward.
Yes, it is. Okay, so, and this is what I don't understand. Why do I have a report to me at all?
Because in typical actual legal mediation, the mediator gives a report. And because it was my understanding from talking with the Jeromes after the session that I had arranged for them, things went much further than the subject of the meeting was supposed to be. And it was
I think that
discussed with, go ahead.
Yeah, I just wanted to say that, you know, when we talked and reported, Donna was still our attorney. Alec and I, in our ignorance, didn't know that. I mean, I guess we should have thought about it, but since it wasn't an official mediation, according to the agency who conducted it, there was an email that said that we didn't think there would be a violation, and didn't know that it. You know, again,
we didn't discuss terms of the tenant lease.
Okay.
What we discussed with Donna was issues that were beyond the discussion matter of the tenant lease agreement that we thought we were meeting with regards to the mediation activity.
Got it.
Your Honor, it all occurred during the mediation process, the confidential process. The report was filed after Ms. Tope was.
No, I get, certainly get that part.
Moreover, Judge, I've done hundreds of mediations or many more than that. And yes, reports do go to the court, but the substance of the discussions never go to the court, just that what happened as far as if they came to a resolution or not.
But even to the extent that they're relevant, that report comes from the mediator. It doesn't, I don't get this. That's why when I saw it, and I was reluctant to even read it and just skimmed over it because I didn't ask for it. I mean, if it went to mediation, so the first thing that I did is I went to the leasing contract basically, or wherever it was, to determine if for whatever reason, as part of that provision, I was supposed to get it because I couldn't figure out why I was getting this. And that's not in there. And so I couldn't figure it out. Is there, given all of that, does anyone have opposition to the court striking the response to the court?
Both, Your Honor, the affidavit as well as the response, which then recounts the response to our motion. When
everything. I'm talking everything, because none of it should have been here. So I'll ask you, Jerome's, do you guys have any?
We do not. Go ahead, please strike it. Thank you.
Okay. Miss Tope, because she's a party, I gotta ask. You have any, given what's been said, do you have any objection to their motion to
None.
strike?
None,
All right,
no.
then please prepare an order to that effect.
I would still ask for costs and attorney's fees, Your Honor. We had requested that this be withdrawn to avoid the necessity of filing this motion.
Ms. Tope, why didn't you withdraw it?
Sorry?
Why didn't, let me ask this, Ms. Rosen, who did you make your response to withdraw to?
My email to request that they withdraw?
My response to my withdrawal of the letter?
I sent it to all parties.
Okay.
So you sent it to the Jeromes also?
I sent it to the Jeromes and I sent it to Ms. Toth by email. I don't have a physical address for the Jeromes.
Gotcha. Okay, that's fine. Okay, so why didn't? Okay, see, this is where it's gonna get hard.
Okay.
I already know the answer to it.
Okay.
Before you say to the Jeromes, is there a reason why you didn't withdraw the report to the court?
Is there a reason why we didn't withdraw the report to the court?
Right, why you didn't acquiesce to the request to withdraw?
We were not aware of the concerns
Yeah,
related
quite
to the
frankly,
court
yeah,
filing.
we weren't aware of.
Oh,
how
you
to-
both started talking. What were you saying to me?
Sorry, Alec, you go. You'll probably have a better.
I just said we were not aware of their concerns related to the court filing and were not aware of the need to rescind.
Well, and
Yeah, I guess ignorance.
you
was-
had no idea as to the ramifications of that happening, did you?
No.
Your Honor, can we inquire, can the court inquire of the Jeromes if they sought legal advice from Ms. Tope after we sent the email asking them to withdraw?
We didn't seek legal advice.
Hold on, I don't. I understand the nature of why you may want that. I'm gonna have I'm very protective even as a judge as to what may be even parts of an attorney-client relationship and communication. So I'm not gonna permit that answer to that question. All right. Is there any reason you didn't acquiesce and just withdraw before?
I didn't acquiesce because I had set up the meeting. I knew what they were to discuss. I knew what the confidentiality agreement should have covered, not as an attorney, but as a person who was trying to effect that section 38 in our lease that allows for seeking advice from the University of Michigan. The mediation service allowed to students no longer exists, and they do not provide that service anymore. And I was referred to the dispute resolution where the parties talk about the issues under dispute, which are the lease terms. And so when there was discussion that there was no discussion with me about what was talked about or agreed to or anything about the lease.
I no longer know what you're talking about. I asked a very simple question.
I know. Why didn't I acquiesce? Because I felt as if there was a good reason to question the applying court rules to the settlement meeting that I had set up that was specifically stated by the person who organized it that it was not mediation. So I felt like there was a way to talk about what parts of it were covered and what parts.
Okay, but listen.
Yes.
If all the
which I did in an answer. I have an answer, but
if all
Your
the
Honor, I included the mediation agreement that all parties signed, indicating pretty clearly that, or quite clearly, that it was confidential in two different spots.
yes. But that confidentiality was over the subject matter of the meeting, and the subject matter of the meeting was strictly the lease and the lease terms. The things that they went off on had nothing to do with that.
The affidavit provided started out by stating during the mediation process this occurred. Mediation was still going on. If this was a conversation that the parties had in the parking lot after the mediation,
It would be different,
Maybe.
perhaps.
There was no mediator present.
I don't, Ms. Tobe, I really don't understand. First of all, why you felt it necessary to give that to the court, right? That's the first thing.
Okay.
But then once you made that decision to do it, and then counsel points out to you why it shouldn't have been done, is asking you just to voluntarily withdraw it, and you don't after looking at everything. That's the part I'm having a hard time with you not doing.
I understand your concern. I felt it was, since we had had such a long discussion about mediation and good faith, and we finally agreeing to try to effectuate the term in the lease and follow that, which is what I did. And the mediation aspect not being available, I felt that it was my responsibility to give you back what had happened during this discussion that you had made very clear that you would like to have us do. And so I did.
Well, why do you think I would need to know?
What?
Why do you think I would need to know?
I don't know, because you told us to do it.
Your Honor, clearly she's just trying to prejudice the
No.
defendant counter plaintiffs by providing false information to the court.
No.
She knew she wasn't supposed to.
No,
provide it.
no, strike it.
At the last hearing.
It's not going to make any difference. The judge will not make any decisions based on that report. It was just saying what happened. That's all. And I have no problem striking it. It's causing such problems.
Costs and attorney's fees, and we'll let the court decide how to proceed.
I've listened to you, and the reason I was asking the question is, Ms. Tope, tell me why I shouldn't sanction you.
Because one of the things that comes out in this back and forth is that I am being attributed by the other party because I am a plaintiff in the counter complaint as having ulterior motives. And honestly, I don't. I'm just trying to respond appropriately to my responsibilities as the agent who has been managing this lease from the very beginning. And
Ms. Tope, that's not a real answer to my question.
I know. Well, but that's how I'm thinking. I'm not doing anything willfully, intentionally, or in an aggressive, oppositional way towards their clients.
And it doesn't have to be aggressive. It's still in violation of the confidentiality agreement, the court rules, the evidence, an opportunity to withdraw it. You didn't. So here we are.
And that is part of the story. But the other part of the story is, given an opportunity to withdraw it, I did it because I felt I had a responsibility to report what the judge had ordered us to do.
Your Honor, I don't see.
I
don't know where that responsibility came from. If it came from a court rule, if it came from the rule of evidence.
It came from his discussion, just like this. I totally hear what the judge said.
I told you to do that?
No.
Making things up right now. And it's improper, and she needs to stop doing that. She needs to stop making false statements to the court.
Okay. Anything else you want to say, Ms. Tope?
No, except I am not making false statements to the court, and I am trying to express my motivations. And you asked me why I didn't, and I tried to express why I didn't. You know,
Ms. Tope,
it's in your hands.
so here's what we're gonna do. Place in the order that I'll take sanctions and costs under advisement.
Thank you.
And I'll decide whether I'm going to order them. Because, and here's my reason. I typically don't, I realize there could be violations. I typically don't sanction attorneys if they've didn't sort of have ill will in doing what they did. And I understand one may look at that differently, right? But sometimes people do things just out of sheer ignorance.
If you don't sanction ignorance, I will plead it.
I don't think you have to plead it. I think we pretty much have. Thank you.
We'll go from there. Your Honor, I would ask just one last thing, really quick.
See, I told you the minute Rosie started.
So
I'm like, why can't you talk? No, go ahead.
Is no longer about possession. Possession will be returned. And it's going to be just about compensation damages. I would ask if the court is so inclined and has the time, and once the Jeromes have attorneys, if you would be willing to engage in your incredible shuttle negotiations and allow us.
See, you've been talking to Mr. Fink too much, first of all. But
I've seen it in action, so.
yeah, I don't, and I really don't have a problem with that. And ultimately, if we could get the case to that point, I'm not going to have a problem with that once we get to the final settlement part and do that. But I've got to make sure that the Jeromes have attorneys in place and that their interests are protected, and we could do that. So, yes.
There's another procedural matter. Sorry.
No, it's okay.
So after Ms. Tope served one of her notices, she filed a complaint that wasn't timely. That was, I think, her third complaint she's filed in this case. So then she went ahead and filed a fourth complaint. In the meantime, we had responded.
Fourth complaint.
We had responded to the third complaint and counterclaim, but now we have not yet actually officially answered the fourth complaint, and we needed an amended counter complaint. So I don't know if the court wants to give us a timeline for that. And there were two case numbers, so I think the court mentioned it, consolidating those cases.
Well, they're gonna, right. I mean, the district court doesn't have a great way of doing that. So how much time are you gonna need? Okay, so here's gonna be part of the problem. Part of the problem is you're going to be filing an answer and a counter complaint, which is going to include the Jeromes, which are then going to have new counsel swing in, right? So I think I'm going to do it this way. I'm at this, and that was filed by Ms. Tope on behalf of the Jeromes.
Yes, the
fourth one.
The complaint, yes.
Okay. And do a separate order. I'm not going to require an answer to that at this time. Because I don't know, once the Jeromes get counsel, I don't know what they might want out of that part completely. I mean, I don't know what their position was.
Those were filed not by me as an attorney. They were filed by me as the agent for the Jeromes. I was
okay, look.
Their attorney till later.
You got to stop that. I mean, you really do. You can't like split yourself and say, I'm doing this because I'm doing this as whatever, but now I'm acting as, you can't do that. Because you're doing it, when you do it, you're doing it to justify you doing something, which quite frankly, I would agree with counsel probably is in violation, certainly if not directly, the spirit of the order regarding your disqualification. So
Right.
you just need to stop it.
So I, Donna Tope, am not able to respond to anything that had to do with my operating as their agent before I became their attorney.
Hang on a second. I don't know how to answer that. Because what may end up happening is that Jerome's get an attorney, the attorney says, oh, heck no, she's not doing anything on your behalf. And they follow that, then you do nothing. Your agency at that point certainly ends.
Mhm.
All right. So I almost hate going here, but I'm going to. So Snowbird, you're going to prepare the order regarding no answer required until the court directs otherwise.
Yes, Your Honor.
Okay,
Is
fantastic.
there also a deadline for a counterclaim though? Because we filed a counterclaim in the third amendment, but the claims are going to be, we'll be adding claims for sure.
Answer and counterclaim. Just everything's on hold because it's not you delaying it. It's not the court delaying it. I just have to it's the court delaying it because I have to give to Jerome's time to do what needs to be done. All right, now without raising a new issue, what is the circuit court case?
I filed I called the sheriff and filed a report of an assault and battery at the property by Eric Cassidy and Paula Cassidy, and followed up with that with a civil complaint of assault and battery.
When did this allegedly happen?
In the early spring. I don't have any of that information with me. It's not pertinent here.
Around March 8th, I believe.
March 8th.
Right, it was during the process of her, she claims the event occurred during the process of her serving a notice on the property.
The notice to quit.
Yes, at that point, it was to allegedly people that weren't supposed to be living in the house that were living there. Which wasn't true. And then, I guess, Your Honor, the question will become, that did occur during, I think it's a permissive joinder, for sure. I don't think it's a mandatory joinder, but it's a permissive joinder. So one question will become, will we be removing our case to circuit court and then join that as well?
Okay, so this is like Groundhog Day. If you remember the first time that you were here, and we were going around and around about that, and I said I could do something that I really don't want to do, and that is get appointed a circuit court judge and just deal with it. And I just let you know what I'm thinking. Excuse me for the pause, and that is, I don't think you should be taking up Judge Connor's time with something that is a result of a landlord-tenant case that I have. If it's regarding the serving of a notice, outside of the landlord-tenant, why would you and the Cassidys even be in contact with each other?
I wasn't in contact with them. I was outside. So, Your Honor,
your entire relationship with the Cassidys is a result. It comes from this landlord-tenant relationship, right? That was a question.
Yeah, no, yeah, absolutely. I mean, the
Okay,
only reason
so-
I was there was in my agency capacity enforcing the lease.
Exactly. So why do I have a separate court hearing and action that came from that? Let me just say this. When was this filed?
Oh, August 8th.
Of this year?
Yeah,
You know, so I'm just gonna tell you. And I don't know anything about it. But this is a lot like her. It's almost like you're just wanting to harass them.
oh my gosh.
Why, then answer me this.
Why would I do it? Because
Why wouldn't you file it if you felt that there was an assault and battery? Why wouldn't you file it in this case?
I didn't consider it a landlord-tenant case.
Civil actions up to 25,000
Mhm.
are the jurisdiction of this district court.
Yeah, I asked for over 25,000,
Ask for what?
over 25,000.
Of course, everybody does. So then why wouldn't we have just done it? And then we might have been back in that whole discussion about, does it get removed? Does it do whatever? I mean, I think this is, I can't help but think while all of this is going on, and quite frankly, you're not getting your way on a lot of things because some of it I don't
right.
understand. No, you don't. Listen.
Yeah, I'm listening.
That what you did is you took that case and almost as an abusive process, filed an action in circuit court to harass the Cassidy. That's what it looks like. So here's what I'm gonna do, because I don't think they should be trying to answer.
I will
two
withdraw
different-
it.
No, you do what you want to do, because I'm just gonna call Judge Connors in the circuit court and I'm taking, if with his permission, I'm gonna take it. Because there's no reason he should be handling it. All the issues, God help me, but all the issues are here.
It was an assault against me personally. It has created a hostile work environment. I am afraid to do my
This is worse
job.
than like being civil. Either we're talking about you personally, we're talking about you as an agent, or we're talking about you as an attorney. You got to make up your mind.
And to be clear, Your Honor, all of these issues are what led to the tenant's commitment to vacate. I realize that if they can tell us where to leave the keys, I will Mr. Cassidy's on the call, I'll know where to leave them.
Mr. and Mrs. Jerome, where should they leave the keys?
It's brothers and sisters.
Mr. Okay.
Ideas? I don't know.
said-
I'd have to think about that. I
Yeah.
don't know. This is such I'm so disoriented by this whole thing. So I have to get back to you.
Is there a lock? I thought there was a lockbox on the back door that we could place them in.
Is there?
Yes.
Okay.
Perfect. That works.
It's easier, they can be brought to my office. I did want to make just a clarification for the record. She filed her complaint on July 18th. July 12th, this court heard argument to disqualify in order of disqualification. And then 6 days later, she filed it.
I withdrew.
I knew you would.
I withdrew within 7 days.
You withdrew what?
I withdrew as attorney on this case.
You really didn't. But that's okay. You were disqualified. And for very good reason. And I did it. And everybody can be mad, but I did it. So here's what we're gonna do. Where do you is there a lockbox back there?
Yes, there is on the back door.
Mr. Cassidy, do you know if there's?
Hello, excuse me, Your Honor. There is a lockbox. It actually has keys and it's on the door. I don't know the code for it. We can simply leave the keys in the kitchen, and they have the lockbox keys that they can enter the house. Or we can
Do you have a problem with that, Mr. If
No,
they
no,
just-
no, that sounds great.
Okay,
Those
just
are-
leave them in the kitchen.
Okay.
All right. Just take a picture that you left them, so I don't have to deal with whether or not the keys are there. What?
Yes.
Return.
Yeah, I really don't want to get one, but I will. She said with a smile. You have a date to return? Mm. All right, let's do it this way. They needed at least 3 weeks out. He was looking at, why don't we get 4? Why don't we make it September 20th? Will that work for you?
Fine, Your
Yes, Your
Honor.
Honor.
I've scheduled a mediation in the afternoon on that day.
And this would go in the afternoon. So what about the 27th?
I believe I'm available as well.
Would you be available the 27th?
Of September.
Yes.
Yes.
All right. And I won't say Mr. and Mrs. Will the Jeromes be available on the
Yes.
27th?
We will make ourselves available.
Okay, that gives you a little bit more time than the 3 weeks, but
Great.
Clock again, Your Honor?
well, I don't know. I set it at 9 and then my staff will send you notifications of the time. All right. Thank you.
Thank you, Your Honor.
Once I get there, I am. And Mr. Fink?
Sure.
Ms. Rosen did something sort of in your name and made me commit to something. She'll tell you about it.
Michigan man finding himself in even bigger trouble this morning.
He was recently arrested after attending a Zoom hearing for driving with a suspended license while driving his car.
Court calls case People versus Corey Harris.
Conrad Siller on behalf of Pittsfield Township.
Assistant Public Defender Natalie Tate for Mr. Harris, who should be present via Zoom.
Mr. Harris, are you driving?
Actually, I'm pulling into my doctor's office, actually. So just give me 1 second. I'm parking right now.
Great. You stationary?
I'm pulling in right now at this second. Yes, I am.
All right. What are we doing?
Your Honor, we are respectfully requesting an adjournment in this matter, up possibly 2 to 4 weeks if the court would allow.
Okay. So maybe I don't understand something. This is a driving while license suspended,
That is correct, Your Honor.
and he was just driving. And he didn't have a license.
Is with the charges, Your Honor, yes.
No, I'm looking at his
Yes.
record. He doesn't have a license. He's suspended and he's just driving.
That is correct, Your Honor.
Hello?
1 minute, Mr. Harris.
I don't even know why he would do that. So defendant's bond is revoked in this matter. Defendant is to turn himself into the Washington County Jail by 6 p.m. today. Failure to turn himself in will result in a bench warrant with no bond. Thank you.
Thank you, Your Honor. Mr. Harris, I'll be giving you a call.
Ann Arbor District Judge Cedric Simpson stunned by the actions of defendant Corey Harris and revoked his bond. This is today's edition of What Were You Thinking?
Oh, it's like it didn't even dawn on him.
Right.
He's like, oh yeah.
Suspended license. Oh, I shouldn't be driving while
Yeah.
talking to the judge. Too late.
Too late.
Yeah.
Busted.
Oh well.
Yeah.
2 weeks later.
Okay, so the people versus Corey Harris.
Yeah, Pittsfield Township.
Good afternoon. May it please this honorable court, Dion Webster Cox appearing on behalf of Mr. Harris. How are you, Your Honor?
We will see.
We're good. We're good.
Mr. Brown, or somebody from the PD's office, because I did not get a substitution. I got an appearance.
Oh, I've got a substitution right here.
Signed off on.
It is.
All right, then I don't need to address. I don't need to address the public defender's motion to withdraw. I'll consider that withdrawn, given the substitution. I do have an appearance, and I will sign off on the substitution.
Thank you.
Thank you. All right, what are we doing today?
So, Your Honor, we were going to, there's several options that my client.
Well, and I want you to know, counsel, that because of certain things, the court has a number of things I have to say.
Okay.
Because I think the record, given particularly some of Mr. Harris's comments with reference to this court potentially acting, what at least as I'm to understand is on what some may be, or is it, let's put it this way. People are saying, and quite frankly, your client has made the assertion that the Pittsfield Township, as well as this court, was acting on some type of defective or faulty information.
Secretary of State records show his license was first suspended for child support back in 2010, but Harris told us he thought his license had been reinstated.
They were supposed to have been lifted it two years ago, but they didn't.
And according to the Saginaw County court records we found, Harris is right. In January 2022, a judge rescinded that suspension on his license, but for some reason that information never got to the Secretary of State.
It's very embarrassing. And with the type of ties that I have with the church and the community, it's very embarrassing. Always double check, be behind these workers, because they will say that they will do something and they don't do it.
Which I will tell you, counsel, caused the court, given what the court did, to investigate what my ruling was. And I will tell you that that assertion is absolutely correct with reference to any faulty information that either came through to the Pittsfield Township Department of Public Safety or to this court ultimately at the May 15th hearing. And I think it needs to be stated, I've been asked for comments. I have refrained from comments, as is my normal practice is. This court with the pending case will speak on the record. And so I am going to make sure that the record is very, very clear as to what this court knows and what this court acted on May 15th. And we can start with this. And my basis for doing it is because of what was said about what this whole process was. And that an indication, counsel, and I know, counsel, you've been before me before.
Absolutely.
I know it is not coming from you, but you also know how I am.
I do.
And the thing is that if for whatever reason, the one time in my life I was wrong, I will say it and did. But when I'm not wrong and when people are not to blame, then it also needs to be said. So I will try to get through this as quick as I possibly can. But I will tell you, first of all, with any reference to your client having had a license on that day, and some indication or misunderstanding as to whether or not he had a license. Let me make it very clear, based upon what the court looked at, he has never had a Michigan license, ever, and has never had a license in the other 49 states and commonwealths that form up this great union. He has never had a license. In point of fact, when they suspended his license, and what people don't understand, when they suspended his license in Saginaw, they don't suspend the license. They suspend the privilege to drive in this state. Hence, for example, if he had had a Kentucky license, he would be able to drive everywhere that Kentucky would allow him to drive. He just couldn't drive in Michigan because his privileges had been restricted. I know you know that, but that wasn't at all said. But it doesn't matter because he didn't have a license. Ever. There is also then, and I will, when it is necessary, come to the defense of my sister courts, and I will come to the defense of Saginaw. They got a great chief judge. Chief judge answered the question. But I will tell you, that court and its friend of the court did nothing wrong. His license was, his driving privileges, better stated, were unsuspended in 2022. That required Mr. Harris to do something. He didn't do it. Therefore, the friend of the court was under no obligation to send anything to the Secretary of State. Now, I hated that I had to look at all of this, but when there's a question as to what I did, I'm going to look at everything to make sure that what I did was all in order. There's then an indication from that because that wasn't sent, there was a direct attack on Michigan's Department of Secretary of State's office, saying that the Secretary of State was somehow at fault. Let me tell you something. Secretary of State did what they were supposed to do. And in point of fact, they did nothing because they hadn't gotten anything from the court because Mr. Harris had not paid the reinstatement. This week, or latter part of last week, once he paid that, Saginaw friend of the court did what they should do, and they sent it. Immediately, based upon the information that I have, the Secretary of State did what they do every day. They took that suspension off of his driving record, and he was then unsuspended. And then your client did what he needed to do with reference to the Secretary of State and paid a reinstatement. Just a second, Mr. Schiller. I'm going to let everybody respond because
Thank you.
I am not done yet.
Okay.
All right.
You covered a lot of the points for me. Thank you, Your Honor.
And so that came down to that. So the information at the time that I had, that Pittsfield Department of Public Safety had, was all correct at the time of both Pittsfield stop as well as the May 15th day. It was all correct. There was no error by anybody. It was a failure on the part of Mr. Harris to do certain things. Now, I grant you that sometimes that can be a complicated process, but it was certainly not anybody's fault that that didn't happen other than that wasn't paid. Now, here's the other thing, and I'm like maybe in church where I say I'm about finished now, but the other part of this is this stop was in October. Most of the cases that we've heard just in this last afternoon are driving while license suspended cases. That's part of my Wednesday afternoon. We go through great pains to try to get people their licenses back, which is really how it should happen. Between October and because I don't live under a rock, I actually watch things. You look very nice on TV.
Thank you.
You're welcome. There was something that was said that was very disturbing to me. And I'm just going to let you know because I believe in being fair with everybody. The question was asked along the lines between October of 2023 and the point in time of the May 15th hearing. Was there an attempt by Mr. Harris to correct his license? Here's the part that was disturbing for me, so that you know.
Okay.
Mr. Harris indicated that at some point he had been involved in some accident. Then being involved into the accident that he was basically bedridden or at least housebound, he could not get to the Secretary of State. That was set up there. And I think I'm going to presume, because my knowledge of counsel, defense counsel is, I know you don't misrepresent anything.
Right.
You never do.
Right.
That's not true.
Okay.
He purposely stated that he could not get to the Secretary of State, which for the way we handle things in this court would have placed him in a whole different category. We would have tried to find a way, let's figure it out. And the reason I know that is because Mr. Harris, on December 28th of 2023, do you know where you were?
December 28th, 23.
23rd.
2023.
I know I was laid up from my accident.
You were at the Secretary of State's office. And you were at the Secretary of State's office because you redid and got your new Michigan ID. I have the date. That's the date you did it. December 28th, 2023. You did. And so that you also know, and in all fairness to counsel, because I don't know if counsel knows this or not, the way I know that he's never had a license is because May 3rd, 1990, he was 19 at the time. May 3rd, 1999, he applied for his first Michigan ID. Counsel knows, so I do, you cannot have both. You either have an ID or you have a license, one of the two. He has religiously every year gotten a new ID. And so he knows that he doesn't have a license. And quite frankly, I just wish he would have said that at the beginning. And all of this hoopla could have been just put all aside. And we all go through the process as we do with all of the people coming here to try to get him his license back. But his falsehoods, misstatements are not going to fare him well in this court. I'm done for now. I'm sure I will have something else to say. Whichever one of you would like to speak first, you may.
I'll wait to go last.
Yes, I spent yesterday at the Pittsfield Township Police Department with Officer Monaster, performing the traffic stop in this case. I also noticed the December 28th, 2023 date, and I know the significance of that, and the court just went through that painstakingly, and I thank you for that. In addition, at the traffic stop, when I was at the police department yesterday, we watched the body cam video. At least twice during this traffic stop, he acknowledged to the officer that he did not have a valid license. Quote unquote, quote, actually, I don't have a valid license. Close quote. The question was, are you a valid driver? Quote, I am not. Close quote. So, you know what, this is all this hoopla and the circus atmosphere is, in my opinion, is an affront to the justice system. I mean, I've been a prosecutor for more than 30 years, And to see this kind of hoopla around a driving while license suspended case is ridiculous. And it wasn't caused by this court. It wasn't caused by the Pittsfield Township Police Department. It was caused by the extrajudicial statements made outside this courtroom.
Thank you.
Okay, so
Go ahead, Counsel.
thank you, Your Honor. Thank you very much. Well, first thing I'd like to say is, very first thing is we're here and that we all saw this video. I wasn't in court. I wasn't even on YouTube watching the court today, right? I saw it because someone saw it and decided to post it. I can assure you that was not Mr. I don't think he has the capacity to be able to post it like that on YouTube or Instagram. So that was not him. And it happened to take off and go viral. So he had what we saw was him saying he was driving, which he should not have been driving, right? We're told not to drive on Zoom while doing that. So that's how this came to the attention, because the court, I saw you. He said, I can't believe this. Is he driving? And we all said that. Everyone who saw that video asked the same question. And that it became a joke. It became a complete joke. Now, with respect to what we want to do, and I cannot say anything is with respect to what my client has said, but when we talk about the hoopla, my client didn't start the hoopla. Perhaps he's made some comments, but he didn't start the hoopla whatsoever. That was someone that was outside of his control as to how it went viral. He had no control over that. And that I'm going to stand on that. He did not send it out to Instagram. He didn't send it out to wherever. He didn't do that part. So with respect to, did he have I don't want to try this case today at all, but what I want to do is focus on what's good. Now, what was good? That day in October, this officer here, that could have gone a whole other direction. And I'm so happy that you were so kind and courteous to my client. Thank you, officer. Thank you so much, because it could have gone another direction. We are here right now. My client has an appointment to go to the Secretary of State for his permit. He's working on that. I want to focus on how do we correct this and cure this? How do we go forward with this situation? Whatever, he was not under oath under any of the things that he said. So we're not talking about any type of perjury going on. Very true, right? True. So with that being the case, let's move forward with this. He is here. This is what I'd like. Because
Counsel, let me just.
Yes.
I would like to move forward too on this case. We handle these cases all the time. But I will tell you, as you know, having appeared before me, the one thing I don't like is when people don't take responsibility for what they've done. When they take responsibility for it, we will use whatever we can to try to get you to another spot, because it doesn't behoove any of us for you to be in that spot. One other thing that I will say, when you say it wasn't started by him, it certainly was. It certainly was when he made his first statement to WXYZ about blaming people for this happening. And he shouldn't have done it, because when you look at the whole thing, the person that needed to be blamed, and we can go back to a lot of other points, but I'm not here to embarrass it, but the person that needed to be blamed is the person that he was staring at in the mirror. He didn't do what he should have done, and that's okay. The majority of people that come here on a license thing didn't do what they were supposed to do. That's like a given. They don't go about blaming anybody. They just say, Your Honor, I didn't pay the ticket. Your Honor, I just didn't do it. I just didn't have the time to do it. I just didn't take whatever.
Right.
Just own it. Once you own it, then it becomes a whole lot easier just to move forward. Okay, I'm sorry. I interrupted you and I said I wouldn't, but
I understand.
my court.
I know who you are and I respect that. So and where I am is where I've always been, because I can assure you that when he did speak to WXYZ that day, I wasn't representing him. I was representing him yesterday, right? And you would heard my message is that what steps are to correct this. And that's what I'm about, Your Honor. How do we correct this, right? I understand the entire process. I have not gone into detail, but I will take the word of the court and of Mr. Stiller here, brother counsel, and about the background and the history of it. But how do we go forward? And that's why I'm here to sort of minimize. You okay? Can he did get into an accident. May he sit down? May he please, Your Honor? Right behind. Oh, well, hold on. Okay. And now that's real. That's a real injury.
I have no comment.
Okay. So what we're looking for, because there are some options here. My client has indicated to me and would like me to indicate to the court that he is in the process of procuring his license. Oh, hopefully that privilege will be available to him, but he does have, as you stated earlier, and I have the receipts. He did pay the reinstatement fee. Those fees are paid. Anything that was out in the previous court, those fees have been paid, and I've been presented with those receipts. In addition, on tomorrow, he's got his permit test coming up, and then after that, because he's an adult, he's working on it so that he can take advantage of the offers that are available, because as you say, this court does want to help. Absolutely. And with that, because my client was in an accident, and I haven't seen the medical records, but because of some of the things it could be, I don't know. But sometimes our memories get a little foggy. Now, am I going back to 1999? No, I'm not. But I'm just saying that I'm saying from this day forward, he is working diligently to take the steps necessary to get his driver's license so he can take advantage of the generous offer. Thank you.
Yes, ma'am.
Yes.
Yes, Mr.
I hate to say this, Your Honor, one additional thing. I think Fletcher Cox and I need to approach the bench. It may involve Mr. Allen.
Who's Mr.
I
Allen?
know, because I know what it is.
Okay, thank you.
Well, who's Mr. Allen?
That's my bailiff.
Oh,
I will give out whatever date I can.
okay.
Counsel, you probably didn't know this, and I wasn't sure where the prosecutor was going to bring. He's got a warrant.
No, I did not know.
Yes, he has a warrant for his arrest. A bench warrant out of
Allen Park.
Allen Park. Mr. Allen.
24th District Court.
Okay.
The shocking thing about it, for a driving while license suspended, that he didn't take care of.
Okay. Well, like I said, he
So-
wants to handle.
So
He's
what it
dedicated.
is that, and it's a valid warrant, I happen to be within their radius of pickup. Now, having said that, I don't know if they will pick him up.
Okay.
I will say that what should have happened, I'm not going to go through and try to figure out whether it did happen. But when he was arrested, when he turned himself in on my revocation of bond, upon being released, he should have been apprised, warned, and released to go take care of it. I don't know whether he was. I really don't care whether he was or not. All I know is that was back at mid-May, and it hasn't been taken care of. And it's still valid. I was hoping maybe that somebody was going to try and take care of it, because I'm sure if you had known, they would have been done. So much so that part of my delay in getting out of here was to make sure that it was valid. I had my staff run him right before I came out, so that if it hadn't gotten taken care of and in, then fine, we were okay and I didn't need to deal with it.
Right.
But it's still there.
Okay.
So will July 17th work as a new date for you to come back? Because as I understand it, he is right now not licensed. So if he goes in on Thursday, gets his permit, he's got to drive for at least 30 days. Apparently he knows how to do that part. Sorry, that was, I'm sorry, I didn't need to say that, but he knows how to do that part, but then he's got to go back, take the test.
Right.
And then he can do that. He may be able to accomplish it in that time, that 45-day period. If not, I mean, counsel, I just want him to have a license.
We all want the same thing. One moment. So the 17th, it may not be me, it'll be another attorney from my office who can.
Well, I don't
I'm
want
in
that.
trial.
I don't want that.
You want me?
Yeah.
Okay.
I know you'll never hear me say that. But I don't want to go through this whole, you understand it.
Right. No, I get it. So I started trial on the 15th and
What's my date after the 17th?
August 7th.
What about August 7th? We can just put it out and then he can do what he's going to do or not do what he's going to do, but he should be able to.
August 7th at 1 o'clock, or would it be at 9 a.m.?
I will set it at 9. We will send an invite now that we have your appearance. So you'll get a direct invite from us as to what time block he's.
Okay. And then I just need one moment to talk to my client. You want to tell me something? Okay. August 7th at 9 a.m.
At 9 a.m. I'm going to take him into custody on the warrant. The only question that I have, and the way I look at the warrant, the bond looks like $500.
Okay.
Two things. First, I don't know whether or not they'll come get him.
Right.
If they don't come and get him, we'll release him. We're not going to hold him. If they are coming to get him and he's going to be held, the only question I would have for you, counsel, is do you want me to set a nominal bond on this so that he gets credit, or do nothing and not worry about it? I'll leave that up to you.
Okay, that will be, but absolutely, I want him to be able to get full credit for anything that is necessary.
So let's do it this way. If he's not, so I'm going to take him in. If for whatever reason he's not released tomorrow, call my office, and with the agreement, I will set a nominal bond on it rather than do it right now. So he has to deal with two things. So that you're also clear. Part of the reason I'm also doing this is because I think he was warned and released, didn't take care of it. And secondly, this has been out there for 9 years.
Well, I did not know about it, Your Honor. Okay.
Counsel, there is not a doubt in my mind that that's true. Yeah, I no, you did not. I go to the bank on that one in a minute because I know you would have taken care of it.
Yes.
All right.
It's going to be taken care of today. His wife is here and it will be taken care of. So I will absolutely call your office tomorrow to see call the court to see the status of it. Oh, we're going to take care of this.
All right.
Okay, that's what we're going to do.
We'll see you in August.
Okay.
Defendant is remanded on the Allen Park. Sir, you can go with my bail. So at this point, his bond will continue as set. Thank you. Counsel, as he's going, can you tell him just to be quiet?
Off the record.
Tell me. Yes, come on. Just tell him to just. Court calls the case, People versus Corey Harris.
Conrad Siller on behalf of Pittsfield Township.
All right, guys, we at the Secretary of State. Mr. Harris is going in to take his test. We'll see how we do. Congratulations! Oh, you did it! Yes.
And may it please this honorable court, Deion Webster Cox, on behalf of Corey Harris. And we have good news.
All right. Yeah, I know. Go ahead. I'll let you say it.
My client has his license, Your Honor.
Fine. He's had it for a while.
Yes, and see, what did we do? We moved forward, focused on the positive, and now here we are. We can proudly stand before this court and say, we did it. Okay? We did.
Yes, he did.
Yes, we all did. It was a collaborative effort. So
24 years late, but we did it.
we did it.
We got there.
We're here.
Congratulations, Mr. Harris.
Thank you.
So-
Better late than never.
That's right.
Wasn't I saying that at the beginning? I was.
Absolutely.
That's all I wanted. I told you that from the very beginning, Mr. Harris. All I wanted you to get your license.
Exactly.
And
Thank you.
I just wish it could have.
Thank you.
You're welcome.
You just helped me out speed up the process a little bit faster. Thank you.
You were hard headed though.
Yes, I am.
Yeah, you were hard headed.
My mother and my wife tells me this daily.
That you're hard headed?
Yes.
Yes. And you showed it to not only me, but the whole world. That you were hard headed. And all I wanted to do, if you had left that first day, you know, after the first hearing, I revoked your bond, you came here, you followed what I said, and I didn't have, you know, because I didn't really have a problem with you. If after you had left the jail, and if you had just gone to the did what you did, we'd have been done with this so long ago. Really. And ultimately, when it all said and done, that's all I wanted. That is all I wanted. I just needed you to have your license.
Mission accomplished. So.
And it feels good, doesn't it?
Mm-hmm.
Yeah, it feels good. You're not looking over your shoulder all the time, right?
Exactly.
It's amazing how that works. All right. And I did, not that I'm a social media person because I don't watch social media, but I saw him do his little dance out there in front of Secretary of State.
That was after his training, after he passed the test.
After he passed the test.
So we were documenting the process.
And
right?
as long as, and I knew, so like I said on the record, I kind of said it a little quip and a little snarky and probably shouldn't have said it that way. But I knew if he just passed a written test, the driving thing wasn't going to be a problem. Because he had been doing that for 24 years. So it didn't, he was going to be able to pass that part. All right. So with the newly vamped Mr. Harris.
Yeah, and we're all happy about that, so I will keep my promise, and if he would like to admit double parking today, he can do that, and if you accept it, Your Honor, I move to dismiss the more serious misdemeanor charge.
He will absolutely admit responsibility to double parking on that fateful and sober.
Mr. Harris. I can find it here. Mr. Harris, do you admit responsibility to the fact that on October 7th, 2023, location of Ellsworth Road near Laura Road, Pittsfield Township, Washtenaw County, State of Michigan, that you double parked?
Yes.
Satisfied.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Anything you want to say before I impose fines and costs?
Your Honor, my client has, I'm asking that the fines be as much as this court can, because he and his wife are both out of work and they've been working diligently trying to find work. But it's just things are financially, the margins are, and as a result, we're just asking that court, in addition to what the court has already done, that.
So after all this, you're asking me to do something nice?
I am. You know I'm going to ask. That's what I do.
Oh. Do I do nice things? I don't. No, I don't. Oh, thanks for volunteering that path. Mr. Harris?
Yes, sir.
Throughout this whole thing, outside of the driver's license, everything else, tell me what you learned that you think makes you a better person now.
What I've learned is it's just pretty much stay focused, stay on task, and not look back and just go on out here and just handle handle things right then and there. And then that way, I don't have to worry about anything crazy later. And thank you very, very much for teaching me that hard lesson.
Maybe one day we'll meet out on the street under better circumstances. Just keep your car in the lane. Don't be running into my truck. All right. So
I'm a very good driver.
I know we have 20 some odd years of you doing that. That's actually pretty good. All right. Fines and costs of $180. Mr. Harris, I don't know why I'm doing this. It is absolutely against my better thought, but I'm going to do it. I'm going to waive the entirety of the 180 and fines and costs.
Thank you.
You're all set.
Thank you, Your Honor.
May I shake your hand?
I know, I don't think you can touch them.
Why do you say that?
Okay.
Thank you. All right.
All right. You're welcome. Just do the right thing. All right. Take care.
Okay. Thank you.
Thank you. Take care. That's all your people around the courtroom waiting for you? Did they think you were gonna get locked up again?
My daughter.
That's your daughter.
That's her daughter. This is my wife.
That's your wife. So she came to make sure you didn't get locked up again. She kept you straight. All right.
Oh, yeah. Little.
Okay. Take care.